Good morning, all. This return date hearing is in the matter of DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al Tamimi Company. Lead counsel is Mr. David Holloway. The first defendant is represented by Quinn Emanuel, and lead counsel is Mr. Tom Montague Smith, KC. Thank you, Your Honour.
Thank you very much, Lena. So my question again, any housekeeping matters?
Nothing. I'm afraid two things from me, which one I've raised with my learned friend, one I haven't. The one I've raised with my learned friend is timings. Just so you've got it in mind, my plan is to run until lunch and then take about, I think then I'll probably hand over at that stage to Mr. McPherson, who may take something like 3/4 of an hour, but we've heard your indication, so we'll see. And then my learned friend will respond. He'll probably have about an hour, as I understand it. I'll have a further reply of up to 45 minutes, and that will take us to 5 o'clock in Dubai. And that's our aim for the purposes of today. The second point, which I didn't raise, my learned friend, but it's really just by way of update, is that those audited accounts from Mazars I mentioned we were hoping for sign-off. We're still hoping for sign-off, but I am told that it's coming from Mazars. So we will keep you posted as soon as that happens and let you know.
Yes, just for your benefit, I have read the second supplementary bundle now.
Very good, thank you. That's helpful. All right. With your permission, then, I was going to come on to deal with the sort of overarching fund as a fraud allegation that is made. What I wanted to do first was just very briefly remind your lordship of some of the principles which apply in this area. We addressed them in our skeleton argument. You don't need to turn that up right now. I was just going to show you a few short passages from the Three Rivers decision. I know your lordship will be familiar with it, but just to remind ourselves of the exercise we're undertaking. If I can ask your lordship to turn to the supplementary bundle, page 2809. Actually, that's the start of the case. So the passage that I would like to take you to is 3057, please.
Yes, it's a long case.
It is, but I'm not going to make you read it all. Again, I'm sure you've read it all before.
3057,
please. And these are some observations from Lord Hope, and where he's reciting some authorities and making some comments on those authorities in the context of how fraud is alleged and pleaded. And just to remind you of those, at paragraph 52, citing the Wallingford case, he cites the passage that says, with regard to fraud, if there be any principle which is perfectly well settled, it is that general allegations, however strong may be the words in which they are stated, are insufficient even to amount to an averment of fraud of which any court ought to take notice. And so we would say, absent particulars, that rather does for a fund as a fraud type assertion. My learned friend took you to paragraph 88 of the pleadings in Hong Kong yesterday and said, well, my learned friend says, we haven't alleged fraud, we have alleged fraud. Our point is not that. They've said the word fraud repeatedly. Our point is that actually when one looks at what they are now saying, it doesn't have an awful lot to do with what is actually pleaded. But onwards we go. In the same case, B, Lord Hope recites, in the same case, Lord Watson said, my lords, it is a well-known and very proper rule that a general allegation of fraud is not sufficient to infer liability on the part of those who are said to have committed it. I won't read all of this, but if your lordship goes down to 4 lines from the bottom, the rule of this particular quotation, the rule must require not only a general and vague allegation, but some actual fact or circumstance or circumstances which taken together imply, or at least very strongly suggest, that a fraud must have been committed, those facts being assumed to be true. And then paragraph 53, Lord Hope himself this time, second sentence starting at the end of the third line. It is also said that it is not enough to aver facts which are consistent either with dishonesty or with negligence. Dishonesty or bad faith must be proved, so the facts relied on must point distinctly to dishonesty. And that's another part of the theme that we come back to, which is that one has to look at the facts in the round. Once you've got them, what are the underlying facts that support the allegation of fraud, and ask the question, are they only consistent with dishonesty? If there could be an honest explanation, then they're not going to be sufficient. Next, a short passage from Lord Hobhouse's judgment, which you'll find at 3092. And at 3092, this is in paragraph 161 of his judgment against C, if your lordship has that. The law quite rightly requires that questions of dishonesty be approached more rigorously than other questions of fault. The burden of proof remains the civil burden, the balance of probabilities, but the assessment of the evidence has to take account of the seriousness of the allegations, and if that be the case, any unlikelihood that the person accused of dishonesty would have acted in that way. Dishonesty is not to be inferred from evidence which is equally consistent with mere negligence. And then the only other bit I'd like you to look at, if you would, is down by E, 4 lines up from the bottom of this paragraph. It is normally to be assumed that a party's pleaded case is the best case he can make or wishes to make. And then 3099 is the next one, which is Lord Millett's speech. Down at paragraph 184 here. Paragraph 184, it is well established that fraud or dishonesty, and the same must go for the present tort, must be distinctly alleged and as distinctly proved, that it must be sufficiently particularized, and that it is not sufficiently particularized if the facts pleaded are consistent with innocence. And then paragraph 185, second sentence, it says, he says, it's 185 says, it's important to appreciate there are 2 principles in play. The first is a matter of pleading. The function of pleadings is to give the party opposite sufficient notice of the case which is being made against him. So, and then moving on, paragraph 186, the second principle, which is quite distinct, is that an allegation of fraud or dishonesty must be sufficiently particularized, and the particulars of facts which are consistent with honesty are not sufficient. This is only partly a matter of pleading. It is also a matter of substance. As I have said, the defendant is entitled to know the case he has to meet, but since dishonesty is usually a matter of inference from primary facts, this involves knowing not only that he is alleged to have acted dishonestly, but also the primary facts which will be relied upon at trial to justify the inference. At trial, the court will not normally allow proof of primary facts which have not been pleaded, and will not do so in a case of fraud. It is not open to the court to infer dishonesty from facts which have not been pleaded, or from facts which have been pleaded, but which are consistent with honesty. So those are the principles that we're working from here. Now, where do we go from here? Well, the first obvious stage is to go to the pleading, which is at 7. Immediately run into a reference that doesn't work. I do apologize. Thought it was 783, but I think that might be. Unfortunately, there's quite a lot of bundle references, and my clear mitigation is that sometimes I used the wrong one. So 738 should be it. So this is the pleading. And you'll recall that I showed this to your lordship.
Sorry, my computer's frozen for some reason. Bear with me a second. It's slowly coming back to life. Sorry about this.
Not at all.
There we go.
738.
738. Yes, I have.
So this is the draft amended pleading.
Yes, we've seen it several times.
The actual pleading as it stands currently on the basis of which service out was obtained was the black text. So we're working on the assumption that they're entitled to amend it, but this is the best case. And 738.
I thought the red is as amended on the 11th of December.
It may have been amended, but I don't, as I understand it, they don't yet have permission to serve this out. It is amended. Sorry, it is amended.
Okay, yes, because
that's the point. Thank you. They have permission to amend because in relation to some, they don't need permission to serve out, but they haven't yet had permission to serve out the amended pleading on.
Yes, and that makes sense because your clients are disputing permission to serve out.
Correct, and that's the jurisdiction dispute. And there's an issue. There's an issue within that, in the application in Hong Kong, which is, can they backfill with amendments, or are they stuck with the case on the basis of which they got permission to serve out? I'm not going to. I wasn't planning to trouble you with that. There's a rule, certainly in England, and the same position is the one that we take in Hong Kong, which is that when the court is looking at the question of good arguable case and real prospect of success and good arguable case for the gateways, the court is looking at the unamended version, because that is the version on the basis of which permission to serve out was granted, and therefore that is the battleground for the purposes of the application to set aside service out. That's the position in England, in the English courts. We're taking that position in the Hong Kong courts. I'm not asking you to take a view on that. What I'm showing you at the moment is the amended version. I just give you that information for information purposes. So what I'm working from is the amended version on the basis that that's their best case.
Yes.
So you'll recall I showed your lordship this yesterday, and this is the allegation that the fund is a fraud. So the plaintiff has discovered that the fund is not in fact a genuine fund. And then what you get are a number of paragraphs which seek to particularize that. And what we have in paragraph 63, you'll see from the final sentence there, is that what follows are particulars of this particular allegation, which is that the bulk of the money purportedly being invested on behalf of the plaintiff in the fund was not paid to the fund and never made it to the fund, but also, just above that, that they were not invested in a way which was, that they were invested in a way which was contrary to that envisaged in the PPM. So those are the sort of two allegations there. And what you will also find in the course of this, if you go down, you'll see, so paragraph 1, for example, is about how the fund was invested, as is paragraph 2. So that's really about, it's been invested in a way that's contrary to the PPM. Buried in there at 2E, you will find a complaint about securitization. It's advanced as a sub-particular of a complaint about the way in which the money has been invested. But we can add it to the list of complaints, if I can put it like that. So you've got, so far, the list of complaints is, contrary to the PPM, the money was not paid to the fund, never made it to the fund. You've got securitization at E. You've got a complaint about insurance further down at 4.
Yeah.
Not supported by any insurance, albeit it said that it couldn't be insured as well at 8. So one wonders whether that's really a complaint about not invested in accordance with the PPM. But there we are.
Yes,
So
I mean, it is the difference. It is the difference between what one might call investing in trade finance proper and investing in associated companies. You can't insure against the credit risk of investing in associated companies, but you can insure it in relation to trade risk.
Right.
Trade finance risk.
Right. And I'll show you what the PPM actually says about insurance. I mean, it's not an allegation that's really, taken much of your time up to now, and there is evidence in relation to it, and it's one that
I've read the evidence. Yes.
The claimant alleged it and then backed off of it. But these are put forward as primary facts on the basis of which one can infer fraud. So essentially, it's those 3, and then just pausing there, you'll see that text about securitization. That's black original text. So that's text that was inserted in as long ago as December 2023. So just when we come back to the questions of securitization, one bears in mind that they've known about it for, a year and a half. It doesn't come as any surprise, but there we are. If I can go on, then
I'm going to need one of the questions that I was going to ask at the end, and it's not dealt with, but I think you will do. I'd like to be walked through how the securitization works.
I'll do my best.
Because I don't really understand that.
All right, I'll do my best to help you with that. So the rest of that paragraph, that paragraph 63 is much of a piece, and then you get to 64. No audited financial statements or periodic unaudited financial statements of the fund in existence and so forth. No annual returns and so on. And then at 3, no share certificate, no share register. So that's the other bit. I'll collect these up at the end, if I may. I mean, my learned friend hasn't really put his case in this way, if I can put it like that, but there we are. Paragraph 65 is the still further. There's allegations that Mr. Chop, Mr. Yai, and Mr. Britton have known each other from at least March 2020. Quite what that has to do with anything, quite how that supports an allegation of fraud is unknown, but there we are. 4 to 6, we pick up something about insurance again, effectively. And, 4 to 7. And then 66 makes the allegations that the remittances were blatant misappropriation and money laundering, and just says, well, they were substantial, they were unauthorized, they were illegitimate because they went to DMCC. There's a complaint about Mrs. Britton, and it said there's no due diligence, and then that says, in short, the fund was a fraud. So those seem to be the primary facts from which the court in Hong Kong will be asked to infer that the fund is a fraud. The fund, and what that means, we say, is ambiguous. In fact, when I raised that with your lordship, we'd understood really that the fund is a fraud means the fund is a sham. And I raised that with your lordship at one of the hearings that we had, and your response to me was, well, it depends what you mean by a fund is a fraud. And we say that rather exposes the problem, that we ought to know precisely what's being said, and we ought to know precisely why each of these primary facts is said to support that. But instead what we're doing is we're rather thrashing around in the dark, trying to piece my own friend's case together. So he says things like, well, something doesn't match in the NAV. Well, what precisely is he saying? What precisely is that fact said to support? So my sum total of where I come down to, what I perceive to be the facts which are relied on in the pleading, really comes to 6. We've got investment was not in accordance with the proposed investment strategy. We've got securitization, lack of accounts. We've got no share register or certificate.
Sorry, can you take it a bit more slowly?
Yeah, of course. This is my collection of the various points.
Yeah, I want to understand your submission. Yeah.
Yeah, of course. I'm so sorry. So number 1 was investment contrary to the proposed strategy. Number 2 was securitization. Number 3 was lack of.
Can I stop you
Yes.
there? Sorry, when you
Yes.
say this proposed strategy, do you mean the strategy proposed by Crossbridge, or do you mean the PPM, or both?
The PPM. I'm sorry, I'm paraphrasing. The PPM is
because there is a document which is headed investment strategy, which then feeds into the 8th March.
Yeah.
Resolution.
That's not pleaded. That's not pleaded as being a complaint. As I say, what I take from this pleading is that the complaint is that the fund must be a fraud because after the money went into the fund, the money was used in a way which was inconsistent with the investment strategy in the PPM.
Okay, so it's the PPM that we're looking at, right?
Yeah.
Okay, then I understand the first point. Second point.
Securitization.
Yeah.
It's not explained in the pleading why that is a problem. It's just said the fund has commenced a securitization process. It's within the context of all the other allegations that the fund invested in a way that was contrary to the PPM. So it appears to be said that securitization is contrary to the PPM.
Yeah.
But I'll deal with it more broadly. The third point is that there's a lack of accounts. That's what we take from the pleadings.
Yes. Okay. Well,
the fourth point is that there's no share certificates or register.
Yes.
The fifth point is that there's no insurance.
That's probably a PPM point too, isn't it?
It is really a PPM point too. And then the sixth point is that the payments went to DMCC, not to the fund, and never made it to the fund. All right. So those are the 6 pleaded points. And as far as we can make it out. And one can immediately see that is not really the way. So some of those points are raised by my learned friend, but that is not really the way the case has been put over the last 2 days. Because the allegations that are being made have ranged very, very widely to support some sort of roving allegation of fraud. And essentially what's happening is that there is a sort of moving audit that my learned friend is seeking to ask you to undertake. And that, we say, is simply not a legitimate exercise. That is precisely what the authorities say should not happen.
Yes. I think there's some confusion between liability and remedy, if I may say so, confusion between what are the primary facts upon which the allegation of fraud are based, and then the tracing, and then facts pertaining to the tracing remedy. And at the moment, I feel that there's a lot that's not relevant to my immediate consideration that's been placed before the court.
Well, we agree, and what we've tried, but we agree, but we can't prejudge what your lordship's going to think of the material.
No. I'm not. It's not a criticism. It's not a criticism of either party, because I can see the way the case is put, but I'm just trying to expose my thinking to both of you. Is that maybe I don't have to get into the granularity of some matters which may be relevant if there is ultimately a tracing remedy. But there you go.
I see. Um, I think I think that's consistent with the way that we would put it, because when we're looking at liability, for example, my learned friend makes granular forensic points about the NAVs and says, well, where do you see there the carbon resilience loans? And there are answers to all of those questions, but what we say is that you're not here to undertake that exercise of auditing the financial statements and documents that you have. What you're here to do, at this stage at least, is to consider what are the pleaded facts in Hong Kong, which are said to demonstrate that the fund is a fraud. Consider those facts.
And/or perpetrating a fraud. I mean, that does come from the
and/or perpetrating a fraud. So I mean, that's, well, yes, but that's not actually the way that it's put. But I hear what you say. That could be an ambiguous allegation. I think your lordship's point to me was, well, there's two ways the fund might be, quotes, a fraud. One is it's never was intended to be a trading fund at all, and the other is, well, it received this money and the money's been spirited away. That's not actually how it's put, but there we are.
Well, I mean, they do allege misappropriation and money laundering.
Yes, and the facts associated with that, as I say, are pretty limited. That's a paragraph 66.
Yes.
So there's substantial remittances which were unauthorized and they were illegitimate because of DMCC, because they went to DMCC, and then the odd point about Mrs. Britton being involved and so forth. But fundamentally, what they're saying is they were unauthorized, and went to DMCC, and they were large sums of money. That's really what it comes down to, and that so what I suppose that links in with is the exercise of porting, the explanation of why it was that the money went to DMCC, and why it was that ended up, how it was that money ended up being credited to the fund effectively. And of course, all of this is within the context of the proprietary case. Yeah. So this is all on the footing that Techteryx owns the money. And there's a difficult balance to be struck in this, because we say there's no arguable case that Techteryx owns the money. Now, you know, if we say if you agree with me on that, that's the end of it. You may though say, well, actually, all right, it's arguable, but there's still a question: whose money is that? And if at the end of the day that is FDT's money, then Techteryx is not entitled to any of this information. This is confidential information about the use of investments of a third-party FDT, in which Techteryx has some related interest. And the way that what's happened to date is that your lordship's order at the ex parte gave permission just to use the information in related proceedings, and that's been merrily used to launch all kinds of applications and bring applications against recipients.
Sorry, you're saying that if FDT were only a contractual fiduciary agent of Techteryx, Techteryx would not be entitled to make investments. Techteryx would not be entitled to details of those investments.
Not from the fund.
Even though its fiduciary agent is dealing with the fund.
Yes, because so there may be, you may be able to imply, or there may be express obligations on FDT to report to the claimant, but that's a relationship between the claimant and FDT. The relationship between in relation to the investment is between FDT and the fund. Now, it may be that FDT is quite happy for them to have that information, in which case, if instructed, we can give it to them.
So what information do you say that Techteryx is not entitled to?
Well, in principle, it's not entitled to any information about the inner workings of the fund or DMCC. And that's why when there was but it's been given a lot of that information because there was an inspectorship application, and then subsequent to a non-disclosure, an NDA being signed, a lot of the information was provided.
They're not entitled to information about the inner workings of the fund and DMCC. Okay.
Well, that's the logical consequence of the money being FDT's. I mean, this is a bit of a sideshow. But what I'm making the point about is that these are confidential. This is confidential information, confidential to FTT. It's up to FTT what it subsequently uses that for. But there are third parties at play here. But the primary point that I was making was that it's just not enough to show it's not, and indeed it's not appropriate to come to the court and say fraud and then sort of throw rocks at the information that is provided. It's very easy to say, well, there's no evidence of this. And in many cases, my own friend's wrong about that. There is evidence of the things that he says there's no evidence of. And then I have to go through and show you what that evidence is. It's rather like the third law of thermodynamics. It's much easier to throw rocks and destroy things than it is to actually present a comprehensive case on this.
Or indeed allege non-disclosure on next pass.
Well, all right. I mean, I'm hoping that that's not an indication of prejudging that. I mean, we've discussed that issue, and if you're interested in that, we can talk about it. We've narrowed that down.
Okay. Well, we'll come to that in due course.
We do say that there are serious issues there. All right. The actual audit of the fund, you've got the audited accounts for 2021, and I'll show you some of that. We've got the 2022 fund accounts, and those are complete, and we are waiting for Mazar's sign off. So my learned friend said this was cobbled together yesterday. He made that up on the hoof. That's an allegation of
no, and they're clearly not cobbled together. And I've skimmed them. I don't pretend to have the sort of expertise that somebody like Kroll would have in reading accounts, but I've looked at them and I've read some of the notes.
Right. Well, I'll show you a few of those. But that we say ought to give you a fair degree of confidence or comfort, because what you've got there is auditors who are required to apply professional skepticism and look out for fraud, have been through these books and accounts, not all of which are before you, and have come to conclusions about what is and is not appropriate, and have reached accounting conclusions in relation to that. Now, accountants, auditors can get things wrong, they can miss things, but in this context, it's rather difficult to suggest that they've simply missed things.
But it depends on what struck me is it depends on the information that they were provided with, and that information and how far that information satisfies accounting standards. That's where those are the limits of my understanding. I don't carry in my head the accounting standards. I don't know how far they would delve in. Look, for example, what I saw in the accounts was an acceptance of the valuations of the mining assets from the Salvi people, but there was some fairly persuasive criticism by Mr. Holloway of errors in the Salvi reports. Now, they may be right or wrong. I don't know.
But they're new. They're new. That's the point. They're new. They were brought to the court's attention day before yesterday. So I've got responses to them. But
Yeah.
those are new. Those are not points. Well, the primary point that he made, and I'll come on to this, was that these were redemption shares at the option of the issuer. And then he said, well, look at the par price. That's the issue price. And he just confused the two. Those are 2 points which were not previously made.
No.
And the point is, so the point in relation to those, just so you've got that point, was that the shares have provision in them that the issuer can purchase them back at the purchase price, not the par price, the purchase price. So, for example, the Pinewood one, there's a $225 million agreed issue price. There's then a DCF, which he didn't show you, which explained why the valuation that's been attributed is $225 million. And then it says the company can buy back those shares after 5 years for $225 million. So it's effectively a hedge. He presents it as $225,000, and that makes no sense whatsoever, because when you look at the DCF, the projected returns in that 5-year period is $35 million or so. So his case is new. It makes no sense. But the point here is Kroll have been all over this. They've been all over this for years. If you can go online and find out who Salva Mining are, you can see that they're reputable mining consultants. If you wanted to, you could do your own valuation of those reserves. There's nothing to stop them from doing that. But they present you with no alternative valuation. They don't criticize Salva at all. They don't say, well, they're not bona fide people. And look at the tendentious things they've said about other people associated with this. They pulled out all kinds of, in relation to Glassdoor, for example, they made all kinds of other allegations. The bottom line on all of this is that the value of the assets of the fund are not pleaded out as being one of the factors on the basis of which you can infer fraud.
Yeah.
We give you the response and the information and the explanation in order to give you some comfort that this isn't what my learned friend wants you to take away from this, that this is just smear.
Yeah.
And so we try to meet the smear and the so-called powerful observations that Mr. Holloway made yesterday, day before yesterday, are specious in large count, but the 1 or 2 points that he made were about the redemptions, and there are answers to that. But those were new. Those were new points raised by ambush, as is the strategy in this litigation.
Yes, I mean, I guess it's the point I was making a moment ago about the difference between asset tracing and primary liability. I guess what I'm really concerned with is the allegation about the porting, which you said a moment ago. So how the money gets from DMCC to the fund, and how how the money is deployed. I mean, that's really what it's about.
Well, yes. The way it is pleaded is that you can infer fraud from the fact that the money went to DMCC and not to the fund.
Yeah.
So that has been explained, and I will show you some documents in relation to this. And that Mr. Chock has said, for example, and my learned friend relies on this, that he thought he was always investing in the fund. And I'll show you, for example, a letter from Mr. Chock to DMCC saying treat all the legacy investments that we've made as FDT investments. So Mr. Chock, maybe he genuinely was confused, but maybe he really did think that he was always investing in the fund, but he was writing letters to DMCC dealing with the investments. So if one thinks about
yes, I'd like to see that. I mean, obviously, I read his witness statement in the second supplementary bundle last night.
Yeah. So I'll take you through that, but one can't approach this on the basis that, is this a fraud? Right. What's the explanation then for this piece of information? Where does that fit within my fraud picture? If you start from the proposition as we do, this was an investment made by Legacy and then FDT, firstly into DMCC, and then it was said, well, actually we want units in the fund, and that was always what was intended. And then that is brought about. Then our position actually is that, well, what fundamentally matters in relation to that is that they got what they wanted in the first place, and that none of that was hidden from them along the way. And so what we say about it is when you actually look at the documentation, you can see that there was a period when they had loan notes from DMCC and not shares in anything. And then, then there was, as they say themselves, they found that out. It wasn't hidden from them. They realized it at a certain point and then said, change that.
Well,
And
I'd like to be
Yeah.
taken to the evidence on that. I think that would be helpful.
Okay. Bear with me one moment, and because I do need to make sure I try and stick to some timings.
Yes, of course. But you put your finger on the area that I think I really need to focus on.
I'll focus on that a little bit then. Thank you. I just pausing though. I just wanted to make a few preliminary observations on the other matters that have been put forward. First, I think you have this. Your lordship will recall some of the more extravagant things that have been said by the claimant, like ghost assets, for example. That's not just that the assets aren't owned, not just that they're not having value, but that they just don't exist. So that was something that my learned friend said.
Yes.
On instructions without evidence. And I just ask your lordship to pause there and understand what that what that entails, and that it's really not supported by any credible evidence. What my learned friend took your lordship to was the Kroll report, which is at 4836. And what at 4836, paragraph 13.1.
Sorry, I've got the corruption issue again.
Can I read it to you, just because otherwise I really am going to run out of time?
Yeah. You read it to me. I will catch you up quite quickly.
So Kroll, at this stage, no name was on this report. Kroll said the majority in value of Aria Group's alleged assets, and then there's a rolled up allegation. They say do not exist or are not beneficially held by the Aria Group or lack adequate documentation to support their purported valuations.
I've actually got it now. What paragraph are you reading?
13.1, and it's the last 3 lines.
Okay. Yes, I have.
So there's a rolled up allegation, which is totally unacceptable on any view, because to have inadequate documentation is not an allegation of fraud. And so you've got this sort of, it's impossible. They don't identify which of the assets they say don't exist, which are not beneficially held by Aria Group, and which of them are not supported by valuations. And this is a point that FTI make in their response. And I'll just give you the reference. It's 8887. And paragraph 2.21. And makes the point a proper forensic accountant should recognize the distinction between those 3 things. I was going to say I don't intend to deal with anything that we've put in or everything that we've put in our appendix. You've seen we've tried to meet some of your lordship's concerns in the appendix. I'm try to focus on the key issues, if that's all right.
Yes. Well, one question I asked you. I mean, you're very helpfully in your reading list. This is something I'm going to come to at the end, but it doesn't matter. In your reading list, I think section 14, isn't it? You've scheduled out all of the documents in relation. Are you happy for me to work through those documents, or are there particular things you want to take me to?
I was going to deal with not all of them, but just take you through an example if I
Okay,
may.
right. Okay.
All right. In relation to the evidence, can I just make 3 quick observations?
Yes.
One is we say the Kroll report is either inadmissible or should be given no weight. We've made a series of points in relation to this in our skeleton argument, paragraphs 64 to 77. But the report, when it was issued, was not named. No individual put their name to it. Kroll is not independent. And I'll explain that in a minute. And the opinions that have been advanced in there, we say, demonstrate the author's bias. And so at best, this should be treated as submission.
Yes.
What has happened since that report was on the first day of the hearing?
I can tell you that I think you have some grounds for saying that it should be treated only as submission.
Yeah.
I mean, insofar, let me clarify that. It seems to me that insofar as Kroll assists me on the facts, then I can look at that, but that's a submission on the facts. I don't find that there's an expert opinion there that's helpful in any way. I mean, it's just factual analysis anyway. If there are side allegations saying this is all terrible and so on, I don't think that's helpful. What is helpful is just scheduling out, here are the documents you should look at, blah, blah, blah.
Yeah, sure. I mean, the difficulty is that when one gets into forensic accountancy, when one has accountancy evidence, it can take broadly 2 forms. One is sort of genuinely accounting opinion, which
yes,
is
and then you talk about standards. Exactly.
Yeah, exactly. On the other hand, you have what would normally be quite a useful exercise where the experts, and there shouldn't really be much scope for discussion, where experts can tally things up and ask themselves the questions. Does this match this, and so on? The difficulty is you've got Kroll just looking at NAVs and saying that doesn't make sense, and that ultimately does neither job, because it doesn't identify the standards which are being applied, it doesn't identify the source material, and it doesn't explain in detail, doesn't take you through what the problems are properly. Now, this though is really getting in much more into the sort of tracing exercise.
Well, that's exactly what I thought.
All right. Can I just make some very quick submissions on Mr.
Yes, of course.
Arbois?
I'm interrupting you a lot. I'm sorry about that.
No, that's absolutely helpful, in fact. But very quickly then, you'll recall Mr. Arbois from the transcript of the call in June 2023. So Mr. Arbois was the expert who was effectively cross-examining Mr. Britton on the telephone. And if you go back to that,
I've read that. I'm not sure you need to take me to it.
I won't. In relation to the actual report itself, I mean, you've indicated helpfully you're not that sure that his opinions are that useful, but just in case there's any concern about that, he identifies hallmarks of fraud, as you will recall, amongst them financial stress. Securitization, he says, is unusual and suspicious, if not illegal. I mean, but you know, that's just bold assertion. And then he calls it a Ponzi scheme, you know, and it's just, these are, but what I'm suggesting is that those sorts of conclusions disqualify him in any event, because they just show what's been going on. It's the worst kind of foregone conclusion. And you will also have seen, I hope, the extract. I'll give you the reference. It's at page 6639, paragraphs 37 to 38, where Mr. Britton explains an episode in which he had exchanges with Mr. Arbois, and a meeting was moved, and Mr. Arbois accused him of playing games. I haven't got time for these games. This is not an independent expert. He's hopelessly conflicted. He's been investigating for years. They were trying to appoint him as an inspector and as a receiver. And importantly, he has not disclosed his instructions. What are his instructions? He should, if they're going to say that he's an independent expert and then rely on that as an independent expert report, they have to disclose his instructions. They should do that forthwith. And those instructions will go back to 2023 or beyond. We don't know what he was asked to do at the outset. quite a lot of experts who are not accountants who are instructed to investigate. One sees this all the time. They're instructed to go and look for fraud.
Yes, I mean, and then, you know, classically.
I'm sorry, I've lost your feed.
I've lost it as well.
Can you hear me now?
Yes, thank you.
Yes, sorry, there's some peculiar thing happened to Teams there. Yes, what I was going to say is that you usually end up then with an investigating expert and a testifying expert.
And there's a reason for that.
Yes, there is a reason for that.
The investigating expert is hopelessly conflicted and they can't reveal their instructions. And I think the fact that Mr. Arbois doesn't see a problem here is in itself problematic. He discloses no conflicts. He merrily signs off and says, I've complied with my duties. I mean, it is pretty surprising. I'll leave it there, though.
Yeah, I mean, but as I said, I do see Kroll as investigating experts rather than testifying experts. If we have that dichotomy,
I agree. But what if those allegations have any weight, then Mr. Thompson from FTI is a testifying expert.
Yes,
he's
I see that
expert. And he has given the unequivocal conclusion that the inferences of fraud that have been drawn from these points by the Kroll report are unfounded. I'll give you the reference to that, but that's at 8888, paragraph 2.26, and 8935, paragraph 9.1.
8935.
Yes. 8935, correct.
Yeah.
So I will come on to the porting in a moment, but if I can just deal with it like this. What we sought to focus on, to give your lordship a little bit of comfort, and also to meet along the way some of these pleaded allegations, is to deal with 5 particular issues. Now, I'll pick up some other issues, but the 5 particular issues, I'm not sure the first one is an issue, but given that the allegation is the fund is a fraud, and one way to see that is that it might be a sham, there's the existence of the fund. Then there's the existence, second is the existence of FDT's shareholding. Then there's the value of the fund's assets. And then there's the redemption of shares, and allied to that, securitization. So those, I was going to try to run through that, and then I will deal with the porting issue. To add to that, though, we have the audited, what will very shortly be confirmed as audited accounts, but they're certainly, we would say, in their final form. You said you've read them, but not with a detailed eye, but they're in the second supplementary bundle. I mean, the starting point is that they provide a clean audit. Now, we do say that should provide some comfort, because auditors, and there's a little bit of evidence in relation to this from Mr. Thompson, but auditors would have to satisfy themselves that these transactions are properly accounted for. And they would have to, in doing so, apply professional skepticism. And so auditors' negligence claims are very often about situations where auditors have not done that. They haven't detected a fraud. They've been misled by their by their own clients, and shareholders or the client themselves sues them for that, and they're exposed. And that's because they are under heavy duties not to just take on trust everything that the client says. They owe duties more broadly than that to other people, the people behind the client, the shareholders, and potentially to investors, although there is some dispute about that. And so the Abrage claim, for example, is a situation which has given rise to quite a lot of litigation in relation to that. But none of that would be possible if it wasn't for the fact that auditors are there to investigate these matters. They have to, otherwise they're exposed. So the fund exists. I think everyone accepts that. The shares in the fund, we would say it's beyond doubt that FDT holds shares in the fund, and that they're commensurate in number and value with the payments that were made by FTT to the first respondent, the 6 remittances. And you can see that the share register is at 4750. And this is one area where my learned friend does make a case, because he says, well, the share register is not compliant with Cayman law. In his skeleton argument, actually, he said the share register provided by Mr. Britton were not compliant with Cayman law. So it wasn't clear whether he accepted that the most recent one is compliant. It's still, we say, not terribly clear what he is saying in relation to that, albeit he did seem to say on Tuesday that this was defective. Now, he relies on the Ogier memo, and it is important just to have a quick look at that. At 5273. And he showed you a passage from the Ogier memo. And I can't really read all this out, but I'll point you to what I say is the most important bits. But you were shown some of this. So 3.23, we're on page 5273.
Sorry, bear with me. It's
of course
one of the corrupted, so I've got to go to.
Oh.
So that's right. Just go to a different copy. I've got myself an uncorrupted copy. Right.
3.23, and so that identifies the relevant requirements. It requires, you'll see there, it has to contain the names and addresses of the fund's shareholders, a statement of the number and category of shares held by each shareholder, the amount paid or agreed to be considered as paid, whether each relevant category of shares held by the shareholder carries voting rights, and if so, whether voting rights are conditional, and the date on which the name of any person was entered on the register as a shareholder, and the date on which the person ceased to be a shareholder. So 324 says it's relevant to note that the share registers which have been provided do not provide an accurate and complete picture of the historical capital activity of the fund. What they don't say is that the share register is obliged or required to provide that. They don't say that. What they say about halfway down this is they say that the earlier extracts, we note that MBW2 page 3, MBW3 page 1 do not comply with section 40. So that the more recent one is MBW 675 to 676. So they say that the first ones don't comply with section 40. And they say, to the extent that there are additional classes of shares held in the fund, a Class C register would not appear to comply with section 40. So my learned friend told you the evidence was from Ogier, oh, well, the current share register that we've produced is not compliant. And Ogier says, well, to the extent that there are other classes of shares out there, it's not compliant. But we know that there are only Class C shares, and that's from the fund administrator, which is at 4722.
So 4722, only Class C shares.
Yeah. All right, that's another wrong reference. Sorry, it's that's the old reference. Sorry, it's 4749. I do apologize.
Okay.
My eye is inexorably drawn to the top right of the page for some reason.
4749. Sorry, which page are we looking at now? 4749.
Yeah. 4749.
Sorry. 4749. Yes. Okay.
Paragraph 2 produces this register and then says we can, do you see 3 lines up from the bottom? We confirm that at this time there are no other subscribers or classes of shares outstanding in the fund. We note that the investment value recorded in this register reflects the paid amount.
Okay.
So the document that we've produced contains all the information required by Section 40 of the Cayman Companies Act, which was the list that Ogier provided, which is names, addresses, amount paid agreed, number and category of shares, voting rights. They have no voting rights. That's at the top of the register, date of entry and date when seized. And the consequence of that is provided for in the Acts, which we don't need to go to, but it's in the supplementary bundle at 3407, which is that the register of members is prima facie evidence of the matters stated in it. So we do say it's beyond doubt, rather like Ms. Lee said in Cayman, it's beyond doubt that FDT has shares in the fund. But what fundamentally matters here is that the fund recognizes FDT as a shareholder. That's really what it's always about. If there were no shares, then that would be one thing. But once you've got the fund administrator saying, here's a statement of the shares, this is what FDT owns, then we would suggest there's no triable issue as to whether FDT owns shares in the fund. Then there's the value of the fund assets, and this is not pleaded. So we've got the NAV statements that have now been provided for the fund for quarterly statements from April 2021 to January 2025. And the most recent is at 8620. And that sets out, sorry, is that right? Sorry, 8622. I'm so sorry. So this is January 2025. And it sets out a NAV total units at 8623 of 500 million. My old friend made a point yesterday, well, why is it that investors have got fixed valuations of units? Answer being, these are specifically shares which are entitled to redemption at the price plus coupons. So they don't participate in the profits of the fund in the way that an ordinary shareholder would. But there we are. Now, the point here is that Mr. Thompson of FTI has looked at these NAV statements and has concluded that they are consistent with the asset list that was provided as being held by the fund. The reference to that is 8918, and it's paragraph 7.10. And he specifically then looks at the three assets that we've identified. And the reason we asked him to look at that was because they are about 85% of the value of the NAV. And you see that on page 8622.
Sorry, Mr. Thompson says that he's looked at the asset list and is consistent with the...
He's with the NAV. So the NAV is consistent
NAV.
with the asset list.
Yes, get that.
And then he goes on to consider the documents and see whether they support the valuations that have been provided in the NAV.
Yes.
And my learned friend's skeleton argument, paragraph 31, I'm going to quote him. He says, Kroll's conclusions as to the asset picture are not seriously challenged by FTI. That's his submission. That is...
Sorry, what paragraph is that?
31 of my learned friend's skeleton argument.
Yeah.
And that is, I'm afraid, just not true. Kroll and FTI are night and day on this. So you've got Kroll suggesting that there's no support for them. I won't take you to it, but it's 4782, and that's Kroll at paragraph 2.1.8. But if we go to what Mr. Thompson actually says, that's 8887. You can see that at 2.22 to 2.25. So he says 2.22, they're consistent with the asset list. 2.23, I've been instructed to inspect the 3 largest. 2.24, as to the existence and rights. He accepts that they have them, save in the case of carbon resilience, where they've got rights, but they're subject to foreign investment approval. And 2.25, the valuation reports, he looks at them and says that's consistent with what they're stated as, and 2.26 rejects the inferences of fraud.
Yes.
So the idea that Kroll's conclusions are not seriously challenged is I'm afraid just false, and that's the worst kind of paraphrasing. Just looking at those 3 projects then, because your lordship said you thought there were some decent points there. Pinewood is covered in Mr. Thompson's statement at page 8919. I'm not going to take you through too much of this. I'm going to take you to the actual documents.
Yeah.
So 8919, but I would ask you to read it if you haven't had a chance yet. It's paragraph 712 to 716, and in particular at 716, where it says, in my view, the documents referred to above show that the underlying coal mining concessions exist, and Aria CFF has rights to them. This is in relation to the Pinewood project. And the underlying documentation is that there's a number of them, but there's 8810 is a Clyde & Co letter confirming the ownership of licenses.
8810.
Correct. 8810 confirms the ownership of licenses by the Tanzanian company called Pinewood. 8785 then is an extract from the Register of Companies demonstrating that Kibo Energy Mozambique owns Pinewood. And then you get to the board resolution that my own friend took you to at 5666. And that is a written resolution of Kibo Energy Moz, or Mozambique, granting 225 million Class B shares to the fund. So there's clear documentary evidence showing the fund's ownership or entitlement, proprietary entitlement, and because it gives 75% revenue-linked participating share and gives participation in 75% of the post-tax income from day one. That's the provision. And the main complaint in relation to that is that the valuation reports doesn't take on board certain issues. In particular, first, if you're looking at page 5666, my learned friend pointed out the price per share of 0.001 as if that was the issue share.
Sorry, can we?
But
I'm having some difficulty getting my head around this, so you're going to take this slowly.
Yeah, I'll just. All right. Well, let me start with the valuation.
Take me to at the moment. I'm not. We're just making a list of documents, but I'm interested in this point.
I'm showing. Thank you. I'm showing you the written resolution.
Okay,
and
so that's
I'll come back to it. So this is I showed you the written resolution to show you the chain of ownership.
yes. I've not got there. 5666. Okay.
Correct.
Yes.
So why don't I come back to this document, because the particular points that were made on it were the first bullet point under Class B shares, the price 001,
Yes.
0.001 per share. And the second, it says, well, it's redeemable at the election of the issuer after 5 years. And then said, well, so the valuation is worthless. And well, I'll come back to why that's problematic. Why, firstly, that those points have never been made before, so I'm telling you the answers to them. But it does all make sense, and my own friends doesn't make sense. But I've got to show you first the valuation report, which is at 8763.
Okay.
So this is the Salva Mining Consultants report, 8763.
Yes, yeah, I have it. Yes, I have it. 8763. Yes.
And
okay.
It's dated 2nd of September 2024. You can see the 2nd of September on the second page.
Yeah.
And if you go down to 8766, you can see who did it. So it's signed off by Manish Garg. If you want to get hold of him, you can send him an email. You know, that nobody is suggesting it doesn't exist, that it isn't a reputable mining consultancy. And what he has then valued is the interest, or the proposed interest. He does say it's a preference share, describes it as a preference share, but this is obviously coming before the transaction, and so he's anticipating what's going to happen. What matters are the rights that are being valued, and the point is that there's a 75% interest in the post-tax profits.
So where are we looking now?
Sorry, that comes on page 8768. And you see
Okay.
under participation.
But he says the issue price is €1, and that's not correct.
No, it is correct. The issue price is €1. The par price is not €1. An issue price is not a par price. An issue price is the price that parties agree will be the consideration paid for the shares. So the issue price is €1. That's the illusion that my learned friends made.
Okay.
He's looked at the par price and said, well, it's 0.001, so this is all purchased for $225,000. But you can see that his response is, so you'll see there the salient features are the maturity redeemable after 5 years. But the point is participation revenue linked 75% of net income from coal sales from underlying reserves. And then if you go down to the actual valuation, he said this was the valuation. He didn't show you the valuation. This isn't the valuation. This is just a recording the transaction. If you go down, what you will see starting at 8770 is an explanation of the valuation, which is a discounted cash flow model. And if you go down to 8773, you'll see the outcome of the present value DCF is 225 million, giving a range.
Yes.
And if you go to 8774, you'll see the DCF.
Let me just
I'll take you back to the board resolution in a moment, but just to show you the DCF, if I may.
Can I just go through 8772 to 3?
Yes.
So this is a valuation based upon a 24-year forecast period.
Yeah, that's the life of the mine.
Yes.
I'll explain the redemption point in a moment, but essentially what my learned friend says is, well, you can't take this on board because it could be redeemed within 5 years at the issue price. That's the term that's used in the board resolution.
Well, it's redeemed at the board, as redeemed at the par price, it says on.
No, it doesn't. It doesn't. It says the issue price. That's
if you go back to 8769. The valuation talks about redemption at the par price.
Yes, but that is not. So it's right that there's a difference between the way that the terms are described here. The question is whether that difference is material. The board resolution,
but it's either it's the par price or it's either €1 or a hundredth of a euro.
Yes, but the par price is €1. That's what you see.
No. You said the issue price is €1. The par price is 0.00.
Correct. The issue price is €1. We can see that in the valuation. We don't have independent evidence in relation to this because the point was raised on Tuesday.
Yes, I see that. But I'm taking this at face value. At face value, the issue price is €1 and the par price is 0.001.
Correct. And then if one goes back to the actual board resolution,
yes, which is
5666, 5666, 5 and 3 6s.
Yeah. Okay.
You see the par price. It's not described at that, but it just says participating shares of 0.001 per share. But it says redeemable at the original issue price.
So it's a mistake in that's a mistake in the valuation.
It's not necessarily a mistake. The point is that the board resolution comes in on the 20th of September 2024, and the valuation is in anticipation of the rights that will be issued. The question is whether or not, in material respects, that the deal that is done matches the valuation. And the answer is it does in material respects, because the effect of this is that the company can buy back at the issue price. So the company can buy back at $225 million. Not at $225,000. But can I just make good why my learned friend's case makes no sense at all?
Yes, sure. Because so the only place that I can see the issue price is actually in the valuation.
Yes.
I mean, there's no document from the fund showing that it actually paid 225.
Well, it doesn't have to actually turn over $225 million at that moment, because obviously there's been prior investment initially through Dmcc. So it's an agreed valuation. It's an agreed valuation.
But it's valued at that in the accounts. Is that right?
Yes, it's valued at that. Correct. So the interest.
So if you go to the most recent accounts, we'll see.
I can't tell you off the top of my head whether that you will actually see that.
I saw the notes on the salary valuation.
That was on I think on the other project. But there we are. But there we are. But let me just so effectively it works a bit like a bond. In other words, the redemption for the issuer is essentially a hedge. Because what can happen is that the issuer can say, right, I've got your 225 million, here's your money for the first 5 years, and now I'm going to buy you back out at exactly the price. But there's still 225 million. So on that scenario, for their 225 million, if all goes as expected, in accordance with the DCF, they'll get, if they stay in for 24 years, the full 225 million, because that's the valuation of the project. But if for whatever reason they find out that the reserves are 10 times that, or whatever, then the company is entitled to say, actually, we'll buy you back out at 225 million after 5 years. One way or another, The fund gets their 225 million. In those circumstances, they get that plus the DC, plus the participation they've had in the first 5 years.
Which is 75% of post-tax profit.
Yes, which you can see what that's projected to be precisely. It's precisely projected to be $32 million in the first 5 years. And we see that from the DCF at 8774.
877. Okay.
So if you zoom, so this is the DCF. If you zoom in on the bottom left row, you'll see there Aria's 75% share of discounted cash flow. This is heavily discounted at 15% discount rate. And you'll see in the first year there's minus 3 million, then 0, then 7, 14, and 14. So the projection is 32 million net over the first 5 years. So the idea, so my learned friend's case is that actually what we've got here is an interest that's been bought at $225,000. If so, that is the deal of the century. Because we've bought $225,000 interest, which gives us $32 million return in 5 years, plus the right to either stay in for another $200 million or get bought out at another at the purchase price of $225,000. My learned friend's case doesn't make sense, and he present it's just an ambush. It's just an ambush which has superficial attraction but isn't right. And this is precisely an example of why you cannot have fraud allegations being lobbed around in this way.
Not in relation to something so complex.
Well, we would say not at all.
Yes.
But the point is that the claimant has made points on this. My learned friend said, well, these are obvious errors that haven't been identified previously. Either they're not so obvious because they didn't spot them earlier, or they are obvious and they did spot them earlier, but they saved them up for ambush. There's only really two possible answers.
But presumably the answer for all this is we see it feeding into the NAV, don't we?
Well, it's in the NAV. It's in the NAV. It's not in the audited accounts.
Okay.
Because it didn't get there yet. But my learned friend's point, so what I'm trying to do is give you support for the proposition that the NAV is accurate in relation to this particular asset. It's really the same point in relation to Mbuyu. And the reason why there's a reference to Salva in the audited accounts is because I think Mbuyu is in those audited accounts, and so they've gone away and they've done their own valuation to check.
So I'm just on page 8622.
Yes.
So investment in preference shares and Bayer 225. So that's okay.
So that's the Mbeya coal, which we've got the Pinewood because of the way that it's.
So that's Pinewood, yes, okay.
So the next one was Mbuyu.
Yes.
Which is
the 65. Story, yes.
Which is the 65. But that's a similar story and has been, I think, referred to in the newly audited accounts. And I don't want to go through all of this in too much detail. Because we've set out the documents.
We can follow the money, DMCC porting into these investments. That's what we can do.
Yes, what I can't do is give you ledger accounts and things like that. But what we can see is this is where it's ended up. So we can't audit the trail in a tracing way, but we can say, look, this fund has these assets and they are verified as having these valuations. FDT has an interest in the fund. So that's what you need to know. That's really ultimately what you would need to know if you wanted comfort that they were properly invested. And rather than take you through all of the Mbuyu mine bit, can I just show you the DCF for the Mbuyu mine, because the same point is made.
Yes.
My learned friend says we rely primarily on a similar resolution. That's just not true. FTI has relied on a series of documents showing a chain of custody, and we've identified those. I can take you through them if you like, but ultimately where it gets to is 8789.
7, 8.
Which is again, this is the Salva mining consultant report from Mbuyula.
Okay.
And then similar dates, same person, valued at 65 million. You see that at 8796. And if you go to the DCF, which is 8797. So my learned friend's point again was, well, these are redeemable at the issue, at the issuer's option. But look at the fund's participation in this, according to this valuation. Between the first 5 years of this is most of it. It's 53.8 million.
Okay, faster than my mental rhythm.
I did it last night. I don't pretend to have. I don't pretend to have done that on the hoof. So what my learned friend's case seems to be is that because of the resolution, my client, the fund, purchased an interest in this mine for $65,000, which an expert has valued as giving a return in the first 5 years of 53.8 million. That's what he says the documents show you. And the reason he's got that wrong is because he's mixed up par with issue. The short point on these is that there's nothing stopping my learned friend doing his own valuation, getting his own valuation, approaching Salva Mining, getting some evidence about how this was obtained. But there's no reason to doubt any of these reports. He makes some forensic observations about the fact that it's dated, but he doesn't explain why that matters. He says, oh, well, it's referring to a preference share, not ordinary shares, but doesn't explain why that matters. The only one he did explain really was the difference between it being redeemable at the holder's option, and redeemable at the issuer's option. But then he misunderstood the price that the holder would have to pay. The other main asset on the NAV, so if we go back to the NAV, she kindly reminded me, was 8622.
8622.
So you've got then, so that's the Mbeya coal, the Mbuyu coal, and then the other main asset was the 125 million for the carbon resilience ordinary shares. That is dealt with by FTI, and that is at, the conclusion is at 8924, paragraph 7.36.
Sorry,
8924.
Paragraph
7.36.
Okay. FT. Yep.
And he says, well, in my view, the documents referred to show that the shares will be held on behalf of Aria CFF pending foreign investment approval. And the ownership documents include a deed of transfer and a nominee agreement. Those are at 4701 and 5661. there are sample share transfer forms that haven't yet been executed because it's subject to foreign investment approval. At 8851, you can see the proposal for foreign investment approval.
So eight. So first of all, sorry, again, it's a bit fast for me.
I know, I'm sorry.
You gave me a document 4701.
Is a deed of transfer.
Yeah.
That's 23 May 2024. Then 5661. There's a nominee agreement, 23 May 2024.
Yeah. And then the share transfer draft.
The share transfer, they're draft, so they're 8847 or specimen, they're called, I think.
8847.
And then 8851 is the email seeking foreign investment approval, dated 4 February 2025.
Sorry, give me the number again.
8851.
8851. Email. Investment. Okay.
And there's a complaint that because there's foreign investment approval, this shouldn't appear on the NAV. But 2 points there. One, there is an agreement for the transfer subject to that approval. So the effect of that in ordinary law would be, because it's for shares in a private company, would be that the beneficial interest will pass anyway. But B, in terms of valuation, it really depends on whether there is really any risk of refusal. And given that these were previously foreign owned, there's no suggestion that there would be.
Mm-hmm.
At 8824, I will ask you to look at that very briefly.
8824.
Yeah, this is the Ernst & Young valuation report in relation to these assets.
Yes.
And you'll see they were engaged on the 6th of February. You can see that on the second page. So before these proceedings, this hasn't been assembled in response to these proceedings.
Well, this is for a different. This is for someone other than your client, isn't it?
This is for the
BIOS, and funded by. Oh, I see. Oh,
these are assets managed by Vivios, funded by Aria Commodity Finance Fund.
Okay.
And,
yes,
and
I
this
think the submission was made that it was made for somebody else, but I didn't see and funded by Aria Commodity.
Yeah, no, but if you go down.
Yeah, no. It's just that I got the wrong impression of this.
Yeah, well, that's not that surprising. 8825, you'll see, we're pleased to present the following report, which outlines our indicative assessment of the fair value of Carbon Resilient Pte Limited's investments. That's the company that we're all talking about.
Yeah.
So this is a valuation of the assets of the company that's being purchased, or that's being acquired. Wouldn't call it a straightforward sale and purchase. And 8829.
Sorry, I better take these down. 8829. Yeah.
Gives an indicative value of the enterprise value of the various different projects and comes out at somewhere between 150 million and 273 million. With the mid-range being 212,500,000.
Yeah.
So this is Ernst & Young. I mean, again, it's not suggested that this is fabricated in any way or that Ernst & Young can't be trusted to undertake this sort of valuation. What my learned friend says is, well, there's no he said this to you in submission, there's no evidence of ownership of individual assets. So I think what he's asking for are contracts, documentation to demonstrate that Carbon Resilience owns each and every one of these projects. It's totally unrealistic.
So what is the fund's interest in the project?
That comes out of the deed of transfer. They're going to get the shares in Carbon Resilience.
Okay, can
So
we
the
just
deed
look at it? Can I have a look at the deed of transfer?
Sure, it's at 4701. And it's prepared by Herbert Smith.
Okay.
And we're not. This is not. It's not cobbled together documents. It's based 23rd of May 2024. And then the outgoing shareholder and the incoming shareholder, and it's FAAR Real Estate Asset Income. Do you see that on page 4703? Is the incoming shareholder?
Outgoing, incoming. Okay.
And Mr. Britton is the principal.
Of Aria, that Aria principle. What's where does Aria figure in this?
There's a nominee. There's a nominee arrangement. So that FAAR Real Asset Income Limited is an Aria nominee.
Where does it say that?
Well,
Below. So lenders and the borrower are entitled to the following agreement. I'll have to read this.
so the nominee agreement is at 5661.
So I just, yeah, I don't want to dot around document. Let me just try and understand this document.
Yeah.
So recitals. The lenders and the borrower entered into following agreement. 8 million and 10 million loans. The loan provided by ACCF was due for repayment. Loan provided by Aria Dmcc.
Can I show you the relevant clause? It's at 4708.
4708. Okay.
And as I say, this has all been looked at by Mr. Thompson. And he said, yes, we can see the chain of custody here. So these are not a document that we're spending quite a lot of time on it. And it's not a document that is under attack, if I can put it like that. But 4708D, you'll see under the heading share transfer, which is clause 2, which is this clause.
4708. Sorry, I can't see heading.
It's on the previous page.
Okay.
So
yes,
D, at completion, the outgoing shareholder shall sell and the incoming shareholder shall buy the transferring shares free and clear of all encumbrances, together with all rights that attach to the transferring shares at the date of this deed and that accrue between the date of this deed and completion. So
the Liechtenstein, whatever it is, foundation or a limited company will buy the shares. Okay. And you say the Liechtenstein entity is a nominee for the fund?
I think that's right, yes.
Okay, well, let's have a look at that.
5661.
All right. All right, nominee agreement. Not the same company, is it?
Is that a different?
FASPC. Right. Sorry, let's just go back. Sorry, I have to go back to where's the first page of that share agreement? 701. So the incoming shareholder is FAAR. So they're different entities.
If you look at the registration number,
Okay, yes, that may be helpful.
it's the same, I think. So if you're looking at the agreement, I'll read out the registration number on the nominee agreement. It's FL dash.
So okay, sorry, I've got the nominee agreement. You want me to go back to the? You want me to go back to 4701, 4701.
Well, your lordship's asking questions which aren't raised, but I'm doing my best. But
yeah, of course you are. Okay, so I've got an agreement for the incoming. I've got a number for the incoming shareholder FAAR. Okay, so you're going to give me the number from the nominee.
Yes, hold on, sorry. I just need to work out where I'm going.
So
I'm reading it here off the nominee.
Yes.
It is FL dash 0002 point 527527.636 dash 5.
Same number. There you go.
Right. So I mean, this is all in the FTI report. They've done this exercise.
Yes.
So the point is, what you've got is you've got a deed of transfer for the shares in Carbon Resilience. You've got a nominee agreement which explains how Aria is going to have the interest in the company that's acquiring it. You've got the valuation report which says these are the assets of the entity. And you've got the request for the foreign investment approval, and that's really the only sticking point. But that the effect of that on the value of the asset that's held depends on the prospect that there's going to be a problem in relation to it. The valuation report provides evidence of 12 different projects that are at different stages of development. You can see a description of them at 8830 and 8832.
Okay. So these are the projects for. Yeah. That is part of the NY report.
Yeah, quite.
Yeah.
So you've got the project update, and then at 8831 you've got the various categories that they categorize them into, and then the 8832 they explain each in relation to each of the projects what stage they're at. Okay. And that then is fed into the valuation, which is explained in some detail on the following pages.
Yeah. Okay.
These are substantial assets. And it's fair to say we don't have the full picture in relation to this, and this is one of the points that FTI accept. They say, well, we don't know precisely what the liabilities of the company are. We've got the asset position, but not the liabilities of the position. But we can't give you the full picture on that. What we can show you is the acquisition of a company which has very substantial assets that are consistent with the NAV valuation. The complaints about the NAV kind of focused on other more forensic complaints.
Yeah, I'm just looking at the time actually at the moment.
Yeah. Well, I'm concerned about that too. I'm behind, I'm afraid. But we'll just have to get through it.
Yes.
Would you like me to stop now for a break?
I would, yeah. It would give my brain a rest for 10 minutes. Yes. Okay. Let's come back at 5 to the hour, shall we? Thank you.
Right. My learned friend complains about the lack of valuation of various other companies and assets, and one of them is PT Barra Energy Macmore Coal, for example. The reason FTI does not report on that is because they're not fund assets, and so they weren't part of the FTI review. And FTI explains all of this and says, in effect, in the time available, we have to narrow the focus. And I've tried to explain why we've done that. My friend, I think, suggests that you should infer that FTR shares Kroll's concerns about the other assets, and of course, that's just trying to magic up a case out of an inference. It's not accurate and doesn't survive what FTI themselves say about their reasons for doing what they did, which you will find at paragraph 7.11 on page 8918. There was some suggestion in the course of that in relation to PT Barra, the ownership chain couldn't be identified, but I think your lordship had the point that in PT Barra was purchased pursuant to an option. There was an option agreement in relation to that, and so it was never said that they had legal title. I think that's the point you made, my learned friend's submissions. My learned friend also says that you cannot see a company called Mbeya Power, interest called that. That is also a DMCC asset. It's in the list at page 4023 at row 439. There were various other forensic points made about things that were missing from the NAVs. And the point is that at various different times, some of these things were recognised as loans to DMCC, some of them were recognised as assets of the fund, some of them were brought into the fund at different times. So the ultimate position is really what you should be concerned with. So we say that there is the up-to-date NAV is supported by credible information. There's no real reason to doubt it, and FDT has shares in it. There have also obviously been some redemptions along the way. That should give your lordship some comfort too. It's not the whole of the answer, I accept that, but it is consistent with a genuine fund and inconsistent with some sort of sham operation. Fraudsters don't usually give the money back. And that's why Kroll is driven to Ponzi scheme, because obviously, but again, it depends on which lens you look at it through. If you look at it and say, this is a fraud, why are they giving the money back? Then you have to go to the Ponzi scheme answer. But if you start from the position, there's money coming in, there's assets on the table, there's money coming back out to investors, then you wouldn't, then the fact that the money is coming out would support you in your conclusion that this is a genuine operation. Securitization. This is one of the issues that is pleaded, albeit no explanation is provided. And my friend Skeleton, in his section B 2.10, but we don't need to look at it. Effectively, what he says is that this goes to real risk of dissipation, because he says, well, there's been persistent attempts to complete the securitization before the return date hearing. We find that quite baffling. The intention to securitize has been known to them all along. It was referred to as long ago in meeting notes as June 2023, and as I showed you, it was pleaded in December 2023, so it comes as no surprise to them.
Do you have to reference those meeting notes?
5017 is the June 22, I think it's June 2023 meeting notes, and the pleading is at 740, and that's paragraph 63(2)(b).
Yeah, that we saw this morning. 017. Oh, this is that conversation.
Yeah. So you'll see in the middle.
Yes, I can see.
So the idea of all of this, I mean, just dealing with the idea that this is some sort of attempt to spirit away. I beg your pardon, I've got a noise in the background. Sorry. Dealing with the idea that this is some attempt to spirit away the assets, we say that's just not properly arguable, because the effect of securitization is you take an asset and you effectively that there's a process by which it is consolidated into a company which then issues tradable notes, and so it's asset backed in that there is, for example, a coal mine at the end of it with revenue streams and so forth, but the note itself is based on that and is ultimately capable of being traded. And what that does is it increases the liquidity of the investment, because you start with a mine, for example, and you end up with a tradable note. And the process for that obviously requires securitization agents and so forth to undertake valuations and due diligence in understanding the ownership and the values. And they produce those notes, and then those notes become marketable. So I think it's the income stream is what is ultimately.
So just what I just want to understand. So let us assume that the fund owns a mine.
Yes.
Okay, so what happens next?
Right. I think I better take you to the evidence on this, because otherwise I'm going to get it wrong. So, well, I mean, the point is, the court is not, and I am not, and we are not experts in securitization.
No.
What we have is an explanation of what was proposed.
Yes.
What we have is FTI's consideration of that and understanding of that, which they summarize. And then they say this is not unusual in our understanding. And there's an assertion, that securitization is unusual and possibly illegal, but no support for that. So my learned friend's case is securitization is indicative of fraud.
But I need to understand the process just to understand what the two sides are saying.
All right. Well, can we just look at then? Let's start with the FTI explanation, which is at 8931.
Yep.
8931, paragraph 821. So the asset owner identifies a pool of assets with similar characteristics that would be replaced with cash, creates a separate special purpose vehicle, and transfers the pool of assets to the SPV. SPV issues securities backed by these assets.
I mean, that's what I don't understand, is how that transfer takes place. Is it a sale?
No, I don't.
Gift? Is it a trust?
I don't think it much matters, because if it's already held in an SPV, then presumably that can be it's just a vehicle. So it's like a nominee, I suppose. Well, I know it wouldn't be a nominee. I don't precisely know how that bit of it is intended to work.
But you see, well, that's why I'm.
But does it matter?
It does if somebody's alleging this is a mechanism of fraud, and it's a layering process. That's what I'm trying to understand. I mean,
right.
So I just want to understand that it's perfectly normal on your case, and this is the way it's done, and that all of this dark muttering on the other side is without any foundation whatsoever. So, yes, okay. Fund owns an asset, so it transfers it to an SPV. Does the SPV pay for it? Is there a debtor-creditor relationship? Is there a trust relationship? Is there a nominee relationship? This is
right.
What
so your
confusing.
concern, right? Well, that's the first time that concern has been specifically raised. So I'll need to take that away. No one has previously said that particular moment of isolation of the asset or the asset-bearing company is the issue. But put it this way, no one is saying, well, securitization exists as a means to liquidate assets. Now, I don't think anyone has previously said securitization is a nefarious thing to do, because it involves the transfer of assets.
And it is said it's nefarious in the context of this case. That's what
Well,
being said.
Right, but then that doesn't answer that. Then the question, which is, well, precisely how is it going to be undertaken, is irrelevant, because what we're saying is that we're going to undertake a securitization process in general, and we've discussed the terms on which we're trying to do that.
Okay,
So
then for me it's a black box. Then you're just saying, okay, securitization is a black box, is going into that black box, and that's okay.
Well, no, I don't think that can be right. So what we're saying is there's a number of different ways to securitize. So no securitization has taken place yet.
No.
So if there was some sort of unlawful divestment of assets, then that's going to be a bad way of doing securitization. We're not suggesting that we're going to undertake a bad way of doing securitization.
No. I'm not being pejorative in any sense. I'm just trying to grapple with what's being said on both sides. That's all.
But I think the answer to the question. Well, I know, but the complaint is at a very high level of generality, and it said, well, the problem with securitization, as I understand it, the problem with securitization is that it makes these assets into something which is highly liquid and therefore capable of being dissipated. So that's what I'm trying to grapple with. So precisely what I can get instruction on precisely what are the terms that are being contemplated, but that will be something that will be discussed with the agent. So
yes,
for example,
what I understand the allegation to be, and Mr. Holloway will make, is that this is the interposition of yet another layer of ownership, which is indicative. This is what I understand them to be saying, maybe rightly or wrongly, that this is a way of dissipate. This is a way of dissipating the asset by making it unreachable in putting it into yet another form.
No, that's not the way.
It's risk of dissipation.
It's not the way it's put.
Okay, then I'm misunderstanding.
Well, no. Well, I mean, it's not. Well, it's not explained at all. So you've heard my learned friend's submissions. He's coming back on reply.
Yeah.
He's not coming back on his substantial submissions, and the submission is simply securitization was problematic because it was done in the face of your order, or it was proposed to be done in the face of your order.
Have a look at the skeleton. Skeleton. Spelled two different ways. It talks in the skeleton about a confusion over who owns the asset.
No, well, I know, but that's what I've just been showing you. So in relation to the critical assets,
and then 58 serious concerns about the lack of any detail in the securitization process, the ambiguity of the limited evidence, and the timing and haste. So Mr. regard this evidence of a risk of dissipation.
Yes.
For no apparent commercial purpose. So I thought that's what I just said.
No, because
I thought it summarized what was being said.
Well, no, I think what you said was because there was a further layer of companies being inserted.
Yes, which is about the ownership of the asset.
No, that's a different question. So the ownership of the assets, yes, it is, because the ownership of the assets was what I've just taken you through. That's about the current question about who owns these assets.
Yes, but they won't be. They will no longer be owned by the fund. They will be owned by another entity.
But right. But the point here is that these are just proposals at this stage. So the fund has not gone off and undertaken a securitization process.
Well, it was about to.
Well, yeah, but always having said this is what we're planning to do.
Yes.
So there's a proposal that has been provided. So there's a PowerPoint proposal, for example, at 1916.
Is that the old one? So that's
Yes.
not the same thing, is it?
Oh, that is the old one.
So that doesn't relate to it.
Sorry, the new one is at 5635. No, but my point is this about this, that at no stage is the fund saying, look what we've done, or indeed look what we're doing in terms of actually transferring around assets. There have been securitization agents who were being appointed to undertake this stuff. But the question for the fund was, well, what do we do now? Because we're being told we need to redeem. We can do it in two ways. This is what Mr. Britton says. We can either fire sale the assets now and generate a lump of cash. So this is Mr. Britton's evidence at 1820, paragraphs 43 to 48. And what he says is we can either fire sell them now or we can undertake some form of securitization process.
So paragraph number again.
43.
Mm-hmm. So I understand. I understand.
Sorry, 46. He says that.
43 to 46. So I understand the position is that this is meant to enable. This is meant to introduce liquidity. I understand your case. It's meant to introduce liquidity, and that you say that you don't have to pay back any cash. You can pay back in these notes, which may or may.
Yeah, I mean, again, this is all subject to discussion. So we will have the notes, which can either be traded for cash or handed back. It depends. So we're not saying we're doing this and this is unilateral. What we're saying is here are a series of proposals that have always been explained what we're thinking of doing, what we're planning to do with this, and opened for discussion with FTT. And so there was that proposal that I was taking you to, but I think it's 5635 is the new proposal.
5635. I don't think I've seen that. That's the Here's another interrupted moment. Concurrency. There you go. Okay, let's try and understand this. So, sorry, what is this then?
This is a securitization proposal. So this is in relation to the appointment of the agent. This has been paused.
Yeah.
Because your lordship made it clear that it wasn't to proceed.
Yes.
I have to say, from our perspective, we don't really understand that because the order's made against DMCC and not against Mr. Britton. But we have given undertakings and so forth, and so this idea that there's a risk of dissipation as a result of this, we would say, just doesn't work, because what's happening is we're putting this on the table and saying this is what we're doing. We're not doing things unilaterally to move assets around. I can see your lordship's point if what we'd done is we came back and said, well, by the way, these were owned by Kibo Mozambique, for example, but they're not anymore because we've moved them off to an SPV in Cayman Islands or the Solomon Islands. And they produced a bunch of notes and we've turned that into cash, or we're turning it into cash. Then it becomes more liquid. And if you already think that there's real risk that there's going to be unjust dissipation, then unjustifiable dissipation, then you might think that increases the risk. I can see that, but we haven't done that. The fund has not done that. The fund has said, we want to do a securitization in total. Here's why, because we want to use it to increase liquidity. Here's how broadly we want to do it. And the complaint comes back, well, this looks like some sort of scheme because you haven't told us exactly and precisely how it's going to happen. So sitting here today, I can't tell you the precise mechanics of how, for example, it's proposed that these things will happen. And this is one of the points I was going to circle back to. Securitization is somehow if securitization is somehow the problem, then that's what the relief should be tailored to, not to this general freezing of accounts and so forth. I mean, this is all subject to my points about not having a proprietary interest in the first place.
Yeah.
But FDT has an FDT wants the securitization to proceed so that they can redeem.
That?
I'm going to get a reference to that. I'll have to give you the reference to that in due course.
Okay.
I will come back to that.
Okay, that's important.
Sure, it was accurate because it was told to me.
I'm sure your instructions are accurate.
Yeah. So, I mean, your concern seems to be focused on precisely how the securitization is going to happen in terms of, so take for example, whichever one of those companies in the chain that I showed you. Precisely how is that going to work, and who's going to be how are things going to be transferred between entities?
Yeah, I mean, I function on a very simple and unsophisticated level, which is assume that let's assume the argument is that the money went to DMCC. The money was then used to buy assets. Those assets were then transferred to the fund. The fund is now a party to proceedings in Hong Kong, and so there is a possibility of tracing through. If everybody is as guilty of conspiracy as alleged, then the fact that the fund is then taking the assets which have been derived from the money paid through DMCC and in some opaque way transferring them, as you say, to a Solomon Islands SPV or whatever for a securitization process, then you can understand, I think, on that basis that the court is going to have some concerns about a risk of dissipation if you look at it through that lens.
Right. I think the starting point of that was, well, if we assume that they've done all these things
exactly
in this way, but this where I'm looking at this at the moment is there's a primary fact on which an inference of fraud is being drawn, and the other assumption that your lordship included in that sentence was in an opaque way.
Yes.
And also, your lordship said it in the present tense, if it is being transferred. None of those things are true. So the point that I'm making is securitization is a normal commercial activity. It can be done in a perfectly acceptable and appropriate way.
Absolutely.
Right. So that's the starting point. The fact that I can't sit here today and say in relation to this particular asset or that particular asset, these are the deal mechanics for it. It isn't we say relevant because the deal mechanics of it will be worked through with the securitization securitization agent in due course, subjected to audits and all the rest of it. So the assumption that this is going to be carried out in an opaque way in the Solomon Islands is an unsupported assumption. There's no evidence to suggest that. And it's also inconsistent with the evidence of how this has been dealt with by the fund to date, which is in an open-handed way. The reality is that these assets have not been securitized. And when your lordship, when your lordship said after the first hearing, the claimant accepts they can't trace through into the assets of DMCC. There was a concession that you accepted in relation to that. That was at page 1126, paragraph 66.
1126. Let's have a look at it. Yeah.
Paragraph 66. So just to frame it, the issue was that the concern, my concern for my clients, was that it might be said that money had recirculated and therefore a proprietary injunction meant that they couldn't touch anything. They couldn't deal with anything. They couldn't pay wages. And your answer at paragraph 66 was Mr. Holloway's submission that Dmcc is not the trading entity renders Mr. Montague-Smith's points moot. Mr. Holloway appears to be conceding that Techteryx would have no claim to the assets of the trading companies.
Yes.
Indeed, it's Aria DMCC's case that it would be impossible to attribute those assets to the 6 remittances since the funds have been turned over several times. There's also commercial logic and so forth. So the point that you were making there, as we understood it, was that there could be no tracing below the level of the company, of DMCC.
No tracing below the level of the shareholding.
Yes, below the level of the shareholding.
Yes.
Right. But obviously you're dealing with trading entities, and what we're talking about now is securitization of the income stream associated with a company that is.
Well, are we talking about? I'm sorry, then I misunderstood. I thought it was securitization of the actual ownership of the company.
But the companies are held. I've shown you the custody chain of the companies.
Yes. But I don't really understand what the securitization is.
No, but this is a slightly different point, which is that if you're saying that the shareholding of the DMCC is what matters,
the shareholding in the company.
But in which company?
Which are the fruits of the, well, first of all, we have to establish that the DMCC has transferred the assets to the fund.
So we're not going to have time to do that now because we're getting bogged down in issues, I think, which aren't really raised. This is the point.
Well, I'm just interested in where the 6 remittances have gone, what assets were purchased with them, how they, whether or not we haven't got to the porting yet, how they, whether and how the assets were transferred to the fund. I mean, that's the basic, isn't it? Really?
Well, it's part of it. What I was just dealing with now was the underlying allegation that is made in Hong Kong that securitization, or the proposal that there will be securitization, is somehow evidence of fraud. And we say it's just not possible to say that. And this is a sidetrack, because what I'm trying to explain to you now is our understanding of your lordship's explanation of why there wasn't a proprietary problem in relation to the trading entities, and
in relation to the assets of the trading entities, not the trading entities themselves.
Right, but the assets of the trading entities are right. Okay, so I see. So well, perhaps we misunderstood that then. In other words, you are saying that you get to, for example, that.
Well, look what it said in terms. Mr. Holloway appears to be conceding that Techteryx would have no claim to the assets of the trading company.
Yes.
So,
which would be shares in mines, for example, or would you? I think that's where we've misunderstood.
So the trading company is the mining company, isn't it?
I see. All right. I understand now. Well, perhaps
So
we
the
misunderstood that.
bitumen, so it's the bitumen plant, whether or not they have any claim towards to the lorries or the ships or.
Right. But in response to that, what happens is that my clients write to the other side and say, we don't think that the judge considers that we have to stop this because of what's been said in the judgment. Now, if my clients had gone ahead and done it and you decided, well, actually, that is inconsistent with your position, then that would be one thing. But they don't do that. They write to the other side and say, look, we don't see that there's a problem with this, but we put you on notice that's what we're planning to do. And then the answer comes back, well, that's discretion. Actually, the answer doesn't come back. The answer that is the solution that is devised is another ex parte application in front of your lordship in circumstances where this has always been on the table. It's been explained in advance in every case. There was no prospect, no arguable basis on which my learned friend could really say, if we give them notice of this hearing, they're going to go ahead and do this in the next 2 hours or whenever it might be. So we do object in the strongest terms to that ex parte hearing taking place without us. And we've never had any kind of real justification for that. And we haven't been heard on that. And in the context that it was done as well, we do say that was a deeply unwise application for my learned friend to make, because he's having one-sided conversations with the judge who is seized of the application and making more submissions that are adverse to my case. We do not accept that was an appropriate way for my learned friend to proceed. But it's symptomatic of the point in relation to securitization. If you get to the end of securitization, it makes things more liquid and therefore more capable of being moved around. I understand that. If we were doing that in secret, you might have the beginning of a point.
Yes.
If you have a process that is telegraphed all the way and explained as being a mechanism for redemption, we just don't see the point.
Okay. I think we really do need to get to the porting and following following the assets, the money and the assets through. So it seems to me that's really what it's all about.
I'm told that the requests from FDT for securitization. I'm going to have to check those references. I'm going to have to check those references because I don't really think
you can give me that after lunch.
Thank you. All right. I don't think those are the right numbers, I'm afraid. All right. The other pleaded complaints are not investing in accordance with the PPM. That was not pressed on this application. And I just draw your attention to 2 short provisions in the PPM, which you find at pages 385 and 425. We don't have a lot of time for that.
So what do you want to take me to?
385. This is the PPM.
Yeah, 385.
And the point is that the investments, the terms of the PPM permit the fund to do whatever they think is the right thing to do.
Yeah.
So at the bottom of that investment strategy, the fund reserves the right to change the types of investments and its techniques for making investments if it believes that such changes are appropriate.
Yeah, and I've got all. I have read all of that, so I understand.
Thank you. And the point as well, the commercial point one would make is there's a difference between a fund that's managing $100 million and a fund that's managing $500 million.
Yes.
And at that point, one can understand quite sensibly a change of strategy. In the middle of the page on 425, you probably have that as well. There's a wide discretion of the directors, so I'll leave that there. Yeah. Insurance, that's not. Yeah.
Insurance, I think is quite important, and also page 415 is quite important. I thought with representative transaction. So if you start at 414.
Yeah.
So 414 is you've got the investment objective and strategy, and then there's the explanation of all of that, and it comes to representative transactions, which is said to be the way in which the fund works.
So the examples that are given are representative of the anticipated investment strategy of the fund at that time.
Yeah.
But my point is that is the allegation that the way that the investments were used was in breach of the PPM terms? Answer: no. They've just got a broad discretion. B, is the use that was put to them indicative that this was just a sham fund in the first place? Answer: well, make the case. What's the case on that?
Yeah.
Answer: no, because they are entitled just to react to the market conditions and the volume of cash that they have at their disposal to invest. And this is explained in relation to insurance. That is explained by Mr. Britton at 6640.
Let's have a look at that. Thanks. Yes.
And so he sets out the liability insurance that is undertaken.
Yes, I've looked at the policies. They don't insure investments in associated entities, do they?
But that's not what's, as we understand it, that is not what is required by the PPM. So he sets out the relevant passage of the PPM. The fund will engage in comprehensive structured credit insurance products to protect against default by counterparties that have been pre-approved by the insurer.
Yeah.
And the insurance policies and so forth.
So when they are investing in that manner, it is insured. That's what's being said. Okay. Understand.
So the payments, the porting of the payments, what has happened is, well, I think you've got an explanation, I hope, of the porting process. What happened was you have one set of documents that is created at the time that the money was sent across, and so I'm sorry, I'm getting a lot of messages. I need to slow down a bit. At that time, the payments were treated as loans, effectively notes to DMCC. And so
where do I see the?
I'm going to take you through some examples of those, but it is shown. And what happens then is that FDT say this needs to become an investment in the fund, and a new set of documents is then created at that time. And then there is an accounting reconciliation. And as a result of that, the fund recognizes subscribers as of the dates of the original payments. And then the money that has come in is reflected either in loans or a loan due from DMCC to the fund, or in investments as they are brought into the fund. Okay. And so it's not a kind of clean picture, but Mazars did look at this in the preparation of the 2021 audited accounts, and you have that at 6548.
Yeah.
And if you look at subsequent events, note 23, subsequent to the balance sheet date, 30th of June 2021, the fund received additional subscriptions totaling to 512. These subscriptions were for newly issued redeemable participating shares. The additional redeemable participating shares will increase the fund's capital and impact its capital structure. Further, following the balance sheet date and up to the issuance date of these financial statements, the fund has redemptions. So it's looked at those additional subscriptions. And my learned friend said, well, he took you to an email and said there's no evidence that the auditors considered the porting. That is not accurate, because the evidence of FTI is that the auditors could not have signed off on this without being satisfied of the porting process. And you have that at 8930.
Okay, I mean, this is all secondary. I just like to be taken through the process, really, and see the documents that underlie it.
I think this is important though, because what I'm pointing out is that we can sit here today and pretend to be experts in accountancy regulations and rules and say, well, this was or wasn't permissible, but Mazars have looked at this, and in the most recent accounts, they've looked at it expressly.
The obverse of that is I don't know what they've seen. I can only work on the evidence that's before me.
Well, I'm showing you what they've seen. There is evidence of what they've seen. So, for example, Mr. Van Vuren says the point about FTI is FTI say they must have seen sufficient to satisfy themselves. So they had to know that there's an after the event treatment of subsequent investment that's treated as having come in earlier. So they would have to have investigated, and that's what the evidence from FTI says at 8930, 818 to 820.
It doesn't say they were treated as coming in earlier, because otherwise they would show in the account. What it says is subsequent received additional subscriptions. Subscriptions were for newly issued redeemable.
What they say is 820. In my view, for this Mazars, a firm of regulated auditors must have reviewed and addressed at least the first part of the porting exercise, i.e. the reclassification of the DMCC payments as subscription in Aria CFF as part of its audit work for Aria CFF's financial statements, and providing an unmodified audit opinion on financial statements, which included the subsequent event disclosure. Forces Mazars appears to have agreed that this is relevant to
What
users
page
of...
is that? Sorry,
what I'm reading from.
Yeah.
It's the next page. It's 8931. It's paragraph 8.20.
8931. Sorry, I was still on the Mazars report. 8931. Paragraph
8.20.
8.20.
But Mr. Van Vuren, sorry, I keep writing his name down wrong.
That's okay.
6398.
It's 639.
Paragraphs 19 and 20.
Yes.
Mazars, I understand that Mazars reviewed the relevant subscription and redemption documentation related to the above events. The most recent accounts deal with this more explicitly. Supplementary Bundle 2, page 13.
Yes. Thank you. What
do
I see there?
So page 13, you see towards the end, net assets attributable to holders of participating shares, and the total liabilities, above that, total. So under the heading liabilities, two-thirds of the way down, total liabilities, and then it says net assets, and then total liabilities, including net assets attributable to holders of redeemable participating shares, 654 million. So that shows the shareholder liability, so the liability to shareholders going up in the period from 180 to 653. That's not the whole of it. We go forward 2 pages.
Yep.
You see the net increase from share transactions. So that's the other side of it, the net increase of proceeds. And then if you go forward to page 28 of this bundle, note 13, in addition to the transactions previously disclosed in the notes above, the fund also entered into the following transactions. During the year, Aria Commodities Dmcc transferred subscriptions and assets to the value of 505 million it had received to fund, and for which investors received 512,294 participating redeemable shares in exchange. So they have looked at that process. They've audited that process.
Yes.
So the idea that the allegations that the sort of the fact of the backdating, for example, of the issue of shares in the fund is somehow unlawful, is unsupported, and is inconsistent with the evidence. Actually, when you look at the OGA evidence, it doesn't say that this is in any way improper. But ultimately, what matters is that the investors got their shares in the fund, and we've seen that in the register. Essentially, the porting process has been explained. There was some suggestion that it's been explained in ways that are inconsistent, and I'll come on to the documents in a moment, but that is not accurate, because you will see at page 8928, FTI's explanation, and they say, well, that's inconsistent with Mr. Britton's. It's paragraph 8.8. But when you look at that,
forgive me, you're going to have to slow down slightly for me. So 8928. I know you're feeling under time pressure. I'm sorry about that.
Well, I mean, my client's accused of very serious frauds,
Of
and we're
course.
getting a spray of allegations that were new during the course of oral submissions, unparticularized allegations that were developed in significant ways during submissions that were put in skeleton, and we need to have an opportunity to answer them. So I'm trying to do this as fast as possible.
Yes, no, I understand all of that. I'm just trying to keep up.
Yeah, I understand. Well, I'm trying to keep up with my learned friend's newly evolving case, and that's the difficulty. So it's 8.8. He explains his understanding of the porting exercise.
Yeah.
And you will see in the footnote, it's derived precisely from Mr. Britton's explanation. The idea that it's inconsistent with that is simply wrong.
So treated as loans. So
yeah.
Okay. So is there loan documentation that you can show me?
Well, there is some. I mean, it's pretty limited. I accept that, but I'm going to show it to you because what you've got. So what Mr. Chock says is he thought that he was always investing in the fund. And what we have in this supplementary bundle is an email.
8.8. Okay. Yes. So Chock. So we've got Chock in the supplementary bundle.
I wanted to take you to page 37.
Yes, of course. That's the second supplementary bundle. Is that all?
Yes.
Supplementary bundle 2.
Supplementary bundle 2, and it's page 37, and you'll see Mr. Britton.
So, page 37.
Yeah,
and Mr.
So,
Van Vuren.
No, 37. 37 is the top right, I'm afraid.
Oh, sorry. Okay, I have it. Yeah.
So you've got an email from Mr. Britton, dated 18th of April 2022, copied to Aria Commodities. It's to Vincent Chock, and then the attachments are Aria DMCC term sheet, 6% March 2022 FDT. So and then so what you've got is he says, "Dear Vincent, once more, thank you for your continued support. In line with previous exchanges, please find attached to the TS, the term sheet for the most recent subscription. Moreover, we're pleased to confirm the transition of all FDT and legacy subscriptions across DMCC and CFF to the 6% classes of 1 May 2022. So we would suggest that he clearly was aware that there were subscriptions across DMCC. Now, I mean, he was told that. Whether he was personally aware of it is another issue, I suppose.
And he's the term sheet.
And then we've got a term sheet, which is for trade finance. Yes, exactly. And so that's effectively what it was. And you've got the terms set out below that. And what happens? I mean, it's Mr. Chock.
Aria Commodities Finance. That's in the fund.
Well, yes, the documentation is not clear on that. That's true. But what we're saying is it's clear that this was, well, we thought that it had been made clear to him that these were in fact loan notes in Aria Commodities. So that's what it says. That's why the attachment is named Aria DMCC term sheet, even if
but it isn't.
Well, so that's an error in the document.
Okay. So
Does that error is that indicative of fraud? Well, if you go at it with the lens that this is all a fraud, you might say, well, that adds grist to the mill. But if you don't, and you know how trading,
this isn't about whether this is a fraud. This is just goes to the issue of refuting the evidence of Mr. Chalk in his first affirmation that he thought he was always investing in the fund. And he might get the impression that he was investing in the fund if a term sheet is sent to him of the fund.
Well, it's possible that happens. But if you go to 4144, for example.
Sorry, can I just make my note?
Yeah.
So you want to take me to 4144?
Yeah. So you've got there in a subscription application form, which is dated February 2021.
Yeah.
And so this is, if you've got our reading list, the 5th DMCC payment. And what I'm showing you is the original 2 documents which made up the 29 million. So there's one for 17 million, and then there's one for 12 million.
Yeah,
right?
I'm pretty familiar with these. I've been through.
Very good. He's the person who signs off on this, right? And then yes. So this is February 2021.
Yeah.
And then 4729.
4729.
Yeah.
Yeah.
You get a letter written to Aria Commodities DMCC.
So that's to DMCC. Okay.
Referring in the first line, I think, to the subscriptions, and says this letter is prepared jointly by First Digital Trust and Legacy Trust, and refers to the enclosed Aria subscriptions and talks about the 2 subscriptions. Then says that they should all be treated as being held by FDT. Sorry, it was agreed that Aria subscriptions shall be held under the escrow and or custodial care of FDT in substitution of LTC. So that's the sort of transfer from Legacy to FDT, essentially. And it's signed off by 3 people: Mr. Chalk, Mr. Jebb as FDT director, and then over the page, this is the letter that's been prepared for signature by the Aria side, and it says, do you have this on page 4730?
Yeah.
Aria Commodities DMCC have read, understood, and agreed to the terms stated in this letter. And so it's an agreement that he's asking for and getting from Aria Commodities DMCC that the investments shall be held for the benefit effectively of FTT. Now, so
First to the subscription. So it refers to subscription. Do we know what those subscriptions are? I haven't traced the.
Those were the ones, I believe, the ones that I just showed you.
Okay, well, I can check.
I
can check. You just make a note. Check.
Yeah. So yeah, it matches the reference number at the top left hand of 4144. So if I'm looking at 4144 now, and I'll read out the reference for your lordship so you can check it. It's ACD underscore SOY underscore 5594 underscore 02 underscore 21.
Yeah.
And the second one is the same, actually.
Okay, so that's 41. So that. Okay, that's good.
So I haven't traced it through for the other aspect of that, but what that shows is that Mr. Chock signs forms for $29 million under the SOY reference number. He then subsequently writes to DMCC seeking agreement that those investments be held for FTT rather than legacy.
Yes.
And he gets that agreement, and that's.
So he accepted. So what's saying is that at the very least, so far as 4144, which is DMC payment number 5, that subscription was in DMCC and not in the fund.
Yeah.
Okay.
But his evidence is that he always thought he was dealing with the fund. So
yes,
that's really the sort of target that we've.
Yes, I understand that. Yes.
But I think what happens then is that this is not hidden from FTT. Is the other point? It's not suggested. They say they realised in late 2022 that this was the position, and they instructed the fund that it be moved to the fund. That's Mr. Chock's own evidence. You've got that in the supplemental bundle at 66, paragraph 32b. Yes. And that is what happened. So what the result of that is that you've got a evidence of the transparency, at least as between DMCC, the fund, and FTT and legacy as to how these are first being held, and then subsequently how they are being treated. And one asks the question: well, is that evidence of fraud? It's not actually alleged that this was concealed from FTT, for example. That's not one of the allegations. The allegation is just the money went to DMCC. That's the pleaded case. So we've explained that. This is the explanation. And then the response comes back, well, perhaps FTT didn't know about that. And the answer is, well, we thought they did, and here's why. But even if they didn't, even if they misunderstood, then how is this regularized? It's regularized as soon as they asked for it to be regularized.
Yes. So they were originally booked as loans.
Yes.
So can you help me?
As credit notes, and the terms of
where I see the loan.
Well, that's just the credit. All we've got are the credit note terms. So I've shown you those.
So credit note. I'm sorry.
The term sheet. The term sheet.
The term sheet.
Yes. That's a supplementary. I mean, it's already in the bundle, but the suggestion was we didn't know whether that was an agreement with DMCC or who the parties were.
So I'm confused now. So the money was transferred to DMCC. It is said by FTI that they were originally booked as loans, which is based upon Mr. Britton's evidence. But so I'm just looking for the loan documentation, but you say there isn't any.
Well, I can show you. Well, if one thinks about how trades are done, that they're usually done by reference to a term sheet, and a concluded agreement.
So it's a trade. So you talk about trade. I mean, I think I had understood Mr. Britton's evidence is that this was a loan by FDT to DMCC.
Yes.
Not that these were loans to not that these were individual trade finance loans to Trafigura or somebody else.
No. Correct. So but the terms on which those monies were lent were the terms set out in the trade finance notes.
Let me go back to. Well,
so you'll see
there's no executed document, at least on the record, that shows.
I think that's right.
Loan.
But what you do have is contemporaneous email from Mr. Britton to Mr. Chock saying, please find attached the term sheet for the most recent subscription.
Let me just go. Well, let me go back to that. That's page 37.
Correct.
In line of please find term sheet for the most recent subscription. Well, I'll have to read that. I didn't read that term sheet in detail.
Well, it goes over the terms are in page 39.
Yeah.
And they provide
Okay,
for.
well, I'll have to read that. I'll have to read that. And that's insured, said to be insured by the Lloyd's of London. Okay.
Yes, looks like it.
Set back collateralizer. Okay, but that's a draft.
Well, it describes itself as an indicative term sheet and a draft, but it's being that, I mean, those are forensic complaints about what a document's clearly being sent by Mr. Britton as the terms.
But this is different from the subscription.
No, this is
different from the first. This is different from the first subscription. So, which subscription are you talking about? For the most recent subscription, so April 22. So what's the April 22?
As I understand, this is one that was is that right? Resubscribed.
I don't know. The last subscription. The last subscription was the 9th of March 22, which was number 6 of the DMCC payment.
Yes.
I mean, is this in relation to a DMCC payment, or is it something else?
This is the 200 million.
So this is the last one.
In the last one, as I understand it, is that right?
Okay, so that is 4177.
4177. Yeah.
Okay, let's have a look at 4177. So this is class D, and the subscription. So this is pre-port.
Correct.
And if that email is pre-port, just to get it straight in my head.
Yes.
Okay. So class D, Aria, Commodities. So it's an investment in DMCC. Again, I'll have to read the terms. Okay.
And what is being said in that email is, so you've got the
confirmation, the confirmation subscription.
Okay. You've got the application here, and then you've got the confirmation at 4179.
Yeah.
And then you've got distribution statements in relation to that at 4183.
4183. Yes, I just that there is a slightly curious feature of all the distribution statements. It's 1 o'clock, and you may want to think about this over lunch. All of the distribution statements change to class C, which we accept is the fund in April of 2022, which is then 8 months before the porting. I found that slightly perplexing, but if there's an explanation for that.
All I can say is I think there probably is an explanation, but I'm not sure I'm going to be able to get it for you in a comprehensive form, because this is part of the problem with this process, is that this, I mean, I understand your
well, it's just me working. I've been given the
desire.
references, and it's a question that arises from the references.
Well, what's been said on this is that the fact that the money went to DMCC and the size of the cash that went is indicative that this was a fraud. That's what was said. That's the bold accusation. And what we say is that that is explained because prior to porting, it was treated as effectively subscription to loan notes. And I've shown you the subscription documents, and I've shown you an example of a document which says here's the terms in relation to the last subscription. And I've shown you an email where Mr. Chock writes to DMCC and says these investments that you've made, make sure that they're now in the name of FTT. So he appears to know, right? Yes. And so then he says late 2022, they say, they realise, if I can put it in those neutral terms, that these are not investments in the fund, or they notice, or however you want to put it, and then that is changed and new documentation is issued and there is an accounting treatment to resolve it. So that's the basic answer to all of that. The distribution statements change, as we understand it. You mentioned this. I'll check it, but the distribution
statement, because it's just there's no suggestion the distribution statements are backdated. So if they are genuinely of their date, 30th April, then they're not. Then it shouldn't be a Class C share. It should be the Class D share, which
B, I think was B.
No, this is D on 4177, not B.
I think there might be. I mean,
well, it says D on the version I've got.
Yeah, no. Well, it does. It certainly says D on the application form. You might, yeah. You appear to be right.
Yes, but so
the question that's being raised is why does it say D there and switch to B in April? Sorry, C in April.
And then C in April. Actually, it says C in March as well. Subscription, compilation subscription. So no, those are the later backdated one. It's the, yes, it gets confusing. It's a distribution statement for April, and it does that in relation to every single DMCC payment.
Okay, I will see if I can get an answer to that for you. One does have to ask the question, where does that go?
Well, look, I don't know.
Yeah.
It is just something that arose out of my reading that I was invited to do, and so the question arises.
No, of course, and I mean, and I'm not suggesting you shouldn't ask questions. Your lordship should ask whatever questions you want, and you'll take all the information away and get to the answers at the end of the day. But my point is not at that stage. My point is at the subsequent stage, which is, what do you get from this? What fact is what is the inference to be drawn, and how does it support the inference of fraud? And essentially what this is a new particular of an inferential fraud case.
It's not for me to raise particulars of fraud cases. I just raise a question on my reading. That's all.
Understood. But I think that that's how it would potentially be relevant to the issues for determination, and only then is really
Well,
relevant.
all I have to decide, I don't have to decide happily, I don't have to decide this case finally. All I have to do is look at the evidence in the context, as you rightly say, of the pleadings, and to see whether there are serious issues to be tried in relation to the pleaded allegations. That's the only thing that I have to do.
With one caveat,
Okay.
which is that you do have to, I think you accepted this previously, you do have to form a view on the merits, on the strength of the case that's put, because that is relevant at various stages of the process. It's not simply, as my learned friend would have it, once you're over the threshold of barely arguable, do you shut down a trading organization?
Yeah.
You have to see, it's very easy to point out discrepancies in documentation and say, well, this all needs to go off for trial. But what my learned friend needs to do is say, that difference between this document and that document means that the only rational conclusion is someone has generated this document, or it's a forgery or something of that nature, and therefore that in itself supports the proposition that X, Y, and Z. But none of that analysis chain is done. We just get peppered with, well, this is inconsistent with this. What's the answer to that? We don't have an answer for it. And you never get the actual case. And that's our primary complaint about those sorts of things. I'm very, very behind on where I need to be.
Yeah, I can understand that, and it's my fault.
No, there's no fault. I'm just warning you.
What I really want to focus on are the 6 remittances, and I really want to focus on. You've dealt with the porting, so we really need just to deal with follow the money, as it were.
Right. I mean, okay. Well, I'll come back on what we can do in relation to that. But the follow the money is not a pleaded allegation, in the sense that the complaint is that the money went to DMCC. That's the complaint. The complaint.
Well, they complain about. They suggest it never reached the fund.
Well, yes, that's right. But that's where we look at the end of the process.
Well, I think we have to look at the middle as well.
All right. Well, I'll do what we can in relation to that.
Because I don't. The end of the process. Anyway, it's not for me to argue a case. Let's take a break now. We've eaten into the lunch hour, but I think we better come back at 2 o'clock, even though. So 2 o'clock and 11 o'clock, I think, for you.
Yes. Thank you very much.
Yeah. Okay. Thank you very much. Okay, shall we proceed?
Please, thank you. All right, so in terms of the fund flows, what the first respondent has done has produced a complete set of the unredacted bank statements, which show the activity on the particular accounts into which the funds were received. Obviously, I'm not going to take you through those, but so you know where they are. They start at page 7649 of the bundle, and FTI has provided an analysis of those statements, and you find that at page 8903. And what I mean, it's right. I'm not in a position to provide you with a sort of chapter and verse. This is how this dollar and cents was used all the way through the life of the fund and back again. And I mean, if that's what your lordship means by we need to see the middle, then ultimately what you're saying is we need to audit these series of transactions over 5 years. I think I appreciate your lordship saying it's not enough just to show me the end of the story, but ultimately in a fund like this, that actually is what matters, because what the investors have is not a participating share in the fund as a whole, not an ordinary share as the of the fund. They're not so if the fund as a whole has an extraordinary year and doubles in size, their investment doesn't double. This is a coupon paying share. So with that in mind, I mean, I think is right. So there's criticisms of what the Kroll report has done. They have done that analysis and undertaken it, and you've got the summary there at paragraph, at pages 8903 to 8916. But what I thought might be more useful for your lordship is firstly to just try and show you how these things were dealt with in the NAVs as we go through time, if I can put it like that. And secondly, just deal with a couple of the points, or a few of the points that my own friend makes about criticisms of the documents that are produced. If one looks at the NAVs, for example, if one goes to 8616, you've got there the 30th of April 2024. And what I'm showing you is how these things, how these particular assets come onto the NAV. So one of the points that my own friend makes in his skeleton argument, he says the two mines that we've been talking about in the carbon resilience shares, they interest, they come into the NAVs in October and July 2024. So I'm going to show you just how, and he says, well, it's inconsistent with the accounting treatment, but essentially the evidence that you have from Mr. Britton is that if you look at the NAVs and go down, what you have this is before those assets are brought onto the funds, into the fund. So what do you have before that? You have a combination of loans to DMCC and also loan notes. And so what you see is in the receivables with third parties column, 2 up from the bottom, there's an investment in loan notes, reserve inventory, Bebco, Kaitai, and so forth, of 97 million. And it's in there that
Sorry,
you see.
So where are we looking?
So we're looking at the NAV.
Yes,
no,
receivable with third parties.
Yeah, investment in loan notes. So in essence, some of these investments were treated as effectively loan notes, and some of them were treated as loans to various Aria related parties. And so you see the related party receivables underneath, totaling 411, of which Aria Commodities has 316 million. And then you have the loan notes of 97. And then if you go forward then to the next NAV, which is at 8618. So now we're in July 2024. You can see there the carbon resilience share interest comes in. And do you see that? Under financial assets at FVTPL. It's the second heading at 125 million.
Yeah.
And then you have a commensurate reduction to the DMCC loan. And the loan notes fluctuate, and it's not a precise science, but you have the loan facility to Aria Commodities DMCC is now 197 million. Right, and then in 859, sorry, 8593, it's 8620 is the next one, which is now the October 2024 one. And so this is the first time you see all three of these primary assets that we've identified. and you see all of them now are in there, Mbuyukol and Bayakol. And you will see that the loan notes entry, receivables third parties, is gone. I mean, that's not to say there aren't obviously other receivables from third parties, but the specific entry that there was has come out of there. And you also see that the receivable from related parties, DMCC, has gone. And the receivable from related parties total has then therefore substantially reduced over that period. So it starts over that period at 411 million. That's on page 8616, which is the first NAV. And then it by 8620, you've got related party receivables is down to 43 million. There's still some out there. Now, it's not straightforward to give you the chapter and verse on precisely how the money, the accounting treatment of each and every item of money that was used for example, for the development of the mine. As I understand it, the position was that DMCC held that until the mine was moved in, I think, in October 2024. But I hesitate to give you, too much detail on that because I don't want to misspeak and mislead you. We don't have 100% sort of line by line audit of this activity, but we can see, we would suggest, that the explanation that has been given, which is that you have, it is consistent with these NAVs. So you've got essentially they're treating this as an investment in the fund, but then of lending from the fund to Aria, Dmcc and various entities, and then a reduction in those loans as assets are moved onto the NAV of the fund. There are some complaints that are made in relation to some elements of this. So, for example, you had some complaints about a lack of information and evidence in relation to hedging, and that accounted for $51 million worth of the monies that were spent and identified in FTI's reports. And it was said there's no evidence, and it was implied that you should draw adverse inferences from that lack of evidence. I mean, I can take you through a sort of worked example of those just to show you that those complaints are not fair. And in fact, actually, you do have sort of line by line entries in relation to hedging, which you can allocate to the $51 million. So the way we do it is we go to 8967. Sorry. Yeah. And what we need to do is just understand, firstly, what this is. This is
I can't read it.
No, sure. And I'm afraid I have to tell you a little bit about it. But essentially, what you have in here are line by line recitals of the entries in the bank statements of the various bank statements.
Okay.
And so it starts at 8963, and you can see what it is, which is a summary of the Maastricht bank accounts.
Sorry, it's also it's small and corrupted.
Right. I think the best way for me to do it, because we are so short on time, is just for me to explain it to you, and hopefully we can then look. So essentially what I'm looking at is an appendix 4-4 of the FTI report, where they recite the summary of the Maastricht bank account. And that's, you see that at 8962. And then you've got line items. And if one goes forward to and essentially what we're looking for are $51 million worth of payments. And you can see, firstly, $21 million worth of payments go to North Dimension. And these are on 8966. To start with, and it's entry 170. And the reference is what you'd be interested in each case.
So let me see if I can have a look at that. 8966. Yeah, okay.
And so
once I'm going to blow it up, I'm going to blow it up a bit.
well,
right,
I mean,
I've got it.
We will, if we do this in line by line, then we're going to be here until next week, I'm afraid. But
okay.
essentially the reference is, yeah, the reference is beneficiary name, North Dimension Inc., file reference, transfer type, TCP, trade credits and advances, payable, FTX deposit of monies for future trades. And then you've got entries which are similar on page 8974. Sorry, that's my which again identify deposits for future trades, and it's line 536 there. On page 8977, you've got line 660.
Sorry,
and page 9.
Do you want to give me the numbers and then I can look at line
536.
536. Then page
8977.
8977 and line
660.
660. Yeah.
And 9000 and line 1749.
Okay.
And that accounts for $21 million.
1749.
Those are the North Dimension payments.
21 million North Dimension. Okay.
And then the other payments were made to IG Limited.
That was the 51, wasn't it?
That's the rest of the 51. So it's 30 million in total in three entries. But those are not visible from the bank statements, and those were the ones in relation to which we needed to get advice notes.
Yeah.
I'll give you the page entries for those. It's 9011.
9011. Yeah.
Sorry, bear with me. 9011, and it's line entry 73.
973.
And the FDI category is payment to IG for hedging. And then you've got entry 9011 again, but this is entry 90, and then entry 102 on the same page.
102. Yeah. Okay.
And then you've got the payment advice notes in relation to each of them, which you will find on pages 8679, 8681, and 8682, all referring to the hedging account. So the total is $51 million. And my learned friend in his skeleton argument, paragraph 19.2, invites you to infer that these monies were used for some other purpose than hedging.
Claimant skeleton para. The paragraph number.
19.2. So sorry.
19.2. No. You said it, but I didn't get it down. Okay.
So he invites you to draw that inference, but it's not an appropriate inference because the evidence says it was for hedging. Now, of course, we don't have the underlying hedging documents, but then we really are into audit territory. There's complaints about the methodological approach that FTI took, but in the time available, absent of complete audits, we say this was an appropriate approach to reduce that. So Mr. Thompson limited himself to payments over $1 million, and the three accounts into which the money was brought to keep things within manageable limits. And then the rest of it was sort of, that you were pointed to the new bank accounts, for example. And in the skeleton argument, there was reference to some of the old information, and it was said, well, they've identified substantial payments to Mr. Britton. In fact, in those documents, the total of the payments comes to $620,000 in the whole period. Which I'm not sure I know precisely what that period is. I think it's for between September 2021 and September 2022.
620,000.
Yes,
Yep.
Correct. And if you want I can give you all the references to that if you need it, but it's page 8959, item 22, page 8990, item 1278, page 9014.
Sorry. 8920, item
1278. And 9014, item 339.
Sorry, what was the item number at 8939?
There was no 8939. I think that's gone wrong. So just to check.
That's maybe not reading my own writing. The first of these.
The first was 8959.
Okay, that's my own writing. Okay, that's good. And then the item is
22.
22. Thank you. That's fine. Thank you.
Essentially, the complaints that are made. So what happened is my own friend put in a bunch of bank statements and said, well, you can't be surprised by these. And then said, well, these bank statements show payments to individuals, and that's all terribly suspect. I can't give you evidence as to respond to that and explain them all away, because that was the first time he's raised these points on this. But we make the point that in a group, the payment to individuals is not terribly surprising. I can tell you what these are. I mean, you've got some references to payments to Mr. Britton himself, but obviously remuneration of chief executive is perfectly normal. And in the particular year, I think this is 2022 we're dealing with, the first respondent made, in terms of revenue, $106 million, but profits were 7.5 million over the period. And no management fees have been taken by the first respondent in relation to any of this. There was complaint about school fees, for example, complaint about payments to Mr. Peter Williams, Mr. Gangle. The school fees were part of trader packages, I understand. Mr. Gangle was lent $68,000 to buy a car, which he repaid. Mr. Williams was due some commission. Ms. Murray was reimbursed for some expenses. Mr. Levchenko was paid funds in relation to Aria, Ukraine. The point is, you can't decide any of that, but it's not enough for my learner friend just to come in and say there's payments to individuals, that's all indicative of fraud. It's not. My Lord, in your reasons previously, you identified concern that it was seriously arguable that there was no one else, really no other than Mr. Britton involved in this enterprise. And so we have introduced evidence of the people who are involved, or some of them. And you've got witness statements from Mr. Van Vuren. You've got witness statement from Mr. Gangle. We also have a new director who you will find at the end of the second supplementary bundle, who's only just been appointed, and that's Mr. Michael Pearson. I would invite you to read the witness statements from Mr. Van Vuren and Mr. Gangle if you have not already done it. In particular, Mr. Gangle is the managing director of Aria Bio, and he gives evidence that Aria Bio employs about 120 people and turns over about $200 million a year on average. This evidence is not seriously challenged. It's just written off as being irrelevant to the issues. But the issue at this stage was whether or not Mr. Britton was the only person in this group. And the answer to that is he's not. And there's strong evidence in relation to that. And also, we've got evidence from FTI that there's no particular problem with concentration of management. I wanted to come back to the securitization bits in a moment, if I may, but just to provide you with the references I promised you. There's complaint about the structure of the group, that it's grouped into 3 separate groups, but no one's ever explained why that is indicative of fraud. It's not. That's not particularly new. There was a complaint that the investment manager was not the owner of the management share in Cayman. There's no requirement that it be that. And the investment manager has changed, as the PPM says it has changed, from the Cayman entity to the FZE entity. Again, it's not explained why these are inferentially supportive of fraud. It's said that there are no financial statements, but we do have audited accounts. We've got the 2022 accounts. I'm still waiting for confirmation that Mazars has signed off on them. It's said that there's lack of information as to the administrator, but we've got at least one administrator report. We've got letters from the administrator, and really they'd reduced to saying, well, the administrator hasn't filed a witness statement, so you should infer that they're not willing to file a witness statement, which is again not an appropriate approach. Secret commissions to Glassdoor are relied on, they're not pleaded. But the evidence, in fact, is that payments to introducers are commonplace. Okay.
Not sure where I got the word secret from. I know it was said it was secret commission. I don't know where that adjective arises.
It arises pejoratively in submissions by my learned friend. It's
I mean, secret from whom?
Yeah, well, quite. And so Techteryx say, well, we weren't told about it. That's not relevant because on this FTT were aware of it, and you've got the evidence from Mr. Chock about the payment of that, and you've got the evidence of Mr. Yai about how that all came about. And they attack it in 2 ways, essentially. Techteryx says, well, we didn't know about it, number one. Well, so what? It's not for you to know about. You're not the investor. But B, they say, well, there's some connection between Mr. Yai, and Mr. Yai deals with that fairly comprehensively, and it's extremely tenuous what is being alleged. So if you're concerned about any of that, have a look at it. But ultimately, payments to introducers are commonplace. FTI says that. That's 8926, paragraph 8.2. Payments to Glassdoor or to introducers were permitted by the...
It's paragraph 892.
No, it's page 8926.
Paragraph
8.2.
8.2.
Payments to introducers were permitted by the PPM and also by regulations. And I have a reference to that, which is 7359.
Mm-hmm.
Where I think it's Mr. Britton recites, recites some of the PPM provisions at 27.4 of that document, which actually is on page 73. I'm so sorry, that's bundle. It's not, that's wrong. Yeah. This is in the Campbell's memo.
Well, I think one of the confusions is describing the subscriptions as being for shares when they're not really. They're for units which pay coupon. I mean, they're more in the nature of bonds than shares.
That's their functional effect. But they are described as participating shares within the legislation in Cayman. Quite, and I think that's part of the response is, and I think the way that that's described is that there isn't such a great. I mean, if one thinks about it, the sort of porting, effectively from my client's perspective, what's happened is that rather than there being something with the functional effect of a bond to DMCC, that's been switched to being something with the functional effect of a bond to the fund. And it's not actually a huge distinction. Obviously, it's important. It needs to be properly regularized. But
well, if
that's
it's a bond,
why.
then a bond, it depends. It depends who's the issuer, because that affects the credit risk and the rating of the bond if it's a bond.
Of course, that's right. Of course, that's
Yes.
right. And obviously, but that's what I say when it requires some sort of accounting adjustment after the event to ensure that actually, I mean, really what matters is what goes forward from the date after porting, but it is regularized going backwards as well. But ultimately, what they get is what they always thought they had, which is something which is the equivalent of a bond which pays a coupon and can be redeemed at the end.
Yes.
And that's why we say actually what's most important is when you look at the end of the story. What's going on?
I mean, if you may not say this, but it may be said that there's a rather casual attitude towards paperwork. At the end of the day, you look at the result.
Yes, I mean, obviously, I may not say that, but
No.
what I would say is if there was a rather casual attitude towards paperwork,
Yeah.
what's the result of that, both in terms of where FTT is left with its investment, but also in terms of whether or not that it's possible to infer from that some sort of nefarious conduct.
Right.
So just dealing with the question about who came up with the idea of securitization, it does appear in that call transcript, and like all call transcripts, things don't emerge terribly clearly.
That's a particularly bad one.
Well, I know, and I think that's difficult. But so if you go to page 5036, so it's one has to work from fragments because that's just the way that conversations happen, particularly in this sort of context. And if you look at about a third of the way down, you see Mr. Britton 003722. He's talking. What he's done is he's just given that presentation, I think you're aware of, about securitization, and he says at the end of that sentence, but that was the sort of mandate we were given. And Diana Bushard says, by whom? And then further down at 3732, she says, who gave this mandate? Again, it's not terribly clear. And later on, she says, where does this direction come from? So then over the page, it's fair to say, in this context, Mr. Britton's being a little coy because he doesn't want to throw anyone under the bus if that turns out to not be the right thing to do. And he says, essentially, he describes it in roundabout terms. About the middle of the page, he says to underline Michael, and that's a reference to Michael Titus of FTT, who comes on later. He says, is it a fair thing to say? We didn't already just decide that this was was a good idea. And Michael Titus says, yeah, I would say that. And he says enough we. I mean, it's very difficult to get it, but and then what happens is over the page, Michael Titus says, the kind of discussion last time when we were by the credit aspect was really one of the things that I think all parties were relatively concerned about, if it was just receivables and not actual assets, and then beneath the funds. So the concept of getting this securitized, or essentially kind of having direct line of sight in relation to this, the value of the assets and securitizing, that was a sense, the understanding that we had. So our understanding was it came from FTT, but ultimately the point here is that this wasn't.
Sorry, Michael. Who's Michael Titus is?
He's of FDT, so you can, I think, he is. I'm not sure what role. I can't.
That's okay. And Dinah Bushard is.
I think she's there on behalf of Techteryx. Is that right? So Michael Tyson's the director of FDT.
And she's.
It helps.
She's Bushard is TrueCoin.
She's
Yes.
TrueCoin. Okay.
And I have been asked just to remind you, I think it's clear that when we were discussing the question of what was the interest in the fund interests, the units in the fund are shares. They are shares.
Yes.
I think I made that clear. They're not debt.
No. They're equity, not debt. That's
Yeah, it's just the function. I think was the point that your lordship was making.
Yes, it is. I mean, because
similar.
you don't often get a share that pays coupon. That's more in the nature of a bond.
Well, that may be right. I'm no expert, I'm afraid, in that, but that's what these instruments did.
Yes.
My lord, there are other points, but I am out of time. And I did want to tell you something about what I say about enforcement of a Hong Kong judgment in the DIFC.
Yes. Well, yes. That's of
But
general interest.
Of general interest, but I think my own friend now says this goes to discretion. It doesn't. It goes to good arguable case. He actually accepted that at the first instance. And I'm going to give you the references again, and we won't, unless you want to particularly go to a document, it may just be necessary for my lord to read them afterwards. But at 1066 of the bundle, and do it myself. You got my learned friend's skeleton argument for the ex parte, and at paragraph 34, he accepted, sit under the heading serious issue to be tried. He said A must demonstrate there's a serious issue to be tried. First, one, in relation to its claims in the Hong Kong proceedings, and two, that any Hong Kong judgment would be enforceable in the DIFC. So he did accept, at least at that stage, that it was about good arguable case. And then at 88 of this skeleton argument, I think for today, he says, well, the argument focuses on a potential defence. And we say, well, precisely, that goes to the merits. So it was incumbent, we say, on him to present the defence. Now, along the way in his analysis of what we need to show for the purposes of today, as he says, I don't understand what an interim injunction is for. We find that a bit of a surprising submission. He says it's just for the purposes of holding the ring. And I think your lordship was slightly interested in that in relation to the Article 15.4 point, because the suggestion was, well, even if there might not be enforcement subsequently, then you can still have an injunction. But that cuts across the whole purpose of any kind of injunction, which is to hold the ring for what? And it's either for a claim that's going to come in this court, or it's for the subsequent enforcement of a claim that's in some other court. It can't have any purpose unless there's some future prospect of the enforcement.
You're pushing on an open door on that aspect. What because time is short.
Yeah.
I really want to focus on how 15.4 may have changed the test from what previously obtained before the 2025 law.
What we say, it hasn't changed the test.
Okay.
It's essentially the best way to rationalise, and of course, because it hasn't been litigated terribly strongly, there's been a decision of the Court of Appeal which says it's all a bit arguable, and a decision of first instance which says there's no jurisdiction at all unless there's assets in the DIFC. But I don't rely on that. No. Your lordship may be aware of it, and that's coming up in front of the Court of Appeal at the beginning of September. But subject to those sorts of points, it's really the Carmen gateway, isn't it? It's Article 15.4. It's saying in terms that the court has jurisdiction to grant orders in support of foreign proceedings. It doesn't affect the way.
Does it have to be? Does it have to be a judgment that is capable which is your point, is capable of enforcement in the
Yes.
DIFC.
Yes, and this sort of all flows from broad idea. So it might just be worth showing you one paragraph from broad idea.
Yes.
And that is at page supplementary.
The broad idea, of
1.8.
course, is dealing with an entirely different statutory environment, that wasn't it? But anyway, let's look at broad idea.
It was, but it's but the point in Carmen is that the enforcement principle, the whole point, the whole reason why you have these sorts of provisions is to preserve the ground for future enforcement of judgments. That's the whole rationale. And so
But the
if you go
question is
to
whether
one,
that's been whether that's been changed.
oh yeah,
Whether,
sure,
yeah.
sure, I understand that, but what would be the point? I mean, we have to ground this in some form of jurisprudence.
Yes. Well, there are two. I agree. I agree. There are two issues, and you actually touched upon it a moment ago. Can this court preserve the situation for the Hong Kong court, or does it have to preserve the situation for the Hong Kong court so that the Hong Kong judgment can be enforced in this court?
Well, it has to be the latter. There has to be the latter. And why do I say that?
Yes.
Because imagine 10 years hence, what have we got? An unenforceable Hong Kong judgment and an order that's maintained in the DIFC over our Aria assets. What's the purpose of that? The entire function of the discretionary remedy of holding the ring is holding the ring pending the final effective relief that will be sought. And it has to be final and effective relief that's sought in relation to the asset over which enforcement is being sought. So just, I mean, the passage that I was going to tell you about from Broad Idea,
yeah,
says paragraph 92 of Broad Idea, and I'm afraid my reference has gone wrong, but it says, in applying for a freezing injunction, the relevance of a cause of action, where there is one, is evidential, in showing that there is a sufficient basis for anticipating that a judgment will be obtained to justify the exercise of the court's powers to freeze assets, against which such a judgment, when obtained, can be enforced. So the justification for the whole exercise is to hold the ring for enforcement, and it has to be in the place where enforcement is taking place. And the reference,
so the injunction has to be in the place where the enforcement is taking place.
Well, where effective enforcement steps will be obtained. So it's slightly different in this case because obviously you've got a situation, I suppose, where we're attempting, you've made an order to hold the ring in relation to assets outside the DIFC. But the function of that is to pave the way for enforcement through the DIFC.
Yes, yes.
And so there's no justification for holding the ring unless there is the future prospect of enforcement through the DIFC.
So it's not good enough to say that we want to help the I think it's the way Mr. Holloway put it, that we're here to help the Hong Kong court because they don't have the jurisdiction that we have to preserve the assets for the purposes of their judgment.
But it's of no help. My point is that it's of no help to the Hong Kong court if that judgment of the Hong Kong court will never have any effect in
coming back to us then to enforce its own judgment.
Yeah. So from the DIFC court's perspective, an unenforceable Hong Kong judgment is just a transcript of some people talking to each other. It has no legal impact that needs recognition or is capable of recognition. That's the point that I'm making. And so you have to look down the line, and this is what Broad Idea tells us. We have to look down the line to determine whether there's going to be an enforceable judgment. Because if there isn't going to be an enforceable judgment, either because it fails on the merits or because it fails at the enforcement stage, then there's no justification for holding the ring in anticipation of that. In other words, it doesn't help Hong Kong.
Yes,
Unless,
yes, unless it's enforceable through this court.
right. So an enforceable through this court requires presence or submission. It's got nothing to do with questions of necessary and proper party. That what's called the exorbitant jurisdiction is not a part of the common law. And we do say, and we've made this clear in our skeleton argument, we do say that when my learned friend, he accepted that this aspect of enforcement was part of the test for good arguable case, and he accepted that he had to tell you that he had to explain to you that it was an enforceable judgment. And then he showed you the memorandum of guidance, which of course says in principle, a money judgment will be enforceable. But what he failed to do was alert you to the fact that there was a very strongly arguable case, we would say unanswerable case, that there would be no enforceable judgment because there's been no presence and no submission, which are the necessary parts of the test under the common law. My learned friend tries to backfill that with the argument that in fact there has been submission. And he argues that by reference to Henry and Prosco and Harris and Taylor, about which there is abundant authority, all of it negative. It has not fared well over the years and was reversed by statute in England and Wales. But before it was, Lord Collins said in an article that it was just a little bit of a wrong turn in the courts. It wasn't the common law. But the point that came from ACC, that's the Arabian construction case, was that the test is whether an objection to jurisdiction has been waived. That's what you have to look at to determine whether there's submission. That's in the authorities at bundle supplementary authority 768 and paragraph 86. And so my learned friend tries to meet that by saying, well, we're not actually objecting to jurisdiction. We're just objecting to the exercise of jurisdiction. So he tries to dance on that pinhead. But that is not true. And if you look at bundle page 1691, you can see that. So this is the description of the application in Mr. Britton's affirmation in support of his application disputing the jurisdiction of the Hong Kong courts. And at 2.2, you'll see what part of the relief that he's seeking on page 1691, a declaration in the circumstances of the case, the court has no jurisdiction or should not exercise any jurisdiction it may have.
Yes, well, it's bog standard.
It's bog standard, but my own friend's point, it seems to be, on an application for service out, you need to satisfy a number of tests. You need to satisfy, firstly, that there's a real issue to be tried on the merits. Secondly, that there's a good arguable case you fit within a gateway. That's what gives you jurisdiction. And then thirdly, that the issues of forum non-conveniens arise. And so what my learned friend is asserting in his skeleton, which is false, is that we're only doing exercises 1 and 3. We're not doing exercise 2, but we are doing exercise 2. And you can see that all the way through this document. In particular, 1692 talks in terms about there being no good arguable case that the claim falls within any of the jurisdictional gateways. Now, the point is, a bit academic in any event, because this is all targeted at jurisdiction application, and contesting jurisdiction cannot by itself turn into a waiver of jurisdiction. And that was the conclusion in Arabian construction. Indeed, in Arabian construction, actually, technically, the conclusion was it's not open to the appellant to run the point, because it all depends on facts, and it wasn't run at first instance, and the facts could have been more different. But in that case, you had a party who was running both jurisdiction and the merits at the same time in the civil law context, because it was a civil law emanating jurisdiction, and that was not submission. So my learned friend mischaracterizes what's going on in Hong Kong, tries to support his position, but B, on any characterization, it's a jurisdiction complaint that's been taken, and therefore could not possibly be called a waiver of a jurisdiction objection. And it's quite impossible to see how he can argue that that is submission, quite apart from my primary position, which is that you shouldn't pay a blind bit of notice to this argument, because it's lobbed into the skeleton argument and presented as an ambush point again, in circumstances where the evidence is not aimed at it. He says, I'm just trying to create legal black holes. That's not true. Every court in the world will ask itself the question, when looking whether to enforce a foreign judgment, did that foreign court have jurisdiction? And they all have different tests for that. And in the DIFC, that test is the common law test. And I don't think it's suggested that test has in fact changed. I don't think I necessarily need to deal with his ancillary points, albeit you did mention one of them, which is that, well, this court should act as an international policeman. And that's a bit of a Hail Mary. And there's another Hail Mary, which is in paragraph 100 of his skeleton, which is he says, well, I might have a Chabra claim here, a non-cause of action defendant claim. The answer to all of those sorts of points is you have to look at the application that's made and consider the test that applies to those applications. I don't think Mr. Justice Jacobs was saying, you know, if there's a whiff of fraud, then I'm going to wade in with both hands, regardless of the law. That's really, in a nutshell, what I was going to say at much greater length on enforcement in the DIFC. And what is left then is full and frank disclosure, which I've left Mr. McPherson about 6 minutes to deal with, but he will do his best. Before we get there, I'm afraid there's also the sort of risk of dissipation, just inconvenience, balance of convenience points. And we've made most of these points before, and you're well aware of them, so I'm not going to labour these points, and you've got our skeleton, but just to highlight 3 points, if I may. The first, this is an extremely stale allegation. The claimant's known about porting, they've known about securitization, they've known about the investment, and they've had complaints for years. And ultimately, we say this money has been invested, and it's gone into the fund has the assets, FDT has shares in that fund, and FDT will get its value back through securitization process or a sale or whatever in due course. If you are concerned about whether or not that might not be the case, we need to focus on what the source of those concerns really are. What is it that is being restrained that you think might happen? Now, if it arises as a result of doubts about the value of the assets, then ultimately it's somewhat self-defeating, because effectively what's being said is, well, the fund doesn't have, Dmcc doesn't have assets, and that's the problem. Well, in those circumstances, what is there being restrained? But if you're comfortable that there is sufficient evidence of assets, sufficient to meet or sufficient to give you comfort that the FDT is protected, then really that's the end of that, it seems to us. Ultimately, one has to ask, what's the point of all of this? What's the point of the proprietary injunction in particular? And what's the effect that it's having? Because ultimately that seems to be the real consequence of all of this. It's just the effect that these orders are having on the respondent in the fund. And so the first point is it's stale. The second point is that it is very rare to impose a freezing order, still less a proprietary order, over a trading group of companies. And that's the ArcelorMittal case and the Polypec case. My learned friend took you to a passage from, I think, the first instance decision on ArcelorMittal, so one of the decisions in ArcelorMittal, but I just wanted to remind you of a passage of Mr. Justice Henderson. It's in the main bundle at 9886, paragraph 200. Yes, paragraph 240. And I'm going to have to ask you to read these in your own time. I apologize for that. It's not terribly satisfactory, but that just is the way. And the other one is the Polypec decision.
Yes.
Which
I'm
is
fairly familiar with these authorities.
Yes, I'm sure you are. But that the reference to that is the supplementary bundle at 2459 around G, and then at 2461 at C to D. And the points that are made there is that these sorts of orders, everybody knows that they make it harder for companies to trade, and they place a black mark against the company as well in the market with banks and so forth. And Mr. Gangel has given a little bit of more information about how this is in practice affecting subsidiaries like Aria Bio. That's at 6617, paragraphs 14 to 15. And ultimately, if the answer is that, as we say it is, that the fund needs to be given the best chance to maximize these assets and give redemptions and all the rest of it, then this is not the best way to go about it. If you are truly trying to protect the value in the fund, making orders which place it at risk and make it harder for the group to trade are not the way to go about it. And the third point is a sort of clean hands type point, which is to say, we do say you're being lied to about the role of Mr. Sun. It's pretty obvious you're not being given the full story in relation to that.
Does it matter?
It does matter, because you've got false evidence, and then you've got the Slack messages of his approval. So you've actually got him approving things, and then you've got the council telling you, well, these things were not approved. So you've actually got lies being told to you to support an application for a freezing order, we would say. The second part, though, is the point about simultaneously making a case in other jurisdictions, which is inconsistent, and which is very often understood to be abusive. Now, obviously, when if this was happening in this court, one or other of those things, or both, would be stayed or struck out as an abuse. Because they're happening in different jurisdictions, the analysis is slightly different, but the essential underpinning policy ought to be the same, we say, which is that you shouldn't be able to say what you like when you want that to, when that's expedient to you, to get a remedy in a foreign court, and then just change the whole thing around and come back in a different place. We don't say there's necessarily a strict issue estoppel or res judicata that arises,
but you say it's abusive.
It's effectively abusive. It's not it's essentially, it's difficult because it's not the abusive process of one court by doing opposite things in the same court, because it's akin to abuse. And then finally, we would ask you to step back. We've obviously got arguments about at the front end, if I can put it like that, which require, we say, a proprietary interest, and if that's successful, then that's the end of it. So, but assume that you're against me on that, and assume you think that there's a problem here. What is this really about? What is it that is the best way to protect against whatever risk it is that your lordship perceives? Now, if it's, for example, that you're concerned what might happen next after a securitization process, that might facilitate value being spirited away, for example, then that seems to us to be the risk that you ought to be focusing on, not blocking up bank accounts and things like that. And at the moment, what's happening, as I understand it, is trading around those accounts. So ultimately, you're relying on Aria DMCC to comply, not voluntarily because it's being told what to do by you, but to comply with those orders. And of course, it will continue to do so. But what that means, what's not happening, for example, other than in relation to bank accounts which have low balances, is it's not a case where there are custodians of assets who are ensuring that those assets don't move around. We're talking about shares in a African mine, for example. So these are in personam orders. So if you
along these lines, I only have jurisdiction in this case to make an order against DMCC. So if I'm satisfied that there is a proprietary interest, let's take two cases. If I'm satisfied that there's a proprietary interest and therefore a tracing claim, the tracing claim would go through DMCC. So I could only make an order against DMCC. It's the fund that's securitizing. I can't stop the fund securitizing because I don't have jurisdiction over the fund. It's a Cayman fund. So anything I can do is only aimed at DMCC.
Well, that's what we'd rather understood, and that was the premise of the discussion I started with you about securitization, because at the moment what's been required is an undertaking that all securitization stop. And I think it was on the footing that partly your lordship wasn't sure who owned what assets.
Correct. And the other issue is it's again, I'm not arguing the case, but it's possibly arguable as evidence of a risk of dissipation, supporting an injunction against DMCC, even though it's the fund that's going to be doing it. Because
yes,
what the argument would run, well, look, they're trying to add extra layers at that end, so that when you trace through DMCC and get to the fund, you've then got problems because then it disappears offshore to a Liechtenstein, Anstalt, or whatever. So it's evidence of it's arguably evidence of dissipation in support of an order against DMCC. There are two orders that could be made against DMCC, and there are two orders currently made against them, both proprietary and freezing. The question is, if the assets have fled completely and been transferred, and I never knew, I was confused. I'm not saying I'm not confused now, but I certainly was confused before as to what had happened to the assets through DMCC. So if there's a freezing, if there's just a, well, first of all, where do I see what the assets of DMCC are? I mentioned before the DMCC accounts, and I was quite interested in the way in which these payments have been treated in the DMCC account. You haven't had time to deal with that. I've looked at, there are two sets of accounts which are for this relevant period.
The audited accounts, yeah. I mean, I'm just very, it wasn't raised against me as one of the things. I'm very hesitant to try to help you find your way through that, because I worry that we'll it's not straightforward. One can't just say,
no, of course it's
look
not.
at the balance here and match it with the balance over there. These match because A, they're audited over different periods, but B, there's quite a lot behind that. I think that the DMCC assets, so there is an asset list where we identify what are the DMCC assets. But I think, I think the point is that we are clear what is and what is not within DMCC, and what is in the fund. And I think what's been of concern to date is
Do you know
that
where the DMCC asset list is?
someone will help me. I did take you to it, I think, previously, but I'll wait for that.
Yeah.
I think the major concern was that you've made an order against DMCC, and obviously Mr. Britton and various other directors, the directors of DMCC, are in charge of that. And they wanted to be sure that action was not being taken, which subsequently it would be said that those individuals and DMCC were in contempt of court.
Okay.
And so the securitization which has been proposed has always been the funds securitization process. And so that's why we took the view that no order of this court could really reach through and prevent that. But knowing that there might be an argument about it, that's why we wrote to the other side and said, this is what we propose. And then that is what triggered the ex parte application and the order that was made. And then
I see all that. And I can understand the sensitivity of people within the reach of this court via perhaps the Attorney General's department in Dubai, who would want to ensure that they weren't jeopardizing themselves in any way. See all of that.
So I think what we would ask for, if we're in this zone where you said either there's a proprietary or a freezing order, whatever it may be, we would ask your lordship just to make absolutely crystal clear what that does and doesn't bite on in terms of activity. And if you're right, and I think you are right, this court can only make orders against DMCC. The fact that you have an officer who is also an officer of the fund doesn't mean that the officer's actions in relation to the fund are actions of DMCC, for example.
Well, I'm not going to express a view on that.
Right, but I mean the problem then is that the effect of an order, just maintaining, for example, the existing position, will leave my clients in a position where they don't understand what they're entitled to do in relation to securitization by the fund.
No, I mean I'm not going to express an opinion. So I don't think it's appropriate at this stage on what an officer of both entities should do and should not do. I think any order, if I were ever minded to make an order, and I'll come back to that in a moment, could only be against DMCC.
Yeah.
And it would be clear. It has to be clear on its face. It's only against DMCC. Because
yes, of course.
The fund is not a party to this application, to this litigation.
Right. I mean, the reality, though, is that the fund has been affected by this, and I think it's largely come out of that ex parte order that was made and the subsequent treatment of it, and the suggestion that we've done something. But I think, you know, it seems to me that any order that your lordship was to make could not, for example, prohibit the fund from undertaking a securitization of its assets in total.
Well, I can't prohibit the fund from doing anything. I have no jurisdiction over it.
All right. I really ought to let Mr. McPherson do his thing. I think he's probably going to be asked to do it quite quickly. But is now a convenient moment for me to hand over to him, or would you like to stop?
No. I mean, I wouldn't take a break for another half an hour anyway. So
very good. Thank you very much. So I'll invite. Yes, he has. He's turned on the screen, and I'll hand over to him. Thank you.
Good afternoon, Your Honour. I'm obviously conscious that I'm already living on borrowed time at the commencement of these submissions, so I will go as quickly as I can. I had planned to speak for 45 minutes, but I can see that I'm going to have to cut my cloth accordingly. Just to summarise, what I'm going to be developing orally are that there are 4 key breaches of the full and frank duty by the claimant. The first relates to the statement about the fund's audited accounts, Miss Lee's untruthful evidence on oath that there were no audited accounts in respect of the fund. The second relates to the the first respondent's authority defence, my learned friend's misrepresentation of the key pleadings and evidence relating to that defence at the ex parte hearing. The third is the claimant's rescission case and the claimant's failure to explain the relevance of that case in the Hong Kong proceedings to the proprietary relief it is seeking. And the fourth is all about the enforcement issue, enforcement of a Hong Kong judgment in DIFC and the misstatement of the principles governing enforcement of such a judgment in DIFC. And we say
I think
individually.
I think the fourth one is by far the weakest. I think it's an issue of law, and there are different views on it.
Well, thank you for that indication, my lord. What I will do is take those each as quickly as I can. What I was proposing to do was address you very briefly on the relevant principles. I absolutely accept your honour has been taken to them, but with a particular focus in mind. And I do just wish to remind you of what we say are the key principles to have in mind, and then to address each complaint briefly, or as briefly as I can, and then finally to deal with the consequences. On the principles, as my learned friend said, it is largely, or they are largely common ground in the sense that both parties accept that it's the Tugashev decision and the principles in that decision which are the law. That's been recognised by the English Court of Appeal. One of the most recent occasions is the Mex Group decision. That's 2235 of the supplemental bundle at paragraph 119. It's obviously been recognised in DIFC in the Globe Investments case. And your lordship, your honour will be very familiar with them. They are at 2444 of the supplemental bundle, if your honour has that.
Yep.
Oh, in fact, sorry, that's a good start. That's not a correct reference. Sorry, it's that, I think that was a previous reference. It's 3105.
Mm-hmm.
And obviously there are 13 principles, but just focusing on those on which we rely. Principle 1, the duty bites on significant factual, legal and procedural aspects of the case. Principle 2, it's an onerous duty. It's described as a high duty and of the first importance to ensure the integrity of the court's process. It relates to both evidence and arguments. And the court needs to rely on a party presenting the case ex parte. And this, I'm quoting now, the court must be able to rely on the party who appears alone to present the argument in a way which is not merely designed to promote its own interests, but in a fair and even-handed manner, drawing attention to evidence and arguments which it can reasonably anticipate the absent party would wish to make. And we say both those things, both evidence and arguments, were matters in which my learned friend failed. Principle 3 is the duty of fair presentation. Just to make the point there that it's not sufficient merely to exhibit numerous documents and then say, well, that was disclosed to the judge. And then moving down to principle 9, that is the proposition that a claimant will be guilty of material non-disclosure. And if they are guilty of material non-disclosure, they will be deprived of any advantage obtained thereby. Principle 10 is the importance of whether a breach is innocent or deliberate. And if it's deliberate, it will only be in exceptional circumstances that immediate discharge is not justified. Just on the difference between innocent breaches and deliberate breaches, I'm not going to take you to it, but there is at at 1293 of the bundle, there's a passage from G, which is from the Brinksmat decision, which was one of the early forerunners of statements of the full and frank duty, and it's principle 6 there, which discusses what is an innocent breach when it's not known to the applicant or the relevance of a fact is not perceived. Clearly, the obverse of that is if a fact is known and its relevance is perceived, then that will be a deliberate breach. Back to Tugashev, principle 11. It's a penal jurisdiction with intended deterrent effect. You don't ask, would the court have made the order anyway? It's not a causation analysis. And then principle 12, you would only exercise your jurisdiction to re-grant the injunction sparingly. Obviously, the overriding consideration is the interests of justice, but a strong case on the merits is never a good excuse for a failure to disclose material facts. One final decision, I'm not going to go to it, it's the Nauf decision. It's at the relevant passage is 2021 of the supplemental authorities or the authorities bundle, and it's paragraph 65 and 66, and this is important for our purposes because it's dealing with the significance of the explanation that's provided for a breach. And effectively what it's saying is it's a high stakes game to play if you don't give any explanation and you effectively maintain your position and seek to justify it and continue to justify it. Because if there is a material non-disclosure, then and there's no explanation, then the court's more likely will be more likely to discharge the order and take the view that it was a deliberate breach. Moving then to the specific examples I'm relying on orally. The first is the audited accounts. Now, the relevant passage in Miss Lee's evidence is at 61 of the main bundle. And your Honour will see there, paragraph 67A, the statement that as to the fund, there are no audited financial statements or periodic unaudited financial statements of the fund in existence. And then it gives the years, and all years between 2019 to 2022. So that's an unequivocal statement of fact. No audited accounts in existence, and that was, as we know, that was false. And we get the falsity from Mr. Britton's evidence in Hong Kong. His second affirmation, paragraph 14. That's the reference for that is 1723. Where he refers to
that predated the statement.
Yes.
Okay.
So that was a statement that he made on the 25th of November 2024. So that's 1720 that's the front sheet of the statement.
So predated Ms. Lee's affirmation.
Ms. Lee's statement.
So you would say not only untrue, but known to be untrue.
Known to be untrue, because the context of this was that these accounts, these audited accounts, were provided via the inspectorship application in the Cayman Islands, which was vacated on terms pursuant to an NDA. That documents were provided, and one of those documents was the audited accounts. And you get that from Mr. Britton's second witness statement, paragraphs 14 to 15. That's 2369 to 2370. And one more reference for your Honour's note is the email providing the audited financial statements to FTT is 1779 to 1807, and that is
sorry, give me the number again.
what 1779 to 1807.
Okay.
And as you know, the Miss Lee had obviously filed the witness statement in support of that application. So Techteryx were clearly aware of everything that was going on in the context of the inspectorship application. And so yes, we say it was an unknowingly false statement. Then in my learned friend's skeleton, this is paragraph 25 of his skeleton for the ex parte. This is 1061.
Yep.
He repeats the statement in reliance on Miss Lee's evidence that the fund has not produced any audited or unaudited financial statements for several consecutive fiscal years. We know from that paragraph that this was central. This proposition that there were no audited accounts was central to the fund as a fraud case, and Your Honour's seen that. But it's paragraph 63 of the pleaded case in Hong Kong. That's 738. The non-disclosure is then identified in the claimant's skeleton for the first return date. That's paragraph 10 of the skeleton, and the reference for that is 2506. There's no explanation there of how the error came to be made. It just says that Miss Lee's statement was incorrect. And then in effect, what happens is in paragraph 11, my learned friend doubles down on the statement and starts making various comments about the account, the history of not filing accounts or delays in filing accounts, and insinuates wholly improperly that there's something untoward about BDO's replacement by Mazars. So in effect saying an error's been made, but we continue to invite the court to disbelieve Mr. Britton's evidence. And then we have how the claimant defends itself now, and that's at paragraph 140 of the skeleton for today, at page 52. What he says is, whilst it was an error, it has to be kept in perspective. And then he says, the real thrust of the allegation still stands. And he alleges that the first respondent is in breach of Section 8.2 of the Cayman Mutual Funds Act, and has been since the 31st of December 2022. Now that paragraph of the skeleton is false on two counts. First, the thrust of the allegation was that the first respondent had never filed audited accounts. That was the key supporting particular of the claimant's case on the fund being a fraud. It was critical that there were no audited accounts at all. And that was false. The second point is that it was also false. It is now also false for him to say that the first respondent is in breach of Section 8.2 of the Cayman Mutual Funds Act. Now, the evidence for that, and I think we do need to go to it, it's at 5268. And this is the OSHA memo, which we've looked at before. And you'll see you'll see there at 3.7 that it's expressed in highly caveated language, to the extent that audited accounts of the fund have only been prepared for the year ending 30th of June 2021, and subject to any extensions having been granted by CIMA, the fund is in breach. So with that very carefully circumscribed wording, on the basis of that, my learned friend has felt fit in his skeleton to advance that accusation of breach, and it's false, because if you go to the Campbell's memorandum at 7355,
I don't want to stop you in any sense, but this is not relevant to the non-disclosure on the ex parte. I mean, these are all sort of Hail Mary points, but
yes, well,
I'm only really concerned with whether or not there was a non-disclosure on the ex parte.
I take that point, Your Honour, and I won't labour them. But the reason for taking you to this is the point about the NAV decision, which I alluded to, which is that the explanation provided, and if you like, the subsequent conduct is relevant. And if you're totally unrepentant, and in effect your approach is, well, an error was made, but it was as good as the truth, I don't resile from it, and I'm going to make a further false statement, then that's an aggravating feature. It's a relevant.
You say this is. I mean, this is a difference of opinion between Ogier and Campbell's, or a difference of emphasis.
I think it goes further than that, Your Honour, because they're not. Ogier are not saying there is a breach. They're saying in particular circumstances there may be a breach, and those circumstances don't arise. So for my learned friend to say in his skeleton, as explained by Ogier, the fund is in breach. Now, that's not a reflection of that evidence. He doesn't caveat it in any way whatsoever.
So you're saying that there are extensions, or?
No, I am. What I'm saying, that's what I was about to go to, which, and I can give you the notes. It's the Campbell is paragraphs 15 to 18, and it's 7355. And what they say is that extensions from CIMA are entirely common, and that CIMA is aware that the audits are outstanding.
But you don't know whether there's been an extension or not.
What Mr. Van Vuren says is that there's been no enforcement action.
Yeah, okay.
And that's paragraph 25.
But what I mean, I do think this is a blind alleyway. So we don't know. We don't know whether an extension has been granted or not. And Ogier, let me speak. Ogier is saying if an extension hasn't been granted, then they're in breach. But I mean, well, okay, you follow your own course.
No, but my lord, you're right. I take the point. All I'm saying is that it's not faithfully reflected in the skeleton, that evidence from Ogier. Okay. The rescission case, Your Honour has been shown this. The short point is that you weren't shown the pleading of this rescission case at the ex parte. You've seen it for your note now. It's 838 to 840. It's paragraphs 44A to 44Q. Your Honour can reread that case. You have been shown it, but essentially what that case is, there are two cases. There's a breach of contract claim at paragraphs 44A to 44.5, and that's alleging that there was a repudiatory breach entitling the claimant to terminate the SAA and relieving it from any payment obligation. And then at paragraphs 44K to P, there's the misrepresentation rescission claim. And the rescission plea is at paragraph 44P, and that's page 840. So there are two claims, one by the claimant to terminate the SAA, the other to rescind it. Now, neither claim is consistent with the claimant acquiring a proprietary interest under the SAA. The termination claim, because the way it's expressed is that the termination is effective because the repudiatory breach is accepted. It is effective from the closing date, which is the date of the transaction. And the rescission claim, because obviously rescission means what it says, parties give back whatever rights or interests they've acquired under the agreement. So ex parte, those passages were not shown to you. In Miss Lee's evidence, this is page 39 now, paragraph 15, she refers to the SAA. She refers to the SAA, she refers to section 2.1, which is the clause pursuant to which the claimant acquires what is said to be the rights, title, and interest to the reserves. And then at 63, she refers to the Hong Kong claim and exhibits the pleadings. And then at 63I, she says, and this is page 59, Techteryx makes claims against Truecoin for breach of the SAA and MSA and misrepresentation. That's what she says. And then she refers to those paragraphs I've just indicated. And what she doesn't say is that what the claimant is seeking as a remedy for the misrepresentation is rescission. And what she certainly doesn't say is that rescission, if granted, would require the claimant to give back the proprietary interests acquired. So that is the misstatement or the omission, and that's the backdrop against which the application was made. An ex parte, Your Honour, I don't know if Your Honour recalls this, but you in fact said to my learned friend that you hadn't analysed in detail the SAA. That's at 1206. There's no reference to the SAA in the reading list. You weren't directed to it. It's obviously one of the exhibits to the Lee affirmation. And you weren't taken to it in the course of the hearing. There was no reference at all to the misrepresentation claim or the rescission claim relating to the SAA. So we say that was a material misstatement, a material omission, because it was clearly highly relevant to the entitlement to proprietary relief, and it cut across that entitlement. Now, one point that was made was that there was nothing in the prayer which pleaded rescission. That was all about termination. That's really the point that's made in my learned friend's skeleton and orally. In fact, there was in the prayer a relevant declaration that was sought, and for your note, it's prayer paragraph 11 on page 844. Declaration that the SAA is at an end as and from the closing date, and that the plaintiff has no obligations or liability thereunder. So that declaration functions both for the contractual claim and the misrepresentation claim, because the remedy is in effect identical. And that is the prayer for rescission is embodied in that declaration, and that wasn't shown to you. There was a point raised yesterday about the fact that these proceedings are stayed. And so I think what was being suggested is they're stayed, so it doesn't matter anyway. They're not relevant. I didn't need, the learned friend was saying, I didn't need to show, Your Honour. It's correct they are stayed because an anti-suit injunction was obtained, which precluded Techteryx from pursuing this claim. And that's at 7175 for your note. But I would just ask you to look at 7183 because that is the judgment granting the anti-suit. What you see there in paragraph, this is the Singapore court that granted the anti-suit because there was an arbitration clause that precluded the matter from proceeding by way of court proceeding in Hong Kong. And you'll see that the way that the Singapore court characterizes the claim is as for termination or rescission of the SAA. And then at 19 makes the point that there's an obvious connection between the claims in the arbitration and the claims in the litigation. And clearly, what all that suggests, we would say, is that the arbitration which does proceed, there's likely to be.
Sorry, where are you? I have got on page 7183.
Yes, that's correct.
Techteryx sought the following relief against TrueCoin in the Hong Kong action, termination or rescission.
Yes, so that's the SAA.
Yes, okay.
Relief. And at 19, what's the point that's being made is that there's a connection between the claims in the arbitration and the claims in the Hong Kong action. And the point there is that obviously the arbitration is proceeding, and now one can anticipate that one of the defences to TrueCoin's claims for payment will be a claim that the SAA should be rescinded, and that's a defence to payment. And in that eventuality, we don't know the status of the arbitration proceedings, but in that eventuality, we'll be in the same situation, notwithstanding that the Hong Kong claim is stayed. So that was another a material matter that this relief could create serious issues for the proprietary claim, and that wasn't raised. Obviously, that wasn't part of my original submissions, but it was raised by my learned friend, so I thought I should deal with the point. So that's what we say about the rescission claim. It doesn't work against the proprietary claim, and that was a matter that was a matter on which Your Honour should have been advised and shown the relevant pleadings. Then the third point is the authority defence. And as briefly as I can, for 4 reasons we say the presentation of this was misleading. The first is that Your Honour wasn't taken to the Hong Kong pleading that Mr. de Lorraine, as the way in which Mr. de Lorraine authorised the payments from FDT to the first respondent, that pleading was left buried in an exhibit, to use the phrase in Tugashev, and the paragraphs which you've seen, a paragraph 44R, where he's appointed as an authorised person by Techteryx by board resolution in light of his experience, and then 44V, which is the plea that he authorised the payments to the first respondent. So that's point 1, the pleadings, you weren't shown the pleadings. But point 2 is that you weren't taken to 2 bits of highly material evidence relevant to the authority defence, and indeed those pieces of evidence were not even exhibited to Miss Lee's statement. And the first piece of evidence was Mr. de Lorraine's affidavit in Hong Kong. And you've been given the reference for those, but it's paragraphs 110 to 117 at 7409 to 74 and that's his evidence that he acted with Techteryx's instructions and approval.
Can you give me
and
that
senior
reference?
management-
Would you give me that reference again, please?
Yes, I'm sorry. It's 7409
7409. Yep.
to 7410. So it's just those 2 pages, and it's paragraphs 110 to 117.
Thank you.
As his evidence there being that the claimant's senior management knew about the investments and approved them. And then there's the Slack messages that obviously quite a bit's been said about already. They weren't exhibited, that they weren't shown, that they demonstrate that Mr. Sun was in control of the Techteryx, that he was, in effect, Techteryx, with his blessing, approved the payments for investment in the fund. So that's the evidence. And then the third point is that at the ex parte hearing, my learned friend said that Mr. de Lorraine was acting on a frolic of his own. And that's at 1225. And that submission is problematic, but because it's inconsistent with the evidence that you weren't shown, the affidavit evidence and the Slack messages, that he was actually acting with the specific sanction of Mr. Sun. And so we do say that the inference to be drawn is that that it was a deliberate decision not to exhibit this evidence, not to show it to Your Honour, but because if you'd been shown the Slack messages, that would have disclosed Mr. Sun's involvement. It would have given the lie to Miss Lee's repeated assertions that she is the beneficial owner. And that
I don't
was the
think
reason.
it doesn't prove that he's the beneficial owner. It proves he seems to exercise some control or some. I'm still a little at sea as to why it's important. But there you go.
Well, we would say it fundamentally undermines the case that they've advanced, the assertion that they've advanced, that it is Miss Lee who is the ultimate beneficial owner rather than Mr. Sun. And the fourth point is a point arising in respect of my learned friend's ex parte skeleton. And that is simply the point, and you've been taken to this, but it's paragraph 75 at 1077. And you'll recall that what is said in the last sentence is that insofar as A, that's Techteryx, purportedly accepted First Digital Trust and Mr. de Lorraine's purported investment of the additional investment sums in the fund, this was induced by fraudulent misrepresentation, including by Truecoin and Mr. de Lorraine. And then there's a reference to Miss Lee's evidence, and that is not what Miss Lee's evidence says.
Sorry,
so
that. Well, sorry, I'm looking at paragraph 75 on one.
It's 75. You're on it. I'm sorry. I'm going too quickly, I think.
No.
It's the last sentence, and we did look at this with Mr. Montague Smith.
Yes, I misrepresented.
It's the reference to Miss Lee's evidence, and you see that there it's 69J to L.
Yes. Sorry, it's my own fault because I thought we were talking about. I thought your fourth point was to do with arguments about jurisdiction.
I'm sorry. This is my fourth point in respect of. This is my last point in respect of authority, and I'm.
So we haven't even got to your fourth point.
No, but I'm not going to trouble you, I don't think, with my fourth point in a way which I will develop in just a moment. But this is the final point on authority, and it's simply that that this statement, which says it's supported by Miss Lee's evidence in paragraph 69J to L, that is not what Miss Lee says. She does not say that the investment was induced by fraudulent misrepresentation in those paragraphs. So that's the misstatement, and the reference for her evidence is page 66. But you can get, Your Honour can go back to that, and that was not corrected at the ex parte hearing. And my learned friend's position is simply that he accepts you weren't shown every underlying document, but he says he didn't need to do that. And we say that he absolutely did. He needed to explain this. He needed to fairly present this issue, including by showing your lordship the underlying documents and evidence. And he didn't even that evidence wasn't even exhibited. My lord, Your Honour, I was going to that finally the point about enforcement of the Hong Kong judgment. I've heard the indication Your Honour gave. What I would say about that is we rely on our written submissions. We've made the points we wish to make. We do say it wasn't fairly presented, but we rely on our written submissions for that, and I won't take up any more time on that. But then just to finish on the consequences, what we say about the consequences is that each of these failures is significant in their own right. Each would justify discharge of the order. At the cumulative effect is that discharge must follow. And we do say, as I've indicated, that there are two aggravating factors. One is that the claimant has doubled down in meeting this case, has not accepted responsibility, and then has defended its position on spurious grounds. And the second point is, and it's an important point, is that we say that the evidence justifies Your Honour finding that these breaches are deliberate. We don't make that allegation lightly, but we do say that the number of breaches, the scale of the breaches, and the surrounding circumstances support that conclusion, as does the claimant's refusal to accept fault for any of them. So, as I said at the outset, in the face of a material breach, the usual response is discharge. In this case, there are numerous serious breaches, deliberate breaches, and we say that they, in their own right, they justify discharging the injunctions, irrespective of the findings Your Honour makes on the other issues.
Thank you very much indeed. Good. Okay, so it is now just before 3:45 Dubai. Let's come back at 5 to 4, please, or 5 to 1, I think, UK time. Thank you.
Thank you.
Thanks.
Well, just before my learned friend says anything, I just wanted to let you know that Mazars have now issued
okay.
the accounts, the long-awaited accounts. So those will, I think, will have been sent to my learned friend, and we will be asking to file those, just so you have the verification. And they're not changed from the previous version, but they are signed off by Mazars. Thank you.
Thank you very much, Mr. Holloway.
Thank you. Well, I'll pick up just where we left off with the outstanding full and frank points, if I may. And the opening comment is that there were, I think, 13 allegations in the application of Mr. Britton's witness statement, and that's been whittled down to 4, and I believe the fourth one wasn't pressed very hard. So the first point is that there was a scattergun approach taken to this. People have pored over the transcript and the documents to look for problems where they don't exist. Nothing's been said about why the other allegations have been withdrawn. But I'll deal with the ones that we just spoke about, and I'll rely also on the points that I made earlier. I believe the day before yesterday on those, on the main thrust of it. First, Ms. Lee's affidavit on the outstanding accounts. I'll be very quick on this, my Lord. She apologised for that inaccuracy in her affidavit. I think it's page 1685, paragraph 18 of her affidavit, and she apologised back in March before the first return date hearing. I apologise for that mistake as well. It's not the case that I'm doubling down on that. We regret that that mistake happened. We're perfectly entitled to make the further submissions about whatever outstanding accounts that remain outstanding, but that was wrong, and we corrected it quickly. And I'll leave that there. I haven't got anything else to say about that, apart from to apologise again. It wasn't deliberate. The second one then to authorisation, and I think I've made some of these points before. Your Honour, we went through this in quite some detail at the ex parte hearing, and I think I was ending the submission at the end of my time 2 days ago, but I did take you to that. It's at page 1220. There was around about 7 pages of the transcript were taken up with that discussion, and we went through FDT's defence that the payments had been authorised, and that was in my skeleton for the ex parte hearing. That's page 1076, 3 or 4 paragraphs on that. It was always in there as one of the issues that was going to be fought apart in the case. If I can just run through what we did talk about at the ex parte hearing, because there's a little bit of a sort of confusion here, because what I was emphasising at the hearing was that there's no evidence that Mr. de Lorraine had authority to authorise the DMCC payments as opposed to investments in the fund. That was the focus of my submissions. But it's not that I didn't show Your Excellency all the documents that were put in play. So for example, if we follow this discussion from the top of page 23 of the transcript, so that will be 1220. But 1223, sorry, 1220 indeed is where it started. And we looked at the board resolution, which is the key document that my learned friend was talking about yesterday. I made submissions about that. At the top of page 23, a couple of pages, sorry, page 23 is the transcript, so that will be 1218. This is where it begins, 1218. And I say the defence that is being run is that we authorised the payments, and Your Honour, you then said, well, let's talk about the share certificates, and for the rest of that page, and then I come back to the issue of authorisation on the next page, 1219. So we talked about diverted into share certificates, and then I came back to this point. The document that is relied on for authorisation is the board resolution, and we talk about that. And then we get to the central point that I made at page 1225, at the bottom of that page and at the top of 1226. we look at Mr. Britton's affidavits, and we looked at his affidavit and what he said about authorization at that time, and I'm quoting from him there. We're looking through his affidavit, and he's saying it was authorized, and so on. So we're looking at what he said in his affidavit at that point.
Sorry, what page are we on? The transcript are we on?
1225 at the bottom of that page. And if we sort of just scroll up a little bit from the very bottom of the page, at this point we're running through Mr. Britton's affidavit. If we go back a little bit. So it certainly does. Yeah, sorry, even if we go back slightly further, 1224, I suppose. I do beg your pardon. We are running through his affidavit paragraph by paragraph at this point. And at 1225 at the bottom, I'm talking about, or on 1225 in the middle, I'm saying the board resolution doesn't authorize anyone to go off on a frolic of their own and make investments into Mr. Britton's wife's company. And that's the frolic of their own part that my learned friend's talking about. But it's talking about the diversion of the monies into the DMCC account, which was the focus of what we were discussing at the ex parte hearing. And then just slightly further down, towards the end of paragraph 25, 1225, page 1225. Sorry, it's been a long day. Scroll up a bit more. We're talking about the comments in his affidavit about using Aria sometimes to mean the fund and sometimes to mean Aria. And then we're saying that what Mr. Britton's saying, that we don't have a proprietary interest in the fund, that we didn't authorize the investments. And we're saying that we didn't authorize the investments, certainly not into the DMCC company. And then scrolling a little bit down, you come to a conclusion. I may have got my page references wrong here. There is a quote from you saying those are all eminently triable issues. I've lost the page and I've been taking you to the wrong page, I believe. It's 1239. I've got the pages wrong. Yes. Okay, so I've got my chronology a bit wrong there. If we scroll up from there, this is going through Mr. Britton's affidavit, and we say at the bottom of page 43 or page 1238. A bit more, please. Other way. I'm talking about the rest of his affidavit. The first affidavit repeats all the defences by FDT, and Your Excellency says yes. Then going over the page, he takes the jurisdiction point that Your Honour has picked up with Cayman Islands. That's paragraph 34 and 35. And then at 52 and 53, he says they only dealt with FDT. And then you say they could have produced a share certificate. And then I say he repeats the argument that we had no interest in the funds. We've gone through that. There was no breach of trust, that we authorised everything. And we're looking at his affidavit paragraph by paragraph. I put to you exactly what he was saying. And then my simple submission is that that is a complicated issue. But whatever way you look at it, no one authorised Mr. De Lorraine to invest the monies in the DMCC company, and that's the quotation I gave you back before. No one gave no one authorised him to go off on a frolic of his own and invest in the DMCC company. Now that's really what my submission was at the ex-parte hearing. But we did go through what the other position was. We did talk about the board resolution, we discussed it, and then your conclusion was those are all eminently triable issues. So my submission is we put the first respondent's case to you, and we said that whatever they were saying about the board resolution did not explain or justify the DMCC payments. And what my learned friends are trying to do is to conflate that and say that I'm talking about the investments overall. And I'll emphasise that nothing in Mr. De Lorraine's evidence or in any pleadings says that the diversion into the DMCC was directly authorised by Mr. De Lorraine. It's all references to investments in the fund, not to DMCC. And that's, that includes Mr. De Lorraine's statement. So my learned friend says we should have put Mr. De Lorraine's affidavit before you, Your Excellency. If I can turn that up, his evidence in Hong Kong, it's at 7409. Paragraph 114. This is the part that my learned friend criticises me for not putting in, but that doesn't say anything, that paragraph, about DMCC. We're talking about investments in the fund here. My point at the ex-parte hearings, regardless of the board resolution, there was no authorisation to invest in Mr. Britain's wife company, and that point remains. There's nothing in Mr. De Lorraine's evidence that said that he did authorise that. He's talking about authorising investments in the fund, and that's not what we're talking about. The Slack messages that my learned friend took you to don't mention DMCC at all. Justin Sun doesn't mention it. Nobody else mentions it at all. So your conclusion, Your Honour, was that you'd seen the board resolution, you'd seen the arguments, but it was a tribal issue. Now, if they're telling you that the board resolution authorised the investment, and Mr. De Lorraine is saying that in Hong Kong, and if there are a million different people saying it, it still doesn't reach the point that it's not talking about the DMCC company, and that is the nub, or one of the nubs of the pleaded case against Aria. There was no authorisation to invest in the DMCC company. That's the pleaded case against them, and we've been through that pleading. So my submission is you had the defence there. You were aware that it was going to revolve around things like the board resolution and questions of authorisation, and you had my case on it, which is none of that mentions DMCC, and nothing that you've been shown yesterday, today, says anything different. So that's what I'd say about that. If we put Mr. Britain's affidavit before you, and we went through it with you, we have shown you what he's saying on that point at the ex-parte hearing, and that goes for a lot of these allegations that were made originally. So I'll leave it there. I don't mean to sort of downplay the allegation, but that's my answer to it. And then the rescission point, the alleged inconsistency between the two claims. Your Honour, so the point is there's supposedly an inconsistency between the two claims, but we say there isn't, because we are not seeking rescission ab initio of the SAA. We've never sought that, and we never will seek it. And if the word rescission appears somewhere in a pleading, that does not mean that we are asking any court or tribunal to declare that agreement void ab initio, so that the parties have to restore themselves to the original position before the agreements were made. That's just simply not the case. Now I'll take you to that. I'll look at the pleading again. The statement of claim is, I think, page 810, around there. I'll start. This is all in paragraph 44, and my learned friend's gone over it. But 44F, what we're seeking there is first a declaration that the SAA is terminated. Then 44P, the word rescission is there. What we're saying is, because of the allegations of fraud made, we are entitled to rescind those contracts. But what we're actually seeking as relief, and my learned friend did take you to that, is at page 815, and he took you to the paragraph 11. It's a declaration that the SAA is at an end as and from the closing date, and the plaintiff has no obligations or liability as and from such date. That is not a claim for rescission ab initio and restitution. It's a claim for a declaration that that contract is of no force going forward, and you don't see any claim for restitution there. What you claim, see at paragraph 13 of the relief, you've got.
Sorry, but I mean, how is it at an end as and from the closing date? So
Yes.
What's the closing date?
I believe it's the date on which the reserves were transferred, or the date on which the contract came into effect.
Yes, so what it's saying is a declaration that the SAA was at an end from the date in which it came into effect. Well, isn't that right?
From the date, from birth.
As and from the date, the closing date. Well, isn't that effectively rescission ab initio?
No, it's a looking forward declaration, not a looking backward one. That there is no claim here that we wish to give our rights back to Truecoin, and that wouldn't be possible anyway.
But I don't understand what the declaration is then. If the declaration is the closing date, I assume is the execution of the transaction, the date at which the transaction, the SAA, closed. So if it's of no effect and at an end, if it's at an end from the date on which it closed, then that means it never had any effect.
No, it means it had any effect, and after that it had no further effect, in the sense that the parties may have had liabilities ongoing to each other, and we are saying we don't have any more obligations to pay you anything. But what we're not saying is we're going to give you back everything and you have to give us back everything. And then you'll see, to back that up, the damages claim at paragraph 15 is effectively damages in lieu of rescission, I believe, because it would not be possible to grant rescission of that contract. It is not sought. I'm instructed that it is not sought and was not sought, rescission ab initio. And that phrase, the word rescission, can be used in more than one sense, but that's not a restitutionary claim. And those are my instructions, and it would make no sense if it were otherwise, because we're not advancing a claim to restore the parties to their original position under that, nor could it be possible to do so. Now, to the extent that that is legally debatable, that in my submission, if we're not pursuing a claim like that, then it ends there, and that's the way the case has been put. Also, I think my learned friend referred to the Singapore court, but what he was quoting from was the judge's summary of Truecoin's summary of the case. There wasn't really any, that wasn't a decision that was making any substantive findings about what people were or weren't claiming. It just wasn't relevant at the time. They were talking about whether an arbitration clause was binding or not. So that's the position. You did have that in Mr. Britton's affidavit. In Hong Kong, it was a throwaway paragraph, just saying that there was a contradiction or an inconsistency. We don't see that, but that's. And we're not advancing a claim on that basis. I'm instructed.
Okay.
And I think I've made my submissions on the Hong Kong point before. I'm a learned friend didn't press it further, so I'll not say anything more about that. Unless Your Honour wants me to.
No.
So I'll move on to reply, substantively reply, and my learned friend did take quite a bit longer than I thought he would. I hope I'll get a reasonable shot at replying to some of these points, because he's made quite a few of them. I'm just thinking of time, but I will need at least an hour, probably a bit more. My learned friend said he would take 45 minutes. I would hope he'd curtail that in light of the fact that they've overrun quite a bit. But I'm in Your Honour's hands as to how you want to manage this. It is late in the day. I understand that.
Yes, I mean it's. I'm happy to sit as long as it takes. Frankly, whether I take as much in as I would have done earlier in the day, I don't know. But no, I mean I'm here and I'm ready to listen to the parties. Certainly.
Very grateful.
And Mr. Montague Smith, if I do continue to sit late, does that convenient for you?
Not at all, but thank you for asking.
Yes. Sorry, not at all convenient, or not at all, it's no problem.
I thought you said it does that inconvenience you.
Oh, sorry.
It doesn't.
No.
So I think I might be suffering from the things that you suspected you might suffer from.
Okay. Good. Well, Mr. Holloway, you have your hour, and then Mr. Montague Smith may have his 45 minutes. We may take a bit of a break at some point, so just stretch legs and things. Okay, Mr. Holloway, over to you.
Yes. So I think the first point I'm going to make is about the valuations, and I think just the first thing to say is it really isn't fair to say that what I told you was in any way an ambush. And the reason for that's true is that the evidence on this mining valuation came in from FTI in rejoinder evidence not that long ago. I analysed it as soon as I could, and I put the points in my skeleton as soon as I could, but it's not. I couldn't have done it any earlier because I didn't have the evidence any earlier. But more importantly, we really do have to look at the Pinewood documents again, because there really is a serious error there in the way that Muller and Friend presented that evidence. There is a massive error in valuation to the tune of a factor of 1,000, and that is apparent from the documents. So I'm going to have to turn you, I did point this out, but I'm going to have to go back to it and look at page 5666. So what you'll see, this is the evidence of title that Aria rely on, and this is the resolution which backs up their claim. And the issue price of the shares is perfectly clear on this document. There's really no room for argument about it, because it says the whole point of the memorandum is to issue Class A ordinary shares, Class B and Class C shares. And the Class B shares, which are being issued to them, are valued at 0.001 euro per share. That is the issue price. That is the price at which they were issued. And there can be no room for argument about that. That's the issue price. So if they bought 225 million of those shares, they would have had to invest 225,000 euro. That's point number one. Point number two is that they are redeemable 3 points down anytime from 5 years onward at the election of the issuer. That's the basis on which these shares have been issued. And then point three, just below that, they are redeemable by the issuer at the original issue price, which is 0.001 euro per share. That's what they've got.
Can I just step back? Where does all of this take me?
Well, really,
I mean, as I said to Mr. Montague-Smith, it is unarguable that I only have jurisdiction to make any orders against DMCC. I can't make any orders against the fund. So if the fund is holding assets which are overvalued, the only way this can go is for you to say, well, then the valuation of the fund is inflated, and we don't know where the money went from DMCC. I mean, that's what this goes to, is it?
it goes to two things. Of course, that is a very important point. It is also evidence of the fraud that we have pleaded, in that the fund didn't invest in genuine assets at all, and that the monies didn't.
But there's no suggestion that this isn't a genuine asset, is there? I mean, you use the word ghost assets, but the documentation, particularly with the EY valuation and so on, it all looks like a genuine investment. It may be an investment for a lot less than it is said to be.
What of substance has become of these $456 million?
Well, that's your point, isn't it? Your point is that this is that in order to account for what's become of the money, the investments said ultimately to have been purchased with it have been inflated to make a total, to show that the money has been spent properly.
Yes.
But then you come up against the fact that there are audited accounts.
Well, yeah, but the audited accounts don't value these assets or rely on these valuations or rely on what they're told. I mean, we can come back to the audited accounts. We haven't seen the final versions yet, but we are looking at what happened with this money. And what we've seen is these kinds of assets being acquired in 2024, 2025, and what's being said is we've got this huge fund, and actually 90% of it is tied up in these 7 assets or even 4 assets, the vast majority of them, and you look at it, and what is it? It is a $225,000 investment in a mining project, which would take 20 or 30 years to realise, would cost 30 odd million to get going, and on which the issuer has the right to eject you for 225,000 after 5 years. So they've got nothing.
Well, it may or may not be a sensible investment. That's a different issue. But isn't it? I mean, looking at it in common sense, that you've got this influx of money into the fund, and the fund then goes off because it's feeling flush and starts investing money in assets. The assets may be questionable. They may be, they may have made an utter mistake in investing.
That's the point. That this investment was made by the fund in 2024. The monies weren't paid into the fund; they were paid into DMCC, and we don't know where they've gone after that. What they said is, well, you now have shares in the fund, and that's what you get for your money years later. But actually, by that point, the money is gone, and the shares in the fund are backed up by nothing but paper or loans from people we know nothing about, or assets that actually are worth 1,000 times less than what they say. So let's say if they say the fund is worth $500 million, and that's enough to pay back our money. If each of those assets, most of them look like they're worth, if it's overvalued by 1,000, which the 2 mining ones look like they are, then we've got a couple of $100,000 in the bank for our investment, and where has the rest of it gone? It's gone. We've got a piece of paper after the money was spent by other entities. So that's, I mean, I must just turn back to the valuation report just to show that share, it's 769. You see, it's valued at 225 million shares at €1 per issue price. That's not right. It wasn't €1 per issue price. And then it says redeemable after 5 years at the election of the holder. That's just not what they have. I mean, and it's all very well for FTI to say, well, we've seen title and we've seen a valuation report. I mean, it didn't. Be honest, we don't need an expert to spot that there's something seriously wrong with that piece of paper, or there's something seriously wrong with the share register. And this is another reason why these things are important, because the evidence that you're being given is just not reliable. It is not reliable at all. And just to complete that, 2 more pieces of evidence on this. The share register 8788. It's 787. 8786, I beg your pardon.
So, okay, where are we going?
8786. This is the share register. And this shows Aria's share. It was bought at 0.001 euro, not €1. That's the issue value, that's the par value. And you can pay someone to value a mining project under a DCF formula all you like, but what they're valuing is the share. And I've shown you that the valuation that they've done is completely wrong. It's not just wrong, it's seriously incredible. Then you also have AIM notice, which I took you to on day 2, I think, or on day 1, page 5144. Yes, I mean, I'm sorry, we did go through this, but it's important to look at it again. It's the 4th paragraph on paragraph 3, section 3. That mining project was taken on for nil consideration, nil cash being received, it says. Yes, so yeah, you see it on 5138 as well.
Sorry, just bear with me 1 second. Where I see nil consideration there.
It's probably, yes, it's nil cash, it says there, being received at the end.
Where am I looking?
The 4th paragraph down starts KMCL, and then I think just at the end of that, 3 lines
Nil
up.
cash, I've got.
But even clearer, I think 5138. At the very end.
Group disposed of Tybo for £1 Okay.
So I've given you, I've went through these key assets on day 1, but they all tell the same story. You're being told that something that is bought for either 0 or a couple of $100,000 can be seriously valued in the hundreds of millions of dollars, and that is simply incredible. It's beyond incredible. It's being cooked up. These assets, they're not reliable at all. You can see that with the large assets. And sorry, the other point is that FTI have really not engaged with this at all. What they say is, well, I'm not an expert on mining valuations. I've seen a valuation report. So I'm content that something exists, it's been valued, and so on. But and that may well be the approach that has been fed into the accounts when they're being prepared, but it's not the truth. It's not correct, and it is quite obviously not correct. So that you cannot just simply ignore that. It is evidence of fraud, I say. it is also evidence that where the money didn't go where it was supposed to go, and didn't end up where they say it has ended up. And I've made more granular points in the skeleton. I tried to go through it on day one, but I realised it's a big information overload. But we only got these documents in the FGI report a couple of weeks ago. We're doing our best to get to the bottom of it. You can see glaring inconsistencies in the big assets and in the small assets. So it's we say that's a pattern. I mean, I can go to each one of them again, but the carbon resilience one, you saw the EY report. That wasn't prepared for Aria. It was prepared for somebody else. It said funded by Aria. It was done for BVOS, who we don't know who that is, and actually even FTI say on that huge asset, what they say is they don't have it at the minute, but they will have it pending some kind of approvals, and we've seen that the approvals don't have Aria's name on them, so it's a pretty speculative. The documentation is pretty opaque. The valuation is also heavily caveated. So what we've got is somebody saying, well, I've seen there is an asset, I've seen there is a valuation, there is a connection, therefore everything's okay. But that's it. And FTI have only looked at 3 of them, and they haven't really looked very hard. The rest of it, the Indonesian mine, we've gone through it. What is it? It is an option that was purchased for $500,000. It's now worth, that option is worth 247 million. They're not valuing the thing that is in Aria's hands, if anything. And it certainly doesn't tell you where the money's gone. Now, just before I leave that transcript of that phone call back in June 2023, I appreciate it was difficult to go through, but I do urge Your Excellency at an appropriate time to try and read that, because it makes absolutely clear that this has been what's been going on since 2023. It is, where has the money gone? And Mr. Britton saying, well, I'm going to securitize some assets and we'll get some sort of cash flow. And then they say, well, where did you get the assets? And he says, well, I paid a couple of £100,000 for it, but it might be worth $1 billion. And they say, well, that accounts for a minuscule fraction of this money. Where did the rest of it go? And we just don't have any answers 3 years later. That's the point of your order, Your Honour. The only way we're going to get this is through tracing through the orders that you've made, that they tell us the ultimate beneficiary of the monies, and it isn't these assets. So that's what I'd say about that. But look at the evidence on the assets clearly, and it just evaporates. And there's all kinds of significance for that in this case.
So you say the benefit of an order is a freezing or proprietary order is meant to hold the ring until the Hong Kong courts give judgment. You say that a benefit of the order is that it will help you discover where the money has gone.
Yes.
Does it matter whether it's a proprietary order or an ordinary freezing order with discovery obligations?
Well, it does, in the sense that this is a proprietary claim. It's a tracing claim. We're not just looking at DMCC assets here. We're looking at where the fruits of that money went, because that's what we're trying to get at. And also, I'll come back to securitization. but that's that is the risk here, that these assets, such as they are, wherever they are, get turned into pieces of paper, and we don't know who's behind that piece of paper. So it's.
But I can't stop the fund securitizing any of its assets.
Well, what you can do is what you did do, which is to say quite clearly that Mr. Britton, the key man in the fund and in the DMC, would be in contempt of court if he proceeded with that venture. I agree the fund is outside your jurisdiction, but I believe you've made it clear, and rightly so, that in the context, if this order is maintained, that the fund were to dissipate assets, that Mr. Britton were to be involved in that might amount to contempt of court. But I agree that this is I mean, I think we find ourselves in each one of these three return date hearings debating securitization, and the fund, my learned friend, Mr. Britton, they seem absolutely desperate to do this, despite the fact that apparently there are no other investors apart from Legacy and us in there, and we don't want that, because we believe that we're going to, that will make it more difficult to get at the assets and what happened. But no, I take what you've said, Your Honour. I think we got an ex-party order on that for good reason, and I can take you to that, to why we got it. But it was never challenged. You know, no one came back and said you've got to set that order aside. It was.
Well, Mr. Montague-Smith made some fairly strenuous submissions today about it. So I have to think whether it.
Let's look at that, because I think the best place that you can see how that came about is in the application notice itself. If you want to take a quick look at that, it's at 5927. And yeah, sorry, 5926. We can start with. What actually happened in the lead up to that order was not that Aria wrote to us and asked, you know, for permission to do this. What actually happened was that Mr. Britton announced in his affidavit that he was going to go ahead with the securitization process, and he described the process that was going to happen in that affidavit. And I think I better take you to that, actually. It's 4056. And this probably will give you an idea of the concern. Really just para 109 was the one that prompted the application. So the process was going to work along the line of the asset would be transferred, sold to a Luxembourg entity.
Excuse me, sorry. Yes, okay.
And what the fund would get in return are notes. And so that would leave instead of a tangible asset of whatever value, we would have another piece of paper from a unknown Luxembourg entity, of which whatever security that would provide is completely unknown. So that's what prompted the application, and we wrote to them saying, we don't think you can do that. Tell us more about this process. And they refused to do it. And then we went ex parte to get the order. And all that is in the application notice in page 5927. The application notice itself sets out the chronology of what happened. We still don't really know what is being proposed, but what we did see was that it was really Mr. Britton who was driving it. All the correspondence was in his name, and so on. And Your Honour, you observed that might amount to contempt of court if he were to be seen to be dissipating assets. I'm not asking you to go any further than the position as it is. That's the concern on that.
And it was also the case, wasn't it, if I recollect, that DMCC was, what did they call it? Sponsor, issuer?
It was, yes, now you're testing me, but they were, we'll have to go to those documents and give you that reference. I don't have that at my fingertips, but yes. Let's see if I can turn that up. It will be exhibited to his application.
Yes.
76. Oh, sorry. There's reference to it in your reasons, which may be helpful. It's page 1176. 74.1 at the bottom. So, 74.1. Yes, the initiator.
Initiator.
But every time we have come back to court, they've not applied to set that order aside, but they have tried to find a way to get Your Excellency to say that this is all okay, and you haven't. I believe you shouldn't. I mean, whether you want to say anything more one way or the other, that's for Your Excellency. It probably will be interesting to see if that undertaking not to do it will continue beyond today. So, okay, I'll move on to the agreement and proprietary interest point, if I may. And I think the first thing I want to turn to is the idea of, I mean, we've gone through the text of the agreements. I don't want to label them, but I do want to come back to the idea of segregation.
But it all, I mean, Mr. Montague Smith basically says it all turns on clause 6 of the escrow agreement.
Yes.
And it does say pretty clearly. Let's have a look at it, shall we?
It is roundabout 529.
Sorry, my computer's being slightly slow again.
Surprised my computer hasn't died actually after it's. So 533 is clause 6. Yes.
Yeah, you have to bear with me a second. I'm sorry. It seems to have a big not responding. I don't know. Oh, there we go. Now responding. Okay, all right. 2 secs. 6. Yeah, okay, have it. Page 533.
Right. So, I mean, this is, it's not something we've ever shied away from. There is a tension between the second sentence in clause 6, and we say the rest of the agreements construed as a whole.
Well, he said there isn't a tension because the client services agreement it is an umbrella agreement, and the custody agreement does not deal with money held for investment purposes. And there's some force in that, isn't there? Because this agreement specifically refers to at 4D the sorry, there you go. Is it 4D? Yes, investment of escrow amount. So it rather looks like it's money under this agreement and not under the custody agreement that it is for onward investment.
Well, the agreements put together as a whole, and they say so in terms. So we've gone through that and go back to it, but go right up to the top of the agreement. It actually says 529 clause 1, I think.
Yes.
The client agreement, custody agreement prevail. This escrow agreement is subject to the terms and conditions in the client custody agreement.
Let's just have a look. The terms and conditions set forth in the escrow agreement are in addition to those set forth in the client and custody agreement, and that the former, which is the escrow agreement, which is this agreement, shall prevail for matters specifically dealt with in this escrow services agreement.
Yes.
So this is the governing agreement in relation to matters expressly dealt with. One matter expressly dealt with is investment of the escrow amount.
Well, it is not governing in the sense that if there's something extra in there that is not mentioned in the other two agreements, then you follow this one. But it is subject to and to be read with the other two, in which case.
But that doesn't answer the question that 4D specifically directed towards investment. And specifically directed towards the investment proposal.
Well, they have authority subject to the investment proposal, which comes from us, and it's also subject to all the other agreements about the receipt of property and who owns it in the custody services agreement. There is, I should also say, he did look at the entire agreement clause 14, but that talks about the account. It doesn't talk about the amount, etc. But you cannot, you have to read this contract in conjunction with the others. And the important question is how the money is held. Is it, as the cases say, are we giving it to them to use with their own money and to do what they want with? Or are we telling them you've got to segregate this money and hold it for us in accordance with our directions? And that is the test about whether a trustee or fiduciary relationship opens up. And we say that you've got that written all the way through all of the agreements. And clause 6, you can't interpret it, the second clause of it, to do violence to all the other bits about receiving property as fiduciary for us to be held in accordance with our instructions, marked so that it is not their property. I've gone through all those clauses with you and go through them again, but let's go back then to where we end up with clause 6. You've got to make sense of it in the context of the whole package. Were they given this money to do what they liked with, to mix it with their own money, or were they given it to hold in separate custody accounts and use in accordance with our directions or instructions on behalf of us? And it's very clear from all of the provisions that it is the latter.
Well, you've got clause 2 of this. So FDT shall establish an account for the funds received from purchasers. So that's the escrow account.
Yes, and that's perfectly consistent with all the segregation provisions in the other agreements. So there's no conflict there at all. We say that those do apply.
So then we go to 3A.
Yes.
During the escrow period, the parties agree, subject to terms of the escrow agreement, FDT will act as agent of the client for receipt of the funds from purchaser. Upon receipt of the funds, FDT will hold the funds as fiduciary of the client to the order of the client, subject to 4F.
Yes.
Okay, then 4F is the exception for a triggering event which gives rise to resulting trust. So we've got a separate account.
Yes.
And we've got an agency agreement. But so far, there's nothing that indicates a trust. If we go to 6, FDT shall hold and manage the escrow amount. I wonder if escrow amount as a fiduciary for the benefit of the client or its agent. To the avoidance of that, the client shall have no proprietary rights in the escrow amount and shall hold the escrow amount exclusively for the benefit of the holders. So it's providing that Techteryx holds the escrow amount for the benefit of the holders. That does seem to suggest that there is a trust relationship as between Techteryx and the holder.
Well, what we say is that,
which is contrary to your case.
well, if putting that second sentence aside, what we say is it couldn't be clearer. They are holding the funds for us as our fiduciary. The word trustee is written at the top of the agreement. They have to segregate the money. They're not allowed to do certain things with it without our consent. All of that is written through the agreement. It is not to be made available to them or their creditors, etc. And then what we've got to do then is make sense of that second sentence. And on our view, the only way that it makes sense is either they are our trustee, which is our primary case, based on all of those clauses, or they are our trustee or fiduciary, but we hold on behalf of the holders. What it just cannot mean is what my learned friend says it means, which is that they hold the money for their own account. We've just given them that money, and they can do whatever they like with it and treat it as their own money. It just can't mean that. Now, there is a tension in between 1 and 2, but if you are going to give effect to the second clause, the only way to do it, the best way to do it, is not to sort of throw aside the whole context and say, FDT just get the money and we've given it to them, because the second sentence doesn't even say that. It doesn't say that they will hold the money on behalf of the holders. It says we will. So it just doesn't, their construction does violence to the reality, to the language of all the agreements, and even to the second sentence of clause 6 itself. Now, if you're not prepared to say that it's arguable that we have a proprietary fiduciary interest under these agreements, strictly under the letter of them, because of clause 6, either by way of primary trust or the sub-trust analysis, it doesn't really matter, because on an objective construction, They plainly are fiduciary. They're plainly holding the monies on our account. They're paid into separate custody accounts. That's written all through the documents. It was never the intention that they were given that money to do with as they please, and to mix it with their own money. That's the test. And whatever way you look at it, they owe those fiduciary obligations, create proprietary remedies, whether it's trust, subtrust, quis trust, fiduciary. The result is the same. And I gave you a line of cases on that, but I can also tell you the reality. If you look at some of the documents here, 5508, this is the document that my learned friend took me to yesterday to say that it wasn't a custody account, but it clearly says custody number. There is a custody account, but that's probably the high point of his case. There's so many other documents. Look at 4078. This is an Aria, this is an Aria document confirming a subscription marked custody account 1004240. If you just, it's littered throughout 4081. The same. All of the documents have this. Most of them have this language or that number. Some of them have true coin, as you've seen. But there's just the reality is they were using custody account. They weren't mixing this with their own money. They couldn't do that. And then finally, we have the trust ordinance. And the reference to that because it's 3631 in the supplementary bundle. This is section 89 of the trustee ordinance. And bear in mind, this is a trust company. Now, I just can't accept my learned friend's construction of this that he put yesterday. It is pretty clear. All monies, property and securities held by any trust company in a fiduciary capacity shall be segregated. They're obliged to do that by law. And then at the end, it says the investments shall be designated so that the trusts to which the investments belong can be readily identified at any time. Oh, sorry, Your Excellency, you're on mute.
Yes, it muted for some reason. Actually, you remind me of a point that I wanted to raise with both of you. We've addressed all of this under English law. This is a bit of Hong Kong statute, and the only bit. But so, is it agreed between the parties that I have to deal with this case, that I am able to deal with this case on English law?
Well, it's obvious that Hong Kong is a common law jurisdiction, but I think we've got to be a bit careful about assuming that we know the final answer to these questions.
Well, neither side, neither you nor the other side have addressed me on Hong Kong law at all. The fiction, of course, of English law is you then assume that English law is the same, but I'm not sitting in England. I'm sitting in the DIFC. Do I assume that, in fact, Hong Kong law is the same as DIFC law?
Well, I mean, I have referred you to one.
It's one case. There's one case.
And that on fiduciary duties does seem to say that not only is Hong Kong law similar, but it's often referred to by.
So I mean, what I would like, frankly, what I would like is an assurance from both parties that I can deal with this case on the basis that there is no significant difference for the purposes of this case between Hong Kong and English law. Otherwise, I'm totally lost.
Well, if it's on the basis that we're doing this on an interlocutory basis,
Yes.
to the extent of trying to decide whether there's a serious issue to be tried under Hong Kong law, I don't see any marked difference between the two laws, so I wouldn't object to that. But I would say if to the extent that you're not clear, then it is a matter that the Hong Kong court needs to decide at trial if these are very finely.
Well, no, of course, the Hong Kong court has to decide at trial. But you know, I'm getting submissions about the meaning of documents and about how proprietary interests work or don't work under English law, and it may well be that Hong Kong law is identical and follows the English law, but I would just like some comfort from the parties that both sides' submissions can be taken by me in writing my judgment for the purposes of this application, that Hong Kong law can be taken to be similar or identical to English law on these topics.
Similar, I would say, for sure. Yes.
Okay.
Then 2 points. One of the points my learned friend raised, that if they're just a fiduciary, then he refers to Bousted, page 3263. And I think the point being made is that if it's a fiduciary duty, a fiduciary agent, then I think the point being made is that a proprietary interest would only arise from profits made.
Yes. What's the reference? Give me the paper.
It's Bousted, page 3263 of the bundle.
Yeah.
And then I think over the page he relies on the very last sentence of paragraph 60439. Sorry.
Sorry, this is forgive me, wrong bundle. This is
right, supplementary bundle, I believe.
Yes. Yeah, got it.
Yes, so he relies on a couple of lines at the very end of that passage, and 3265. And says it's generally accepted that it would be inappropriate for a breach of duty to create proprietary rights and assets that have not been derived from the breach. And I think what's being said there is that you can have a proprietary interest for breach of fiduciary duty over profits, but not over assets themselves, which were given to you.
But if the agent, well, it depends on the terms upon which the agent is holding the assets, doesn't it?
Yes.
If a trustee misuses trust property and makes a profit, then there is a proprietary interest under the profit rule in the profit, but also because they're trust assets, the trust assets themselves can be traced. If, on the other hand, the agent is not holding the assets, let's say it's a commercial agent, and it's not, and the agent is not holding the assets on trust, but nevertheless makes a profit from the use of those assets, then the profit rule says there's a constructive trust over the profit, but not over the assets. In other words, it doesn't create a trust where none existed before. The profit rule does not create a trust.
That's the distinction that's being missed here. That's the profit rule. But if I'm not going to put this in the bundle, but if you if you go back over that chapter in Bowstead, that profit rule is one limb of the fiduciary obligation. The other being, one of the others being the no conflict rule. But in fact, that isn't, and I think we picked up on this a little bit with Lord Leggett's judgment in Rukadza. What that masks, as he said, or is that the underlying obligation of a fiduciary is not the profit rule or the conflict rule, is loyalty to the principle. And that is more important than those sub rules. Now, my learned friend said yesterday, well, that you can have it over profits because those profits might come from information that you get as a fiduciary, and because the principal owns that information and has used it to make profits, then because the information belongs to the principal, you get the profit as well. But it's even more obvious that when you've been given property by someone with obligations to look after it on their behalf and deal with it as they say, the same proprietary remedy attaches.
But there has to be a pre-existing trust.
Has to be a pre-existing fiduciary duty. That's the distinction. It doesn't have to be a trust stricto sensu. It can be a fiduciary obligation. So if you find that this agreement doesn't create strictly a trust on the terms, you can say, well, it does imply a trust because of the segregation, the control, the limit on the use of the funds and so on. You can also, even if you don't go that far, say these agreements plainly create fiduciary obligations. They say so. And it's not that they say so willy-nilly just as a badge that doesn't mean anything. It corresponds exactly with what the parties have agreed. FTT were not given these assets as their own. They were given them to look after for us on our account. And that means that the fiduciary obligation, even if it isn't a trust, gives rise to the proprietary remedy. Now, I've got a few, I mean, what I've cited on that point is Lewin, and there are a few authorities, but I'll just take you to that quickly. It's page 1307 of the supplementary bundle. The trust. It's pretty basic, but it does say.
Do for me then, yes.
Yes,
Okay.
For the present purposes, trusts are not confined to trust in the strict sense, but also extend over property which is subject to a fiduciary relationship. And then further down in this chapter, references to trustee include what we call quasi-trustees. And then I think the last part, there is no need for the fiduciary.
But it cannot be enough merely to establish that an agent has a personal duty to account to his principal and other personal fiduciary obligations, because there is no property in which the principal has proprietary interest at all.
Yes, there is always an agent doesn't have that duty, but here, for example, there's no need for the. Oh, sorry. Yes, no property in which the principal has a proprietary interest. So that's Techteryx.
Yes.
And then just the final sentence.
Okay.
Yes, 3 lines up. A fiduciary relationship in this context, meaning no more than the duty to restore property concerned imposed on the person whose conscience is sufficiently affected to justify the intervention of equity. Now that means that it is not required that this is a formal trust, either in the expressly agreed in the contracts or even objectively construed by the agreement and the reality. It clearly is that kind of fiduciary relationship, and that gives rise to the proprietary remedy. And the passage in Bowstead that my learned friend counters with doesn't say anything other then the assets need to be derived from the breach. That doesn't mean it has to be profits. If you've taken property and given it to somebody else, the assets that Mr. Britton and Aria held derive from the breach. If that relationship stands, then those fiduciary obligations give rise to proprietary remedies. And there's Lewin. I've cited a few more cases. The Hong Kong one, Ajib and Jackson. I went through them in opening, but and then finally Rukadza. I think although that case was a profit case, and they were discussing it, Lord Leggett's judgment.
Can we go to the Hong Kong? Can we have a look at the Hong Kong case again? So
it's 3538. And it's paragraph 20. So, in fact, I've just invited you to read that, but it's 20 to 23.
sorry, and this is
Lord Hoffman.
Lord Hoffman, isn't it? Yes.
Yes, the 20. Yes. And 23. Really the end of paragraph 23.
Yes, yes. Yeah, highlighting.
Your trustees. So there are two points with fiduciary.
Transaction which the breach of trust. So they must know. This is knowing receipt.
Well, it's wider than that, though, isn't it? It's all persons who enter into fiduciary relationship are category 1 trustees. So
But all persons enter into fiduciary relationships, such as the category is not confined to those who agree to such relationship and expect be deemed for limitation purposes.
that's a limitation point, obviously.
Yeah. That's the,
and we say that is consistent with Rukadza. In fact, the case was relied on and quoted in Rukadza. And although Rukadza was a profit case, I took you to some passages in Lord Leggett which explained that there was a deeper duty involved in a fiduciary relationship than just the profit rule. And the duty is not to do things that are unauthorized. So.
Yeah.
A very final sub point on that, on page 1915. Oh, sorry, that's the main bundle. See here, there's an email exchange between FDT and the fund, and this has been raised as a I think it was raised as a full and frank point at one point, but that wasn't pursued. But that email of the 29th of March 2024, it's between the fund manager and Nicole Soon from First Digital, and it's the second paragraph that I want you to look at, because although been said about that email is that it raises, it's raising KYC concerns that haven't been answered. It's clear, first of all, that you have identified Techteryx as the beneficiary of the shares. And that's what FTT were telling the fund manager at that point. And they may say the opposite now, they may say they weren't a trustee, but that seems to clearly say.
Well, yes, I mean, that's actually an interesting point. Why would the ultimate beneficial owner of Techteryx be relevant on Dmcc's case if, as they contend, FDT was the legal and beneficial owner?
Yeah. Well, I think put your finger on it, it's not relevant at all. It's a complete smokescreen. But that's what we say. They can't have it both ways. They can't own the money and then criticise us.
Wait, please. So there would be no reason to suspend the redemption. Okay.
Okay, my next topic is the pleadings, and I'm so sorry, but we're going to have to go through the pleadings again because I submit that Mr. Montague-Smith gave an extremely narrow, to say the least, version of how this case has been pleaded.
I know. I don't mean to cut you short. I mean, I can read the pleadings for myself.
You have to read them, the court title, I guess.
I've read them already in the context of the last 3 days many times. So I'm not sure that I'm going to benefit from another voyage through them. Frankly, I understand both parties' cases.
Very good. Then I'm going to come to porting.
Porting?
Yes. I think you've remarked before that you didn't understand what was being said about the porting exercise, and it remains completely confusing and contradictory. For example, you asked my learned friend not to tell you what FTI say about the porting and what they say that Mazars may have should have seen. You asked them to take you through what actually happened, and he didn't do that at all, because, as I told you at the beginning of the case, we've got various different explanations in various different places at various different times, and it is a completely confusing mess. What seems to be happening is that the money was misappropriated. Mr. Britton got caught, and he spent the last couple of years trying to recreate a paper trail that somehow makes sense of where these monies have gone, how they fit in the accounts, how do they relate to assets. And the irony of my learned friend accusing me of backfilling a case, it should not be lost in that context. Just one example of what he told you today. He looked at the net asset value statements, and I think he looked at page 2024.
Mm-hmm.
And that's one example Oh, maybe I've got that wrong. 8024. I'm sorry.
Okay.
Oh, wait. Please wait. Give me a minute. I'm sorry.
No, that's okay. It's getting late. It's
8592.
sorry, what page?
I'm sorry. Well, right. There's a run of NAV statements, the new ones, and they start at 8592. I'm trying to find the one.
I think he started at 8616.
All right, 8616. Yes, I think 8616.
8616.
And he was telling you something about the coal interests, the coal assets. I think it was investment in loan notes.
Yes, I can see that. Yes,
Yeah.
that, I highlighted that.
He was explaining how that asset came into the NAV statement in 2024 by virtue of the porting exercise, I believe. But we've seen, I mean, first of all, the porting exercise was supposed to have happened in late 2022, early 2023. But also the coal assets.
Well, sorry, let's take a sec. This isn't, we're not looking at the coal assets. We're looking at investment loan notes, aren't we?
Yes, yes.
Okay. Well, I don't know whether they're associated with coal or not.
Well, we've no idea, but I think that's what was being said. The coal assets were being brought in.
So it's said that in April, when do these first appear? Can we tell from the investment in loan notes, March, October 23, investment in loan note. Oh, they changed. They changed. April 23. Loan facility. Sorry, I shouldn't be going off a frolic of my own, to use the expression.
It's a simple point, and I'm afraid I'm not going to be able to track it through, but I understood him to say, oh yes, they come in here 8620, I believe.
8620, okay.
Yes, that's the 31st of October 2024. And that comes in, and I think my own friend was saying that came in then as a
No, this is the coal.
Yes, that's the one. And I'm sorry.
I like it. Okay, let me start my note over again. So
8620.
Okay, so the coal comes in.
And I understood my own friend to be saying that came in at that point as a consequence of the porting exercise.
No, I think this is as a consequence of the purchase of those assets. With what I understood was these assets came in, the loans to Dmcc reduced. So
yes.
what was being said was we carried on the books of the fund the fact that Dmcc owed us money.
Yes.
But when that money then was converted into assets, then we reduced the amount of the loan.
Yes, I think that's right. But the problem is that coal asset was never held by Dmcc. We've gone through those share certificates. That was a fund asset. So it's
so it shouldn't reduce the loan.
No, it doesn't have any relevance to the loan at all. So that's just one point that I thought was wrong. But generally, apart from the fact that we still don't know when it happened or how it happened or when the suite of documents was created, been very careful. At some point in late 2023, that's all we know. But what is the point of this? I mean, it's if everybody agreed that this was a DMCC investment at the beginning, there wouldn't have been any need to port things after at all. So it just doesn't make any sense in general. And there's no supporting evidence apart from backdated documents. And I think the backdated documents seem to have found their way through into the statements and so on and so forth, but they don't represent the reality. We've never had that full statement of from the administrator of who owned which kinds of shares and when what happened to the Class B shares, what happened to the Class D shares, and so on. It really is a flimsy explanation, but it doesn't.
Well, the administrator is not the administrator of DMCC.
No, the administrator is the third party company management.
Yes.
So he requested back, I think, in February or March, a full suite of documents showing all of the share registers and how it changed over time. We've not got that. That would have clarified when the porting happened, if it did, whether it was lawfully done, whether it was done by resolution, and so on. But it just doesn't make any sense. All we have is some backdated subscription forms. There are many of the versions of that floating around. A small point on the hedging, 8967. These are large payments of tens of millions of dollars, and what you were shown to show that this is a sort of bona fide transaction that had some value was some bank statements that had hedging written on them. But anybody can type that into their bank when they make a transaction. It's when I transfer money to my mum, I type David payment on it, and there it is. It's meaningless. I've done securitization, but I'll move past that. I'll turn to the new accounts. We've been told these are the same. Give me 1 minute, sorry. Just a few points on this. I mean, we've obviously just seen it in the middle of the night the other day. We're not able to analyse these finely at all, obviously. I can only make a couple of high-level points on it, but I'd like to do that. We are at page, starts around about page 9 of the second supplementary bundle. Sorry, it starts at page 7, but if you look at page 9.
Sorry, it's page 7 of the third supplement.
The third one, I'm sorry. Yes, maybe the last. So just on page 9.
Sorry, you said page 7.
I started at page 7, I'm so sorry. I wanted to first look at page 9. It's the share classes, just at the bottom of that page.
Yes, I saw that.
That seems inconsistent with what the fund administrator said when you had looked at that letter, which is at 4749.
Well, I'm not sure that actually says that list of, I forget what ISIN stands for. It's the International registration number. I mean, they may have shares registered under those numbers. Doesn't mean they've been issued, does it?
It seems like a list of Class A, Class B, and those actually, we've seen subscription documents in Mr. Britton's, I believe, first affidavit. He didn't exhibit the real ones. He exhibited some examples of them. And Your Excellency noticed that they had all different kinds of class and currency and so on. And so that looks like what's going on there is lots of different classes of investment. But the fund administrator is saying, well, there's only one class and it's only FT2, Legacy and FT2 who have it. So that's odd. And
I don't know enough to take that on board. I mean, whether the auditors are saying that those are the classes of share that they're entitled to issue and that they have registered with whatever the registry is for ISI. I have no idea. Really, it's not a great point, I think.
Well, leave it there. It would be a general point. This is page 12. Going down, restriction on use and distribution. This is again, this is not the Cayman auditor who is the one who finally signs off on accounts to be sent to the Cayman regulator. This is again Mazars Dubai who prepare these, and then what happens is from the last ones they got sort of topped and tailed and then put in Cayman. But there is a disclaimer there, and it's clear that this is not for the eyes of the Cayman authorities. I know there are various versions of language like that, but Mazars Dubai are not, as far as I know, they can't file the final versions in Cayman, and these are, solely for internal management use only. The next point.
So I'm so sorry to interrupt. We've not been provided with the third bundle. I've obviously got the accounts, but if you could just give me the internal pagination, then I'll be able to follow what you're saying. Thank you.
Page 4.
Sorry. Yes. I think those instructing you will have had it, Mr. Montague-Smith, but I'm sorry if it hasn't got to.
It's on the court
Right.
website. I downloaded it from the court website.
For whatever reason, my access is not working. It's not a complaint. It's just a request to the internal information.
Didn't mean you were complaining. I'm just trying to say we've not deliberately not given you those.
Don't worry about that. Time is.
Okay, so page
long. Yes.
26. I'll give you the internal reference. I believe it's page 26 of the bundle, and maybe page 18. We're looking at notes 8 and notes 13. Now, I think what we get from this, what we get from this is note 8 first. What seems to be reflected here is that the porting exercise has completed in June 2022. This is for year end June 2022, and that large increase in assets and receivables and due from related parties seems to be, I think what's going to be said is that this reflects the porting exercise. Yes, it's during the year, and the second sentence of note 8, Aria Commodities Dmcc transferred subscriptions and assets to the value of 505 million into the fund, and investors received participating redeemable shares in exchange. And that's just not what Mr. Britton says. I mean, that he says it happened at the end of the year, FDT noticed, and then it happened after that. Now, I think what might be said is, well, it was all backdated. But that's just not the reality. That didn't happen during that year, even on Mr. Britton's case. So
he said that the issue was raised in December of 2022, and that the porting took place in January 2023.
Yes, yes. So there's a strong possibility that, just like the Hong Kong courts, this auditor has been shown backdated subscription forms, but this doesn't reflect reality. This is not.
I still don't understand how it works. I mean, there has to be a double entry, doesn't there?
Well,
so if Aria DMCC transferred $500 million, then that must come out of Aria's account. I mean, nobody's shown me Aria's account.
No, we don't think it's there at all. In there, I think we don't see it in the DMCC accounts, and we've not seen it till today in these accounts. But this is not consistent with what Mr. Britton said about the porting at all.
I think we do have Aria's accounts for the right period,
but I don't think we see the porting in there.
I can have a look.
Let me look, because I have a reference to it, but I can't find it. Yes, sorry, it's 8705.
8705.
This
so okay. So if the transfer took place in the year that ended in June, then there should be a corresponding entry.
Yes,
these are
right, and we don't see that, in fact. And this is obviously September 21 to September 22. But even if it happened after that, if you look at page 8706.
8706.
These DMCC accounts were signed, I believe, in 2023.
Yes.
November 2023. And there's no mention of any. Yes, if you see events since the end of the period, there's no significant event occurred since the end of the period. So what he's saying in the DMCC accounts is that nothing happened that is of interest, and then the fund accounts seem to say that reporting happened, but not at the time that Mr. Britton says that it happened. So they're completely inconsistent. So the idea that you can trust the Mazars accounts, but not these ones, it doesn't make sense. Two more points. The page 11 of the bundle, page 3 of the accounts. Looking at these accounts, there are only two tangible assets, really. There's the.
So page 11, back to the third.
Yeah, Yes, straight back to the new accounts.
Okay. Yes.
If you look at the bottom, this is the convertible loan note. And this is one of the biggest assets that is actually, apart from loans internally between the companies. You see that the auditor, even Mazars, have said here, on the bottom of the first column, the significant estimation uncertainty associated with the valuation. So they're remarking that.
What convertible loan note is this?
If you're looking at the assets, page 7. Sorry,
It's disclosed in note 7. 7. Convertible loan note issued in relation to Mabula.
Yeah, again, but it's that's never that's
embedded equity conversion option. That's what's the relationship between that and the valuation?
Which valuation? You know, since the
Valuation.
It's a different valuation by.
Well, it's an entirely different structure.
It's not been mentioned before in the asset list. Again, material uncertainty surrounding that valuation. Very much what we said about the other valuations that they relied on. And then, oh, sorry, yes, this, if you look at that asset is dated 2022. The other one was 2024. It doesn't appear in the asset list as far as we know. But even so, that even the auditors here have spotted uncertainty in that valuation. So that can be taken at face value. And then finally, just one small point at the end.
Mm-hmm.
Page 24, which is page 16 of the
yeah.
Note 6. Sorry, I've got it wrong. It's in the note 5.
Note 5.
Yeah. Interest due from related parties. So that what that means is that $35 million of interest from these related companies for these loans, Aria, Dmcc, Aria Axe, Aria Bio they're not paying interest on the loans. Will be paid up. That's that on those as far as I can get to today. But then Mr. Chalk, I do want to point you to Mr. Chalk's evidence.
Okay.
We raised this before I just want to turn you to what Mr. Britton said about why the monies went to DMCC in the first place. That's at 1816 of the main bundle. Paragraph 22 and paragraph 23. So he's
18.
yeah, 16.
1860. Yes.
So he said that
I know. Yes, this is a 22, 23. I've read all of this. This is
yes.
the FDT. It's taking too slow to pay.
And then he said
Glassdoor say that they're not linked to FDT at all.
First of all, he said it would take too long to pay Glassdoor, and then FDT asked him to pay the money to DMCC.
And he denies that. I've read his affirmation.
I just want to give you the note. It's paragraph 32 of his statement. He says that's not true, and that's a big part of our case, that these monies were diverted. And Mr. Britton says, well, Mr. Chock told him to do it.
Yes, and he denies that.
No, they've got to fight that out at trial, but that's
But that's a head-on conflict.
one of them is not telling the truth, or both of them may not be telling the truth. That's, there we are.
Or in the present world, each of them may be telling their own truth. It's, okay. Anything else?
Yes, I've got a couple of brief points, but I'm really near the end. You'll be happy to hear.
Okay.
The Hong Kong judgment, good arguable case on enforcement. Had to put that in. That was the jurisdictional hook at the time. Even your first judgment said that the question of jurisdiction was decided provisionally. You were satisfied that there was an arguable case that the judgment would be enforceable, and you were prepared to accept jurisdiction on that provisional basis pending the return date. Now, I say the new law is not tethered in a jurisdictional way to that requirement, and I'm not putting it any higher than that. But you have directly jurisdiction to make an order like this under the new law, and it says so in terms. It can't possibly be the case that is the jurisdiction is limited. But I don't think my learned friend is saying it is. But there is a sub.
Well, yes, he is, because what he's saying it is that it serves no purpose to preserve the assets to support a judgment if that judgment is not going to be enforced in this court.
Yes, he does say that, but what he doesn't say is that you wouldn't have jurisdiction to make an order for that reason. He's not said that you don't have jurisdiction to make the order, and he hasn't said that under the old law or the new law. What he's saying is, as a matter of arguability, as a matter of good arguable case, and I say that's ultimately in the discretion of the court, that you may consider what's the point of doing this if at the end of the Hong Kong judgment it won't be enforceable here. And that's a perfectly reasonable question to ask. But I say a number of things about that. It's even under the old law, even under it's always talked about a prospective judgment, a judgment that is prospectively enforceable. It may not even be a freezing order to be granted before proceedings are even issued.
Yes, of course.
So we're looking at even in your first reasons when we were working under the old law, you said might be, maybe enforceable. And I've referred to passages in the skeleton. I'm going to take you to that now. But it's always an open question at the early point of proceedings whether a judgment is going to be issued and whether it's going to be enforceable. And I submit that whether, when we win in Hong Kong, whether that judgment is enforceable or not is a completely open question at this stage of inquiry. I do say that there's authority that they did submit to the jurisdiction, and I do say that those common law authorities haven't been tested. But I also say we're really speculating as to what's going to happen next. I can't know, and neither can you, nor could I have known at the ex parte hearing what is going to happen after their jurisdiction challenge happens in Hong Kong. Are they going to boycott the case? Are they going to have default judgment entered against them? Are they going to apply to set aside that default judgment? Are they going to appeal that judgment? We don't know. We do know that they have been participating so far. So the idea that the judgment cannot be enforceable is premised on the suggestion that they're going to boycott the proceedings and that they will not take any part, even at any point in the proceedings, up until the point when time for appeal is over. And so we just can't know that. And in fact, the facts suggest the opposite. And the cases that I cited, the old cases, say when you're sued in a foreign court, you have a very basic option, which is just to do nothing. Aria Dmcc is worried about its assets in Dubai. They didn't have to do anything in Hong Kong, but they stepped forward, they engaged counsel, they engaged solicitors, and they argued points that go beyond just saying the court has no jurisdiction. And that is a technical question, but the jurisdiction of the Hong Kong courts is always discretionary over foreign parties. They have jurisdiction to do whatever they want, and you cannot tell them, that order was made without jurisdiction. What you can say is that in your discretion, interpreting the service art case law, you have made a mistake because we don't live here, number one. Number two, there isn't a very strong case against us. These are discretionary points, and the common law authorities say you do that and you take your chance, and that's going too far. And it is strict and it's old law. It hasn't been decided yet. But I think the more important point is it is just speculation at this point. And then secondly, if it wasn't directly enforceable, I mean, we would say that a judgment would be. But if it isn't, if there's an argument about that, we will argue that at the enforcement stage, and we will seek to attach those assets. And if the court doesn't agree, we will say there's been a huge fraud here, and we want to do something to protect those assets. So we'll be asking for a renewal at that point, either by issuing new proceedings or on a Chabra basis, because we'll have a judgment against FTT and the fund, etc. And I think what my learned friend's point just boils down to is that we wouldn't be able to directly enforce a judgment like that. But a judgment is never directly enforceable. You always have to make an application, issue proceedings to have it recognised and enforced. Whether you do that by declaration, whether you need to do that, there will be some other process needed in the end. So we say that's just not a good reason to set this aside. It rests on a hypothesis that we just don't and can't know the answer to. But if you are satisfied that there is a seriously arguable case of a fraud of this magnitude.
But if the judgment is not directly enforceable, but it is indirectly enforceable.
Yes, that's the Chabra test, isn't it? I mean, you hold a ring until we can get such proceedings underway as to unravel transactions, trace assets, etc. That's always the way it works. It doesn't matter whether this is a direct enforcement of a money judgment or some other court process that will enable us to get those assets in the end. And so that's one submission. The other submission is the fraud cases. It's not a Hail Mary. It's a crucially important point in a case like this. Your order has been effective. You know, this fraud happened via Hong Kong, but the money ended up here. There are people here, there are companies here, there are banks here who will obey your order and will help us secure this position and trace to find out what we have to do next to get that money back. And that's the purpose of it. It really is a rather strange argument. I think at some point in his skeleton, he said, well, there may not be any assets at all, in which case, what's the point of it? But that's a fraudster's argument. You know, there's no point doing it because I've wasted all the money already and you're not going to get anything out of it. So I don't accept that this has no utility. And then...
Can I, sorry, can I just ask how much longer this is going to go? Because we've been going for 2 hours and 5 minutes now on a 1 hour response.
Well, you went quite a bit over time as well, actually, to be honest.
But after that, you said you'd take an hour. So now I'm asking just for everyone's benefit, how much there is.
Actually, it was before that I said it'd be an hour, and then you overran. But anyway,
well, no, I mean, the point is that while I'm sure you both believe I'm superhuman, I regret to inform you I'm not. And assuming that
I'm done. I mean, I'm
exactly what I was
I
going
have
to
one
say.
more point to make.
I was going to say to you, you're done.
Can I have one more point? I mean, it's a 2-minute one.
It better be. Okay.
The inconsistent acts point. He referred to the inspectorship proceedings in Cayman and what we did to try and get information. That was back in 2023. That was before the fraud case had been established. The point of that to get information and what came out of that was useful information. And then the statutory demand on FTT, that if you look at the affidavit in that, it completely mirrors what we're saying here. It's not inconsistent. Sorry, that's the receivership application. And the statutory demand, we've asked them to give us 200 million of our money back. And that's that. That's not inconsistent with the claim that we're pleading. So I'll leave it there. Sorry, and thank you for your patience.
Okay.
Well, in the knowledge that none of us are superhuman, would you like to take a few minutes? I'm going to go as fast as I can.
I certainly would like to take a few minutes. Thank you very much. It's 5 past the hour for me, and you, just a different hour. So let's come back at 15:15. Let's take 10 minutes. Okay.
Thank you.
Thanks. Okay.
Very good. I shall move without rushing things. I'll just try and be as economical as possible. So I'll take it in the same order as my learned friend, because that's the easiest way for me to respond to his submissions. If you'd like it in a different order, then please tell me. But he started with full and frank, and just dealing with the 3 points. Firstly, in relation to Ms. Lee's statement that there were no audited accounts. There's been an apology. There's been no explanation. It's not disputed. It appears that that's material. It's not disputed that it should have been disclosed. There's no explanation for why it was not disclosed. And as my learned junior said, now suggests that in those circumstances, the proper inference may well be that it is deliberate, and we would say in the context it's difficult to avoid that conclusion. As to authorization, I just make 2 additional points. My learned friend said he told you about the board resolution, but his point was what wasn't authorized was payments to DMCC. And what he didn't tell you about was the ratification, the terms of the ratification in that board resolution, which you see at 567, We've been there before, but it's clause 3.
I thought we read the whole of the board minute.
We
the
did.
ex-parte.
I don't think you, well, I don't know, because what my learned friend was saying to you, and what he's saying now, is that there's nothing in this document which authorised a payment to DMCC. Maybe it
Yes,
authorised
I do
payment.
I do think I saw the ratification.
Well, you will know better, because it's obviously what we had was the bundle.
Yes.
And the
I think we did read through it. I mean,
yeah, sorry. The short point in relation to this was simply that well, there's 2 points. One is 3.3 ratifies all actions, all instructions given by Alex de Lorraine on behalf of the company to FDT in connection with the investment amount. In connection with the investment amount. So it doesn't restrict it to the investment proposal. It doesn't restrict it to payments to any particular destination. So everything in the past has been ratified. Then the second point is the point that you were effectively told that the complaints about, well, to the extent that this board resolution was in place, it was vitiated by misrep. Was effectively the case that was put to you. And what that misses out is the point at 44R of the pleadings, which states that the board resolution was issued in reliance on the experience of Mr. de Lorraine, saying nothing about misrep. That's all I was going to say about those two. Very briefly on rescission, because this became a point that your lordship got in.
sorry, you seem to have frozen. Mr. Holloway, can you hear me? Then I think it must be at Mr. Montague Smith's end.
Yes, I can hear and see everybody clearly, but he's frozen on my screen as well. And now he's gone.
I can hear you, my lord. Oh, no, I can't.
Yes, there we go. Mr. McPherson, are you there?
Yes, I'm here. I'm here, my lord. We're trying to establish. Mr. Montague Smith has said technical problem 2 minutes. So
Okay. Right. Well, I shall await his return.
thank you. Your Honour, Mr. Montague Smith is just joining up on the new link. He's had to be resent the link, so hopefully he'll be back with us shortly.
Thank you. I have a very small Mr. Montague Smith in the corner.
Yes, I think you can probably guess what just happened in my house. So many apologies for that. I hope you can see me sufficiently.
I
if
can.
I had time,
I'm looking up to you now.
Well, I'm hoping. I'm trying to find a way that might be more pleasant for you, but leaves my arms free. That's all. Bear with me 1 second. Sorry, you might have to close your eyes so you don't get queasy. No, that's not going to work. I'm going to have to put you on the. I'm very sorry about this.
No, it's okay. It happens to everybody. That's best use for the blue book. Yes.
I'm doing my best, but it's not. I'm not really achieving much. I'm afraid. Maybe that'll do.
There
Right.
we
I think that's as best as I can do. I'm afraid, and I do apologise for that. So
no, thanks to apologise.
I was dealing with the point of full and frank, dealing with rescission. You asked a couple of questions about the closing date, if you'll recall, and what could rescission mean in that context. Just to show you the SAA, and you'll find it at page 100, will give you the definitions. And so page 100 of the main bundle tells you what closing date means, and that's the date of closing. Yeah, not very helpful, but it is actually relevant, because if one goes forward then to page 109, you see what happens on closing. Article 2, purchase and sale.
If they're rather assumed that was.
Yeah, well, quite. So as and at the closing date is the recital in my learned friend's pleadings in Hong Kong, and presumably also in the arbitration, but we haven't been told. And what it says is, upon the terms and subject to the terms and conditions of this agreement at the closing, Techteryx shall purchase and accept, and then all the property from which its rights are said to derive. So we find it very difficult to understand how it can be said that they're not really claiming a rescission claim. I mean, essentially what my learned friend says is, well, we say that there's a scintilla of time between when we receive when we're entitled to receive the property and when we're obliged to pay for it, and we want to call halt in between the two. But in fact, it doesn't work, because you've got purchase and sale, and you've got price payment as well. But all, I mean, a purchase and sale anyway is at the closing. So rescission as and at the closing does for all of it. But there we are. That was all I was going to say on full and frank. Right, yes. Valuations. Valuations. My learned friend said that he was going to correct all the things that I got wrong, but ultimately he just resorted to reasserting everything that he'd said previously, which is that the par price is the same thing as an issue price. It isn't, and we can see the issue price in the valuation, which is at 8768. And then he took you to the share registry, which again shows you the par price, which is at 8786. 8768.
Okay.
The valuation. And the point there, which he doesn't deal with, is if you actually look at that valuation at 8768 and then look at the DCF at 8774, his case makes no sense whatsoever, because effectively his case is that the result of these shares is you get 5 years of revenue, of 75% discounted revenue, post-tax revenue for the princely sum, in this case, of $225,000. So you get 32 million for just saying, here's my $225,000. It doesn't make any sense. The point is that what you have are salva valuation reports which have not been met with any other valuation.
Sorry, so on his case, $225,000 buys you 30 million.
$32 million.
And on your case, 225 million buys you 32 million.
No, because they're redeemable at 225 million. So 225 buys you the 24 year, the full life, 75% of the revenue.
Redemption price is par. Says in the
redemption price. Redemption price is issue in the board resolution.
So they've got that wrong.
Yeah, well, then, I mean, it's describing the transaction.
So they've got that wrong. So the board minute
is it 5665?
5665.
Yeah.
Class. So the class B.
Yeah.
Redeemable at issue price.
Yeah. So my learned friend's point is the issue price is the par price.
Okay.
But the issue price is not the par price.
Okay, but the valuers have got it wrong when they say that they're redeemable at par.
Well, that's as I said previously.
Well, it's either right or wrong.
Well, they're anticipating a structure in the transaction, so I'm not criticising them because it comes before the actual deal. But my point is this: what matters is the commercial shape of that deal. And on my learned friend's case, if the deal was genuinely that they can buy it back at par, then his position has to be, well, issue and par are the same, therefore you're talking about $225,000, and that buys you 5 years of revenue only, because why would the issuer
the valuer then thinks you're paying 225 million for 32 million, and then it's purchased back at 225,000. Doesn't sound like a good deal either.
No, sorry. The valuer, the other thing that the valuer says is that it's redeemable at the holder's option.
Oh, so they got that wrong too.
Yeah. So well,
okay.
That's the difference. So the structure.
So the value is valued it on an erroneous basis, at least in terms of the deal.
Well, no, I mean the valuation is looking at whether what would be the DCF, the discounted revenue stream, across the life of the mine.
Yeah, but it's just but the deal is what you pay for it.
No, I understand that, but there are two possible options that you're being presented with, because
redemption price.
What we've got is the board resolution.
Yeah.
And that tells us, and the only issue on that board resolution is what is meant by the issue price. Because if I'm right, then what you pay is 225 million, or what you're deemed to have paid. You get 5 years one way or another, which is 32 million, and then the issuer can buy it back from you for 225 million. So you always get you will always get your.
Oh, I understand. Yeah. What you said.
That's one interpretation. The other interpretation is my learned friends, which is that when it says issue price, it's talking about the par price.
Yeah.
And so what he's saying is that cuts across everything. But what I'm saying is the consequence of that deal is you pay 225,000, you get 5 years of revenue, and then they buy it back from you for 225,000. And the point there is that when you look at the valuation report, that makes no sense at all, because you've got valuation evidence of what 5 years post-tax revenue would be after
I understand.
DCF.
Yes.
But those are the two choices between the interpretation of that document.
Yeah.
And so, you know, what you don't have is chapter and verse in the evidence on this, because this is a new point.
Yes.
My own friend said, well, these are cooked up documents. That's what he said. Cooked up. Now, that's a colloquialism,
Yeah.
which is inappropriate. What is he saying? What is he suggesting? Is he suggesting that my clients have forged these documents? Well, he's had the opportunity to go and ask Salva about them. This particular report is perhaps came in the latest round of evidence, but they've known that there are Salva valuation reports out there in previous iterations. Kroll talk about Salva valuation reports. They've had every opportunity to investigate those. They've also had every opportunity to go ahead and get their own valuations.
Yeah.
So they haven't done that. So the only evidence you've got of that is the Salva reports and the revenue streams that are derived from them. And so just trying to wipe it all away by saying these are cooked up is an inappropriate assertion from the bar, and shouldn't be made. Certainly shouldn't be accepted. It's another vague allegation of fraudulent conduct.
Yeah.
My learned friend then proceeded to invite you to read the transcript of the call with Mr. Britton. He didn't direct you to any particular page of that, so it's impossible to know what point it is that he's trying to derive from that. He says it just makes clear that this has been going on. Those were his words. Makes clear, and this has been going on. Again, that is not an appropriate way to advance an allegation of fraud. You need to identify the evidence you rely on so that we can address it. But instead, what he does is say, here's a bucket of evidence. Sift through that for yourself, and you'll figure it out. But that's not a case that's capable of being met. In relation to securitization, he showed you the reasons for the injunction application. I just take you back to 4056. And at paragraph 106, which is Mr. Britton's evidence, where he says, since the first return date order was made, we've been following the following steps have been taken in relation to securitization. Now, the reason that update was being provided was because obviously securitization and the prospect of it had been explained previously. So what he's doing here is being entirely open-handed about the way in which he's gone about it. And then he explains in terms what the steps are going to be, and explains what the next steps are going to be, and explains what the timetable of those steps is going to be. And my learned friend again resorted to paraphrasing in relation to correspondence, just as he does in relation to case law, and just as he does in relation to evidence. And the paraphrasing is always tendentious and disputed. So he said, they wrote to us and said, well, what are the steps? And we refused to answer them. And it's not as straightforward as that at all. The response letter is at 5581, and the response letter explains in terms why we say we don't understand the position as to how the order that was originally made could be prohibiting the fund from undertaking this process, and goes through it in a fair bit of detail. And I have to say, I endorse everything that's said in that letter, but there we are. And it makes it in a fair way. So, for example, it says the judge did not expressly address whether the securitization process could be carried on in the ordinary course of business, because it was not in dispute at the hearing as a result of Techteryx's own submissions that the securitization process could progress under the order. That's the other aspect of this. My learned friend at that first return date had said, well, we don't understand what's the problem with securitization, they can go ahead and securitize as we understood the submission. So that was all set out in that, and then said, we note that you're asking for lots more detail, but you haven't answered our letter on security for costs. Essentially, stop making us spend a lot of money in circumstances where you're not actually going to stand behind a cost order that comes out in the run. And then what happens is they run off to court ex parte. Now, one might say, all right, Mr. Britton had told you that he was going to undertake the securitization process over the next 14 days or so. So there was a bit of urgency. Urgency is distinct from privacy, and the idea that they could not and should not have told us, given us 3 clear days notice, or even told us that this was happening as and when it was happening, is just indefensible in my submission. And my learned friend says, oh, well, they don't apply to set aside that order now. That was a variation to the order that you made, and obviously I'm applying to set aside the whole of the order. My learned friend's applying to continue the order. So if there's some sort of technical point being made there, it falls flat. We do object strongly to the way that application was advanced, and that it was advanced, you know, the attempt to double down on that and say that it's a risk of dissipation point, we would suggest is also inappropriate in circumstances where it's been an open hand, genuine dispute about what the fund was or wasn't entitled to do. I've had a notification that my computer might now be working again, but I mean, it probably would require a little bit of a pause to get it to do that. So I will move on. Now, I wanted to deal with the submissions on the proprietary interest, unless you're this particular setup is making you queasy.
No, it's absolutely fine.
So,
I was just thinking, what a high definition of them.
I'm struggling to see you as well as I was, so I'm not picking up the nuances. So the usual as Sir Jeremy Cook would call it, the twinkle in the eye, which tells counsel they need to just move on, it is not readily discernible. So you mean,
well, the twinkle's fading at this time of night anyway.
I'm sure that's true. Well, you may be inclined, but you may need to be a bit more blunt than usual, I suspect, if that is the position. But anyway, page 529, we're in the escrow services agreement, and I just want to make a couple of quick points on this, if I may. So my learned friend said, oh, well, we've always accepted that there's a tension between clause 6 and, quotes, the rest of the agreement, but there is nothing in the rest of the agreement that gives rise to a trust. If one places it against the background of the law, and one therefore is looking for an express trust, which one wouldn't likely imply, then there is nowhere else in this agreement. My learned friend keeps saying things like, the document says trust at the top. And again, that's an inadequate paraphrasing of the position. What it does, I think what he's talking about, is that in the first recital, it talks about the client agreement and the custody agreement, referring to being agreements to provide trustee, fiduciary, and custody and other related services, which we talked about, and is just a red herring. It doesn't add anything. So the question then becomes, as to paragraph 1 on page 529, this is about the priority of the agreements. The question is whether or not the escrow amount is a matter, or the escrow account is a matter specifically dealt with in the ESA, because it is matters specifically dealt with in the ESA that the ESA, in respect of which the ESA prevails. So the key question there in terms of priority is simply, is the escrow amount, is the escrow account a matter specifically dealt with in the ESA? Answer, obviously yes. As to the other bit of prioritizing, if I can put it like that, on page 535, clause 14, my learned friend said this about article 14, clause 14. And another bit of liberal paraphrasing. He says it only deals with the account. Those were his words. I've just recited them. This is an entire agreement clause. and it says save and except for the client agreement, this escrow services agreement contains the entire agreement between the client and FTT regarding the escrow account. So when he said it only deals with the account, my understanding was that his submission was it doesn't apply to the terms on which the escrow amount is held. But of course, anything in the escrow account is regarding the escrow account. So that was a submission that should be rejected. He then said, well, what about segregation? He says that's terribly important, and presented it as if segregation was the test. In other words, the way it was presented was, if it's segregated, it's a trust. If it's not segregated, it's not a trust. That is not the law. The law, as I showed your lordship, is that a fund which is not segregated is very unlikely to be a trust. So in other words, segregation is necessary, but not sufficient to establish a trust. Your lordship then took him to clause 2, which is on page 530. And I think his submission was, well, it says FDD shall establish an account for the funds received from the purchasers, and that's all completely consistent with the custody services agreement. I think what he's suggesting is that essentially what the funds are property within the meaning of the custody services agreement, such that it's all caught by the custody services agreement. Well, if that was the case, you would not need this agreement. You would just provide the funds pursuant to the custody services agreement. It doesn't, in fact, say that. It doesn't say trust, and there's nothing in that clause, at least, that could be construed as creating a trust. And similarly, when I won't repeat my submissions in relation to that, but ultimately it comes down to clause 6. I've made my submissions in relation to that. If you've got any further queries about that, I'm very happy to deal with them. But beyond that, I wasn't going to revisit them. But what I was going to do was say, my learned friend again paraphrases my submissions this time in a way that's completely inaccurate by saying, well, my case is that the money belongs to FTT, and quotes, they can do whatever they like with it. That is not my case. Of course, we don't say that. We say the money belongs to FTT beneficially. Why do we say that? Because that's what the contract says. It says it doesn't belong to anyone else.
Well, that's where I pause.
Right.
It's the words shall hold the escrow amount exclusively for the benefit of the holder.
Yes. So what do we know? We know that the holders don't have a beneficial interest.
It's between them, that's the problem.
I see.
There appears to be a dissonance between this and the relationship between Techteryx and the holders.
Right. Well, this.
But as far as this is concerned, so I'm sorry to cut across, but as far as this is concerned, it reads as if FDT believed that the beneficial ownership of the escrow amount was with the holders and not with Techteryx.
Yeah, I mean, well, that's one reading of it. If one took those words in isolation and just said, the client shall hold the escrow amount exclusively for the benefit of holders, and that was the only clause, then one could see that there might be a problem. But first, we know that the holders do not have a beneficial interest. So A, there can't be a prior beneficial interest which could be held in that way. But B, we also know this can't be a declaration of trust in favor of the beneficial of the holders by Techteryx, because we know in terms, for the avoidance of doubt, that Techteryx has no proprietary rights. So what we say is that when one
Well,
looks
even
at that,
more so, they disclaim any trust.
yeah, well, quite, and I think your lordship quite understandably was attracted by the potential for a sub-trust argument, but that disappears. And so the short question becomes, the only case that is viable becomes, what is this a declaration? Is this an agreement pursuant to which FDT holds the escrow amount on trust for Techteryx? And in that context, the words, for the avoidance of doubt, the client shall have no proprietary rights in the escrow amount, can only be interpreted in one way, in my submission. And any doubts that flow from the second half of that sentence, and shall hold the escrow amount exclusively for the benefit of the holders, cannot lead to that particular bit of this, the sentence being overturned, because one has to try to, if one's going to find some meaning in it, one's going to have to distort the language of hold the escrow amount, because we know that it doesn't hold the escrow amount. A, because FDT is in the very prior sentence said to hold it, and B, because we know that there's nothing that in this trust context, Techteryx is holding for the holders. So we accept, of course, that FDT would be bound by contract as to what it can do, and it has agency style duties and fiduciary duties, elevated duties in relation to those obligations. However, we do not accept that there is an arguable case that this creates a trust. And where there is, I mean, the authorities are clear, where that is the conclusion, the language has to be very clear, because everybody needs to know where they stand. And it becomes important when you get to into insolvency situations and so forth. And that is why the default position is there's no trust in a commercial contract.
Yes, I mean, when you look at the pleaded case, it's not actually pleaded that there is an express trust.
They don't use the word express, but what they do is they say, they do plead out the terms, I believe.
But they say, but the actual claim for relief is as constructive trust.
The claim for relief, yes, because the money has left, and so FDT doesn't have it anymore. So that would be pursuant to an express trust. We would say you're bound under the terms of the trust to hand it back to me. But there's, of course, the claim is under a constructive trust, which is predicated on the prior existence of an express trust. In other words, if I'm a trustee for you,
Yes,
and I give, yeah, sorry, okay. But that's all predicated and determined on an express trust under the terms of the ESA. My own friend's other more creative arguments are you can generate a constructive trust without that prior trust situation, without a proprietary interest. And I'm afraid my learned friend's submissions on that are just incoherent. I'm afraid. I'm sorry to have to say it, but it is simply not arguable, and shouldn't be argued, frankly, that you can generate a trust over property which is owned by a fiduciary as a result of the fiduciary's breach of duty. It is just not. And the way he attacks it is he picks out half a sentence here, half a sentence there, and takes it completely out of context. He took, before I get to the law, he took you then to some of the documentation. And I recall I took you myself to an account statement in relation to this, and he said, well, it does say custody, but the word custody appears on the document, but the type of account is not a custody account. It's a bespoke escrow account. But regardless, that is all just colour in the background, because as on this, in terms of the interpretation of contracts, we've put some authority in, which shows that Hong Kong law follows English law, and therefore you are dealing with just the terms of the written contract.
Okay, and what about Hong Kong? Can I assume that Hong Kong law in relation to the creation of trusts also follows English?
The common law, we would accept that, yes. But what my learned friend does, and this is one of the things that happened, I believe, on the Monday before the hearing, was he inserted section 89 of the Hong Kong Trust Ordinance. Now that's a piece of statute, and I'm not sure is the answer what the principles of statutory construction are. I assume that they are the same as we would apply in the DIFC, but also the same as the English law, but I don't know that for certain. And nor do I know whether the particular provision that my learned friend refers to has been the subject of interpretation in the Hong Kong case law. We just don't know that. What he does is he provides it to you, and it is at page 3631 of the supplementary bundle.
Yes.
And he just says, look at that. It has this very curious effect. So this start from the position, my lord, that Techteryx and FDT have tried to agree to a contract on the terms that I'm suggesting, which is that they agree that Techteryx will pay money to FDT. FDT will own that money, but will have a corresponding contractual obligation, a set of contractual obligations to Techteryx as a result. The effect of my learned friend's argument is that's unlawful and can't happen. In fact, it goes further than that, because if one looks at that statute, he says, firstly, the heading, trust funds to be kept separate, just you ignore that for the purposes of construction. It's not just dealing with trust funds, it's dealing with any funds. And then he says, all monies, property and securities received or held by any trust company in a fiduciary capacity shall always be kept distinct from those of the company and in separate accounts, and so marked in the books of the company. So it applies to all property that's received in any kind of fiduciary capacity. So an agent who receives money for any purpose in a fiduciary capacity, which doesn't necessarily on the common law mean that they would that would belong to the principal, because it's quite possible for a fiduciary acting in his fiduciary capacity to receive money in that capacity, which is the fiduciary's own money. There's no particular problem with that. An agent can receive money and own it, but owe duties in relation to it. There's nothing particularly surprising about that. But the effect of what he's saying is that actually that's suddenly on receipt converted into a trust effectively. So the ownership switches as a result of an operation of law. And that's a very curious assertion. And we would suggest that the obvious interpretation of this piece of legislation is that it applies, as it says it applies, to trust funds. And that must be implicit in it, because it says they have to be kept separate and marked on the books of the company for each particular trust, as always to be distinguished from any other in the registers, so that at no time shall trust monies form part of or be mixed with the general assets of the company. So that's the consequence. That's the aim of the thing, is to ensure that trust monies are not mixed with the general assets of the company. And it says, in all investments made by the company as trustee shall be so designated, so that the trusts to which such investments belong can be readily identified at any time. So it would be astonishing if the effect of this was to say, whenever a quotes trust company agrees to act in a fiduciary company capacity in relation to any property, then suddenly the title to that, the beneficial interest in that property suddenly passes to the person to whom the fiduciary duty is owed. And it's even more curious if you consider the consequences in our case, where the money is actually coming in from holders. So the effect is, despite what's been agreed. So this only matters if I'm right on my interpretation of clause 6.
Yeah.
But the agreement is that money shall be handed to FDT by holders, and that FDT shall have fiduciary obligations towards Techteryx in relation to that money. And the agreement is that, for the avoidance of doubt, Techteryx shall have no proprietary rights in that money. But yet, by operation of law, in the face of all of that, all of a sudden, Article 89 means that suddenly it's held on trust, and then it has to be held in separate accounts and marked, and a trust is created out of nowhere. So we say it's pretty clear, it's very clear, that this is about trust funds. In other words, funds that are passed to a fiduciary on trust. Just dealing then with the sort of common law of the common law in this area. My learned friend said, well, I think he accepts that Ricadzi is about the profit rule, but he says, well, it's just one limb of the fiduciary obligations owed by a fiduciary, and the underlying obligation is loyalty to the principal, and that is more important than the sub rules. And he comes back to this, and he says, I think when he came on to Ricadzi, he said the profit rule is one element of a deeper duty, as he puts it, and the deeper duty was, and I'm quoting, not to do things that are unauthorized. I took you through Ricadzi and we can give you the references again if necessary, and I don't want to go back through it, but what you will see, particularly in that paragraph 95 I took you to, which was Lord Leggett's speech, was that it's perfectly obvious that what is going on there is that there's property which is being abused by someone who is a fiduciary but not the custodian. And that's the context in which things like Lewin make the comments that they do. And just dealing with Lewin very briefly, 1307, you'll be pleased to know I'm making progress. So my learned friend now picks up half a sentence at the end of a particular passage, but it's 1307, and you'll recall this passage 44:11. And which my learned friend quoted the first sentence and I quoted the second, because the second said, it cannot be enough merely to establish that an agent has a personal duty to account to his principal and other personal fiduciary obligations, because there is no property in which the principal has any proprietary interest at all. So it's a necessary, and all the way through all of the authorities that I took you through, it makes clear in terms, when you're dealing with a tracing claim, it's essential, it's of course essential that the claiming party establish their proprietary interest before the tracing begins. And then what he does is he takes it to the final half of a sentence at the back end of that paragraph, and he says, a fiduciary relationship in this context, meaning no more than the duty to restore the property concerned imposed on the person whose conscience is sufficiently affected to justify the intervention of equity. I think what's being suggested is that's what fiduciaries are. That's not the definition, a general definition of fiduciary. He's talking about fiduciary relationship in this context, and if you read back the rest of that paragraph, which you really shouldn't have to do because my other friend is just showing you half of a sentence, the point is that it's explaining how a party can have a trust obligations and fiduciary obligations in circumstances where they're not trustees of the property themselves, because they're not custodians of the property. It's not in any way just sort of reaching back and deleting the second half of that, the second sentence of the paragraph. the context there, which is the relevant bit, is that where the principal has a proprietary interest in property and the fiduciary has caused it to be harmed in some way, despite and you know, this is the quasi trustee context that's set up earlier. That's the non-custodial fiduciary. And he does the same thing again in the relation to the Hong Kong judgment, which is at 3549. And so he takes you to the half a paragraph of 23 and just takes it completely out of context and says, well, where Lord Hoffman says all persons who enter into fiduciary relationships, such as the defendant in this case, are category 1 trustees, the category is not confined to those who agree to such a relationship in respect of the property in question. All such fiduciaries must be deemed for limitation purposes to have acted in accordance with their duties in the same way as consensual trustees. He's not saying the common law's got it wrong, all fiduciaries are trustees. He's obviously not saying that. That would be a seismic event in the common law. And in my submission, beyond argument, he is trying to identify within the context of the limitation provisions of the law how you categorize fiduciaries in these circumstances. So the idea that is sort of redefining what a fiduciary is not right. I won't go back through Riccardo. We've had our submissions on that. Moving on, KYC and Mr. Justice Sun, your Lordship asked the question, why were redemptions suspended as a result of concerns about Mr. Sun? The answer is partly in the email, and you've shown the email at page 1915. And the question that is asked by IFIT there, this 1915. Thank you for your email. Funds Council's finalising AML KYC matters. However, we would like to request some support in respect to the following queries. And then it says, you have identified Techteryx as the beneficiary of the shares. You have identified. So they're not saying, we agree with you. They're saying, we need to understand this position. They go on to say, ask questions about whether or not Miss Legion May holds them on trust as a nominee, as a call option, and so forth. And then this is also addressed in a letter from Campbell's, which you'll find at 4256, which sets it out in a bit more detail. And that says 4256, KYC AML issues. At the outset, we reiterate that your client is well aware of the fund's concerns with the KYC AML information. Those concerns remain unresolved. And then second paragraph, our client remains of the view that the KYC AML information relating to the subscriptions made by FTT in the fund is wholly inadequate. As FTT is aware, FTT's subscriptions were made pursuant to subscription forms that represented that FTT was subscribing for shares in the fund as beneficial owner, the implication being that FTT was in turn the beneficial owner of the sums invested, and goes on to ask a series of questions, because this is not about beneficial ownership of the fund. This is about whether or not FTT held shares in the fund. Sorry, when I say the fund, I mean the reserves. I shouldn't mix those. This is about whether or not FTT was holding shares in the fund on trust for somebody else. And what was happening was that someone was coming forward, Techteryx was coming forward and saying, well, hang on, actually, those may look like FTT shares, but they're held for us. We're the beneficiary of them. And that then raised KYC issues, because, of course, what would happen then with any kind of distributions or redemptions is that cash would be handed from the fund to FTT in the knowledge that it wasn't going to stay there, but in fact was going to go on somewhere else. and it is and in the concern that the ultimate source of the cash might be something different. With me. All right. I think your lordship wasn't interested in going back over the pleadings. I can fully understand and respect that, so I won't go back over that. In relation to porting, I think the misunderstanding that took place here was that if I can just do this very briefly, if one goes to the NAV, yeah, if one goes to the NAV at 8616, and the point here is that at this stage, this is the 30th of April 2024, at this stage, the Mbuyu investment is reflected in the loan notes. So that is what they were at that stage, and then they subsequently become a shareholding in the company that owns the mines. And that's what I was explaining to your lordship, that essentially what you see is this line ultimately being eliminated from the NAV, and then the introduction subsequently of the Mbuyu mine. And that is why so you see that at 8593. Where you see, sorry, 8592, is that right? Where you see the April 2021 and the loan notes have gone, but the sorry, I think I've got this wrong. This is
yes, because we've gone back in time.
Sorry, that's my error. I think we go forward. So it's 8. So we were at 8616.
Yes.
So 8616 is the 97 million in the loan notes, and then there's a substantial receivable from various related parties, including from DMCC. And so my understanding is that the Mbuyu mine is reflected in the loan notes, and the Pinewood and the Carbon Resilience are reflected in the loans to DMCC. That's where the assets sit at that stage, and then you see those assets.
Just forgive me. Let me just take that down. So what sits with the MCC? Say that again.
The investments in respect of the mine, in respect of the mine, the other mine, which becomes the Pinewood.
Respect of Pinewood, yes.
And it's not actually in respect of Pinewood itself, as I understand it, but that's how it works. And then Carbon Resilience as well.
Okay, so the investments in respect of the other mine, which is a similar name.
Yeah, Mbeya, I think it is.
Mbeya, and Carbon Resilience. So what? They're owned by the MCC, or what?
I am not 100% sure of how that is reflected at this stage, but someone will no doubt tell me. But if we have it quickly to hand, but essentially there is the development of the mine, and the assets of the mine are going on under the heading of DMCC, and that is then what is brought into the fund through the mechanism of Pinewood and through.
So when I see it in the NAV, where do they sit in the NAV then?
So in the NAV, if you're
They
looking
sit in loan facility.
Aria Commodities DMCC.
Yes, so they're in the NAV as a loan facility, but we don't know precisely the mechanism.
I don't have that information for you, I'm afraid. But if you what you can see, you can trace that through into the next NAV, which is the point that I was making. So 8618 is the next NAV.
8618.
And that's the 125 million for carbon resilience, but then you'll see the loan facility is reduced.
So carbon facility is moved.
Yeah. The point that we were trying to meet in relation to this was that these NAVs were somehow inconsistent.
Sorry, let me just take note. So it moves from the loans facility to DMCC to being a financial asset.
Well,
and how does that work?
Well, if you recall, that was the deed of transfer that I took your lordship to. So this is the one that's contingent on government approval.
Yes,
and the
but I mean, where does DMCC sit in all of that?
So DMCC was the company that had the arrangements with the owners with carbon resilience in the first place. And those are the ones that were then collapsed into the deed of transfer, the effect of which is to bring it into.
Can we have a look at the deed of transfer then?
Yes, certainly. Do bear with me though, because.
Yeah, of course.
Okay, so the deed of transfer is at 4701.
Yeah, I'm just looking for the DMCC's part of it. 4701. Okay. So, oh yes. So where is DMCC? That we have this collapsing into. Yes, I have it. So it's a recitals. Lenders and the borrower entered into the following agreements: 8 million from the fund, 10 million from DMCC. So 18 million becomes 125.
The loan, yes. I mean, the loans are traded for that, it appears.
Okay, it's a good deal.
Well, I mean, that's on the face of the document, so I don't know what else there is behind it. But what you have are the valuation reports sitting beneath that, and those have been, as I say, reviewed by FTI. But I wasn't going to go back to that because I was just
No.
dealing with the point that the NAV was inconsistent with my explanation of how these things came into the fund. What then emerged from my learned friend's submissions is, if your lordship goes to page 3 of the audited accounts, I believe it's page 3, is it? There's reference there to a convertible loan note in relation to.
Yes, we saw that. Yeah.
But yeah, quite. And so the clarification, what I was trying to clear up there, was that that was the status of that investment as at the date of the finalization of those accounts. Not the date the accounts were produced, but the time during the accounting period.
This is in. Is this in which mine is this in relation to?
This is in relation to the Mbuyu mine. So this is the one that was recorded as loan notes, if you'll recall.
Yes, that's what I thought. Yes.
Yeah.
So this is relation to the first one, not the second one.
Not the Pinewood one.
Yes.
The 65 million. Yes, correct.
So you want page 11. Bundle 3. Loan notes.
My learned friend took a couple of other pot shots at the audited accounts. In particular, he mentioned the disclaimer in the accounts. I thought we'd been over that previously. This was Ms. Lee's attempt to rubbish the audited accounts that she previously told you didn't exist. And so we do, I think, have some debate in correspondence in relation to those earlier accounts. And I believe the reference is at page 2458.
The disclaimers are different from reservation.
Yes, but what my learned friend was saying was that because there's a reservation, these are
a disclaimer.
Sorry, you're absolutely right. It's getting late, and I'll stop making excuses. But because there's a disclaimer, he said, that makes the whole thing unreliable. And you'll see what happened in relation to the first set of accounts at 2458 under paragraph 2, where Mr. Van Vuren, from whom you now have a witness statement, was asking the question. I haven't seen a Cayman audit firm use Bannerman language recently on my fund clients in their audit opinion, but we're fine with it. We're informing you now that we obviously have to share and file the financials with SEMA, and the financials will also be shared with investors. And the answer that comes back from, I think it's from Mazars at that stage, is we are aware that the financials are shared with SEMA and investors. It's used by firms to limit liability from other parties in the unlikely event of a dispute. And then just says, 3 lines up from the bottom, I have not come across an audit report of any Cayman firm who did not have some form or a variation of that wording. So again, this is just, we've been over this previously. The disclaimer is there to protect against liability. It goes into every set of accounts. It's not a reason to think that the accounts are any less valuable than that otherwise have been. On enforcement, good arguable case on enforcement. My learned friend said that the new law is not tethered to in a jurisdictional way. And then he said, well, so what that means, as I understand his submission, he said, what that means is that the question of enforceability and the question of whether or not the foreign court had jurisdiction is just a matter for your discretion. That is wrong. It's part of the good arguable case. That's the passage from Broad Idea. that I was referring your lordship to, and the point, I think, the short point is that as we sit here today, that judgment is not an enforceable judgment in the DIFC, or there are no grounds on which a subsequent judgment could be enforced in the DIFC. And my learned friend says, well, maybe there'll be indirect enforcement, but that is just another way of saying, I'm asking you for a Chabra injunction. Because the point is that when one's looking at good arguable case, one's looking at both stages. Do you have a case on the merits? Do you have a case on enforcement? And if you don't have a case on the merits or a case on enforcement against a good arguable case against the respondent, then you're effectively treating them as a Chabra defendant. But this isn't a Chabra application. My learned friend said, oh, well, it's all been very effective, but one has to ask the question, what has it achieved? And what will it have achieved if nothing can be enforced as a result of it? Bear with me. I think one point that I was asked just to revisit, I make the point that my learned friend, I made the point squarely in my submissions that so proprietary claim is central to the claims in our submission, and it's essential. I took your lordship through the pleadings a little bit to look at the personal claims that had been introduced in conspiracy and misrepresentation. Your lordship said, well, I understand everyone's case on the pleadings. What was not put and what hasn't been put to date is any suggestion that this application can be maintained absent a proprietary interest. And so I just want to make sure that your lordship has that on board. As I understand it, a damages claim cannot support the freezing order. Obviously, it can't support the proprietary order, but a damages claim can support the freezing order. And then finally, my learned friend addressed the inconsistencies, and again, just resorted to paraphrasing. He said the receivership completely mirrors the claim in this jurisdiction. I've taken you through in some detail to the assertions that were made. He said the inspectorship was some time ago in 2023. So the suggestion appears to be that the new things have been learned, which justify the fact that in 2023 the inspectorship application was made on the footing that it was clear to Ms. Lee that FTT had a shareholding in this fund. So my learned friend's factual explanation for why that was done is that new things have been developed. That's the implication of what he's telling you. Unfortunately, that's not what Ms. Lee says. Ms. Lee says, essentially, as I took you to, that she said it because it needed to be said to get over the threshold of the application. So the explanation is just invention. In relation to the statutory demand, my learned friend paraphrased it by saying we are simply asking for $100 million of our money back. But if you actually look at the document, as we did previously at 4743, I think it is. I'm afraid this one has been scanned rather oddly. It's 4743. 43. Sorry. 4740. I apologize. And what it says is the demand is served on the company by Techteryx derivatively and in the name of its trustee and fiduciary First Digital Trust Limited. And so they're not saying this is a claim for our money in the sense that he advances it's the our money case in this court. The our money case in this court is that money never became shares
Well,
in a
they are
trust.
saying FDT. They are saying FDT is a trustee form.
They are, but of what? That's the point. The
Well,
point is
the money that they're claiming, presumably.
no, because in the statutory demand they're saying it's a trustee of shares. In
Well, they
this
want to
court, they're saying
redeem. They
trustee of
want to
money.
redeem the shares, don't they?
Yes, yes, they want to redeem the shares, but that means there are shares in the company that can
Held
be
on
redeemed.
trust for them.
Yes, no, absolutely. But what I'm saying is that it's inconsistent for them to say we have shares held on trust for us, which give us these rights, and we're entitled to rely on those rights. But on the other hand, say you look through all of those arrangements, and we maintain our proprietary interest in the funds, the money that was given in exchange for those shares. Those
Oh,
are
I see what you mean.
two
Okay.
diametrically opposed cases. So that's why it's all obscured by my learned friends saying they've got 100 million of our money. Because in this court, he's saying, in fact, what they're saying, sorry, is that we've got an interest in the shares, and so we're using that interest to call on the shares. Whereas in this court, they're saying we don't have any shares, or it hasn't been established we've got any shares. Can I just check whether there's anything else that anyone wants me to deal with? I will be shouted at electronically if there is. Sorry, someone's typing something. Bear with me if you would. I'm so sorry.
Yes, of course.
Yeah, I mean, I think the only thing I'm asked to urge on you is the point which I think I've already covered, which is that that there is currently no case that this application could be maintained without a proprietary interest in the funds. I know we had that debate yesterday, and I explained to you why that couldn't be the case, why there couldn't be the loss, but also why the claims themselves don't stack up. But I haven't actually heard any argument to the alternative, so I don't think I need to labour that. So, my lord, unless there's anything further from you, I think you can.
So, just following up on that point, as far as you're concerned, you're not here to meet a case that a damages claim for, say, conspiracy or misrepresentation arising out of the PPM justifies a freezing order, maybe not a proprietary freezing order, but a freezing.
That's not suggested. I mean, I've made that point, and it's not been. There's no pushback on that, if I can put it like that.
Yes, okay.
It operates at a couple of different levels. One is you have to look at that conspiracy claim and see what's pleaded against my client, that is the first respondent. Yeah. And you recall the conspiracy wasn't pleaded against them. And the second is you have to look at the so-called true coin story and see who is alleged to have made those misrepresentations.
Yeah, I see that.
But the third point is then in relation to damages. So how can you get to damages? So for example, I mean, if you want just one last word on this, just on damages, if you look at the true coin terms, which my learned friend produced in the bundle at 10490. The point here is what happens if the reserves are depleted by fraud? What is Techteryx left with? You've got a bunch of token holders. They show up and say, "I want my USDs, please." And the answer comes back, well, look at this, theft and loss. Any depository account maintained by an independent third-party financial institution for the benefit of TUSD token holders may not be sufficient to cover all losses due to theft or fraud. Transactions in TSD may be irreversible, and accordingly losses due to fraudulent or accidental transactions may not be recoverable. And you've got all of the points that we made previously about risk and so forth. So in other words, if it is right that there has been removal of these monies and that amounts to somehow to a fraud, but it is not right that those monies belong to Techteryx, then it has no loss for a number of different reasons. One of them is token holders. If that leads to token holders being unable to redeem, well, that's at token holders' risk, number one. But number two, they're just left with their remedies against FDT. It's just a contractual remedy. And unless they're saying, which they're not, that FDT is insolvent and couldn't meet those claims, then what's the difference? It's just FDT needs to meet the token holders' demands out of a different pot of money. Anyway, I make those submissions to you almost de bene esse because that is not the case that I'm being asked to respond to. So, my lord, unless you have any further questions, you've been extraordinarily patient with us, and I know I haven't had my part in that, even though I've blamed it on my learned friend mostly.
Yes, well, that's this is urgent, and that's what is slightly troubling me.
Your Excellency, sorry, I did just want to respond to that last point in 30 seconds, if I can.
Well, having not said anything about this, if my learned friend now wants to turn around and say
what I was going to say is the answers in the pleadings. I was going to go through the pleadings, but Your Excellency said don't do that. We have pleaded damages.
I know what's pleaded, but the difference is whether that pleaded claim is relied upon as a basis for a freezing injunction.
Yes, it is.
Well, I will have to look very carefully at the submissions.
Well, I made that submission that is not relied on in opening. My learned friend didn't respond to it. I mean, I can take you to. Well, you'll have to look at the skeleton argument.
Yes, I will do.
The ex parte skeleton argument. My learned friend, what he does is he deals with the proprietary claim, and then there's just a single paragraph that says real prospects of success for the purposes of freezing order, and it just said see paragraphs X to Y above. It doesn't recite anything that would be associated with an additional part, which would have to be advanced, which was a damages claim.
Yes. No, I will have to look at the written submissions in some detail, clearly, to pass out what is claimed and not claimed. So, where I was getting to is this: that this hearing now was pushed back somewhat from at least when I originally thought it was going to be. I'm not criticizing anybody, but I had booked a holiday before this hearing was pushed back. I am going away in 1 week's time. So the question is how I approach this. Do I make an order and then say you're going to have to wait a while for my reasons and give you very full reasons? Or do I say I will do the best I can until, say, next Tuesday, when I can hand something down? The reasons can be in draft then, but at least you would have them so that you would be able the following day before I go away to make any applications that you needed to do. Otherwise, if the reasons don't come until September, for example, the injunction stays in place until September.
Yes. I mean,
you understand. You understand my thinking. Yeah.
Yes, and apologies for our part in putting you in that.
No. But it's just the way it's fallen.
I think yes.
And so, I mean, you either get a pretty rough, judgment, largely with conclusions with some reasons, or you get the proper job, but you've got to wait for the proper job.
Would there be a middle way, which would
is
be a summary of your reasons that sometimes happens, followed by a judgment? In other words, we would have sufficient, as you say, to take steps, or my learned friend would, if that's what's required.
Yeah.
And then that can be progressed with your lordship. I think there probably is merit in your lordship giving full reasons eventually. Obviously, you know, it depends on your calendar and your diary and all the rest. But we would be, I think, find it quite difficult to have to wait until the autumn.
Well, I think that's true for both parties. So I'm trying to think of the best way that I can serve both parties' interests. Leave it with me and let me see how far I can get. But what I want to aim to do is at least to give you the result on Tuesday, so that if necessary, you can make applications on Wednesday, because I go away on Thursday.
I see. I'm in a hearing Thursday, Friday, but so I doubt the applications will be moved by me. But we'll
yes, I mean, I'm afraid that the circumstances don't enable me to take account of council's availability.
Yeah, no, of course, I fully understand that.
The interest of the party is paramount.
Yeah, no, of course, and if that was how you understood my suggestion, I apologise. I wasn't.
No. You were just thinking out loud.
I was thinking out loud, precisely. Fine, very good. All right. Well, look, the sooner that we can have an answer, the better, I think. And you know, some reasons are better than no reasons. But if we can have some fuller reasons later, so much the better.
But as I say, I'll see how far I can get. I'll see how far I can get. Whether I can produce, whether I can be as fast as my colleague Sir Jeremy, which I doubt.
One doubts that.
Yes, he is the fastest judge in the West. But I will certainly. I think you're right. If I can put together at least a summary of my reasons, that may be helpful too. But I'll see what happens. But I should be working on it between maybe not immediately tonight, but after 12 hours here. But yes, so I'll be on it until Tuesday, flat out, and we'll see how far I get.
Very good. Well, thank you very much.
Thank you both for your very cogent submissions, and you'll hear from me on Tuesday, one way or the other.
Excellent.
Thank you very much. Well, good night to you all.
Good night.